recorder. All right, let me just turn this on. Let me just set the scene here.
Containing the whole of their position regarding the evidence of that posture. These guys, in other words, we've been intention that in evidence. Yes, so she didn't strike it, but she found the allegation. And also that that's time. Yeah. No.
Yeah, just in case. Just in case.
It goes.
I was thinking, no, wait for that. Interesting. I looked at the nature. I was like, wow, that is that's what I can tell you. I was really interested.
This show is
And by the time we get used to it, it's even developed. And I was like,
so you
he was a self-made. I was a builder and a lot of things we still were. He used to get a pen and paper and he'd write down some stuff. And he'd be so wrong. He knows something's on his me and my brothers a lot. Still.
See, I know. I just like,
I don't know what to say. This makes the police somebody must come over now. And they have that my dear friends. And that's exactly what they know like they got. Claims for like you have. So it's always good.
You think Boston? New York has a good ball.
They are. Two top teams are having a bad time.
Yeah, Boston and Golden State.
Playing Cleveland.
Cleveland, we wiped out.
Yeah, we down 3-1. So of this game.
They all three were Boston.
I went to sleep, so I didn't know he got hurt.
They don't know who's gonna have an MRI. See what's going on. They're hoping it see. And then they're gonna Steph Curry tomorrow.
Yeah. That's crazy. It's an interesting playoffs.
Yeah. But, you know, I'm sort of glad to see your teams.
Yeah.
Get in, you know, because we didn't have the tradition Golden State, Boston, Denver.
The Denver
I
doing
want to see
good.
some new champions. Spread the love.
sure, you can't press.
Yeah.
I was looking at tennis the other night too. Go, go, go. She playing some good tennis.
What tournament is going on?
This is one in Italy.
Okay.
I knew Coco's parents, friends of one of the library supporters.
Okay.
He brought me back pictures that they all had taken.
I kept sitting for most of the
Haven't watched much TV since his trial, sir.
Yeah.
On the
I've
bed.
been torturing myself. With the game that I enjoy.
All right, defense may proceed.
So the record is clear, we have tendered into evidence defendants. Exhibit number is it
101.
101.
All right, it's conditionally admitted over all plaintiff's objections noted for the record. You can proceed.
Mark Watt, you received a draft of and then the actual filed verified complaint that the plaintiffs filed against me back in August 31, 2020. Is that right?
Yes, sir.
And you and your office,
Objection, Your Honor. It's 2020, not
I said,
21.
I misspoke.
That's right.
2020. I'm not perfect. So you had this document and I'm sure that you reviewed it carefully, did you not?
I did.
And did Mr. Burby also review it?
I'm sure he did, but I know that I reviewed it.
No, you did. And that would have been sometime shortly after it was received, filed. True?
So I reviewed the draft shortly after the draft was received, and I reviewed this as filed version shortly after it was filed a few days later.
So you were familiar with all of the allegations and claims in that complaint filed August 31, 2020. Is that right?
So it's a 67-page complaint. I read it. There's a lot of stuff in there, but I read the complaint. Sure.
And that knowledge that you had from the complaint, you would have maintained that. Did you maintain that knowledge of the case at all times leading up to when the letter was written to me when y'all withdrew from the case? I wouldn't.
I mean, no, I'm following your question. Sure. Did I remember word for word all 67 pages 6 months later? Probably not. But did I remember that this complaint was filed? Yes, sir.
When you put in the letter that you thought our position was right, you were aware of what they had said and claimed and all the exhibits, the business cards, the internet announcement. You were familiar with, you were aware of all of that, weren't you?
Yes, and I'm aware that a complaint is a complaint. It sets forth allegations that may or may not be true. And the whole purpose of a lawsuit is both sides put forward their own version of the facts and someone decides what's actually true.
And if you had any questions about what they were alleging, you and or Joy would have discussed them with me, right?
If I thought they were relevant and material, yes.
Then if you would take a look at defendants 19.
Is that at tab 19 of this notebook, Mr. Exum?
It's in the small one.
And it's in the big one, but the small one's easy. It's the first page in the small one. Convenience.
Thank you, sir. Okay, I have defendant's exhibit 19 in front of me.
2-page letter that you wrote dated August 31, 2020.
Yes, sir.
Is that a true and correct copy of it?
Yes, sir.
Tender into evidence, Your Honor. Defendant's exhibit 19.
We object, Your Honor, on the same grounds as before, and Your Honor's already ruled this out once.
That's not true. This issue has not been raised. Your Honor has not ruled on it. That is just not the truth.
Okay, this is the first time this exhibit has been tendered.
Your Honor, I misspoke. It's the same allegations as in the previous one that Your Honor ruled under 403 grounds. Does not come in.
Are you going to direct me to which exhibit? I think this is tied into what we just addressed at the bench conference.
You want us to approach or,
That's fine.
if
May I have this stuff? It was part of divided for me. Divided total. So that's doesn't matter. It's also the record. Explaining that somehow the problem. I think I might divide what was told. And I go, yeah. I believe. Great, thank you, Your Honor. All right.
Objections noted for the record, and I'm sustaining the tendering of the objection to the tendering of this exhibit. So you can proceed with your next question.
If you still have that in front of you.
I do, yes, sir.
Thank you. Did you and Joy Burby provide me with a copy of this letter on or about the time that you sent it on August 31, 2020?
Yes, sir.
You wanted me to be aware of what you were saying about the complaint.
You were my client, and I was keeping you informed of the work I was doing on your behalf.
And did you therefore convey to me, by sending me a copy of this letter, your opinion where you stated to Mr. Bill, you opined that no one in the public will care about it because, in your words, it's just a fee dispute between lawyers. However, the complaint your clients file tries to turn it into something completely different, a fraud complaint for wrongful purposes, as that phrase is defined in OCGA 51781. The attempt to affirm the settlement.
objection, Your Honor,
All right, there's an objection here, so let's pause. Your objection is?
simply doing through the back door, which Your
Yeah.
Honor said.
So Mr. Wood, I mean, really, I think the issue here is the letter itself, the statements in it are also are hearsay as well. They're not being conveyed to you. If you want to ask him whether certain parts of those statements were conveyed to you, then we can establish that. But just reading a letter that was sent to somebody else,
It's not hearsay. These are his statements made to Mr. Bill and also conveyed to me.
okay, let's establish that link that they were actually conveyed to you.
I think we did, but I'll do it again.
That, as Your Honor discussed, the bad faith issue stops at the filing. This is after the filing. Mr. Wood, it cannot go to his
Yeah.
state of mind because it was after the filing, and it was
The-
8 months after the issues, or 6 months after the issues in this case.
So what's the cutoff on the evidence about my state of mind?
For the 13-611 claim, it's going to be the filing of the complaint.
They're accusing me of fraud.
All right.
Fraud requires
This,
intent.
and this doesn't have to do with the fraud claim. So
No, it absolutely does. They talk directly about that.
then let's go to those sections that you think relate to your fraud claim, since this
I'm doing
postdates
that.
the
That's
filing
what I
of
was
the complaint.
doing. I've only got one more sentence.
All right.
And Your Honor,
Did-
we just remind the court that it can't be the basis of relying
On a fraud claim, it can be.
fraud claim because it's 6 months after the fraudulent acts that we're contending. So, it really, there is no foundation for it.
The evidence after the fact of signing the agreement, after the fact, is relevant on state of mind. For example,
Okay, Mr. Wood, I understand, I understand your argument. I think that, to the extent this letter postdates the filing of the lawsuit and is legal advice being conveyed to you after the act that's in contention, which is the settlement agreement, the time of the settlement agreement, this is not, unless you can tie this into conduct that you conducted after the settlement agreement, then I don't think it would be proper. Why don't you re-ask the question and we'll see where we are.
continuing where I was, did you convey to me that you had informed Mr. Bill that the attempt to affirm the settlement agreement and sue for its alleged breach while also suing for alleged fraudulent?
Your Honor. Just reading from it, and this is exactly the point. This is
Yeah.
why.
This is what you, this is what you told me to do.
Yeah.
He hasn't asked a question.
I haven't finished.
He's just reading the letter.
Okay,
After the event.
understood. Mr. Wood, if you can just tie it down, the extent of your question to a time before the filing of the lawsuit as relates to the subject matter in
I
this
need to be
letter.
heard on that issue outside the presence of the jury.
We will. Okay.
Now, if you don't mind, because it goes directly to the issue of fraudulent intent. And what I do after the date of they claim I was a fraud is relevant to show that was not. My state of mind afterwards, what I did afterwards. Is it consistent with fraud? Is it inconsistent with fraud? It's the exact law on reckless disregard for truth or falsity.
Okay.
You can go into your state of mind before, during, and after.
And
That's all
I
I'm
agree
doing.
with you there, but right now we're not talking about your actions. We're talking about
We're talking
what someone told you.
We're talking about my state of mind, what I was told. And then somebody will decide, I assume the jury, whether I was reasonable in relying on it. It goes directly to the heart
Okay.
of my state of mind, Judge.
All right, we'll come back to it. If you could, right now I'm asking you to move on to a different topic and we may be able to come back to this.
I don't know how I come back to it if the witness is gone. I'd like to get him.
I'm not going to excuse him until I've given you a definitive answer. So we can move on to it. We'll move on to the next topic and we'll come back to it. Okay?
The letter that you sent on August 31, 2020 was sent literally the same day that you had received the filed complaint on August 31 of 2020. True?
So the complaint was filed on August 31st and this letter is dated August 31st. Yes.
You had read the complaint before you sent this letter exhibit D19, true?
I'm positive I had read the draft complaint. I'm just looking at the letter to remind myself, Mr. Wood, whether they had actually filed the complaint before I sent this letter, but that would make sense, that they had actually filed the complaint before I sent the letter.
All right. That's all I have of this witness. Chris, thank you very much.
You're welcome.
All right, let's begin cross-examination. We can take up the issue on redirect if we need to. Mr. Beal.
Thank you, Your Honor. Chris or Mr. Marquardt, which way do you want to go?
Whatever his honor would tell us to do, but Drew, if you want to call me
Leaving it to the
Chris,
parties. You can proceed.
I'll be Drew, you be Chris.
that's fine.
Okay, good. Thank you very much. Now, we know each other from other claims that we've worked on and litigated, and my former partner, who's now deceased. And one of those claims involves
Who is the former partner now deceased?
I don't think that's relevant at all.
I just did, he said he had worked with him. I had heard his name. I didn't know that.
Ed
think-
Buckley, the
you-
guy
you-
that's
you can
on all
follow
these
up?
I did not
documents
know that Mr. Buckley was dead. That
Yeah.
was my reaction.
a week ago.
Understood.
Very sorry.
Understood. Next question.
And one of the claims I brought was against Alston and Bird for malpractice and breach of fiduciary duty. Is that correct?
That's my understanding, yes.
Yes. And essentially the allegations were that Alston and Bird had sued somebody that was its client. Was that essentially the allegation?
That was what you said.
Yes. And that case is resolved.
That's my understanding.
Did Lynn ever accuse, well, let's say it this way. Lynn accused you and Alston and Bird publicly of malpractice in this case. Isn't that true?
My understanding is there were videos to that effect publicly circulated.
And he threatened to sue Alston and Bird in various public online forums. Is that right?
Well, as I said, I don't practice law by social media. I practice law in courts. So I don't follow all of Mr. Wood's social media musings.
Thanks. Okay. The March 17th settlement agreement. You remember that? Do we need to pull it up just to refresh your recollection, or do you remember the March 17th agreement?
I remember that you and I spent many evenings and days working on that agreement to resolve this dispute, to try and prevent this from ever having to be in a court of law in front of jurors. Yes.
Okay. Now, you didn't put anything in there about Nicholas Sandman or his parents consenting because you didn't think it was necessary to be in the contract. Is that fair?
Well, what's fair is you and I worked on that together, and you didn't put anything in the contract, Mr. Beal, on that point, nor did I.
Chris, can you get a little closer to the mic?
I apologize. Can you hear me?
And now, thank you.
And
Can y'all hear me?
I believe that you've testified, it is your position that all the facts that Lynn shared with you are contained in the factual background section of Alston and Bird's evaluation report letter sent to him, Exhibit 95. Is that true?
I'm sorry, could you ask that again?
It's your position that all the facts he told you about the relationship between WGW and Mr. Wood and L. Lynn Wood PC are contained in your report that Alston and Bird sent to Mr. Wood. Is that right?
So you're talking about the July 13th memo?
Yes.
That Joey Burby and Sarah Donahue prepared from our firm. And the facts that we felt were important to the analysis there, as we understood them, are summarized in the early sections of that memo.
Thank you. Let's turn to Plaintiff's Exhibit 95.
I have plaintiff's exhibit 95 in front of me.
Thanks. And I think the factual section is on page 3.
So you want me to skip past the email at the beginning
Yes.
and go to the memo?
Thanks. So the relevant sections, the relevant facts that Mr. Wood told you, you guys put there on page 3.
Well, the facts are from page 3 to page 7 of this memo. So facts that we thought were relevant to the analysis that we were providing to our client are set forth on those several pages.
Did Lynn ever tell you that the 3 plaintiffs since 2016 only handled cases for and on behalf of L. Linwood PC?
I don't remember that.
Did Lynn ever tell you, did Mr. Wood ever tell you that he insisted that the 3 plaintiffs open or create an LLC to receive funds?
I don't want to sound like former President Clinton when I ask you this question, but could you define the word "you" in that sentence?
Tell Alston and Berg in the communications.
So I need to make sure I'm understanding you.
All right.
Okay, so I know what Mr. Wood told me or didn't tell me. There are others at my firm that worked on this case. I may or may not know what he told them.
But if it were material, you would put it in this memo, right?
So if we found it to be material, it would have been summarized in this memo that Mr. Burby and Ms. O'Donohue prepared.
And did Mr. Wood ever tell you that he had routinely called them partners in front of judges and other lawyers?
I don't remember that, but I do remember, because I'm looking at page 3 of the memo that you put in front of me, that the memo said, quote, "Despite not being employees of L. Linwood PC after April 2018, Jonathan and Taylor were occasionally held out to be employees as discussed below." And then there's further discussion on that point below.
And Lynn never told you that they were always held out to every client, every court, every opposing counsel as lawyers of the firm, did he?
I don't remember that conversation with always, every, as you just used it in your question.
Let's look over at page 9 of your report.
And when you say your report, you're talking about
Alston
Mr.
and Bird report, and it's at the bottom of the page, that number, which I believe is Bates number 2939.
Okay, I'm on page 9 of the memo.
And can you read for us comment 8 of Rule 1.5 at the top of that page?
Sure. So comment 8 says, quote, "Paragraph E does not prohibit or regulate division of fees to be received in the future for work done when lawyers were previously associated in a law firm." Close quote.
You then cited the law review article written by David Doge called Eye on Ethics on page 9, where you state lawyers who are otherwise independent contractors may be deemed to be in the same firm if they hold themselves out to clients as having such a relationship or practice together as a single collective entity. Did I read that correctly?
You did. Again, this is not my memo, and that was not my comment. That was a quote from a law review article.
And you believe that follows closely with Georgia ethical rules that a determination of whether a lawyer is in a firm or not can turn in large part on how they hold themselves out to the public.
The point that we reached in this memo, Mr. Beal, as you're aware, is that the Georgia Supreme Court and Georgia law hadn't established this and it wasn't
Objection, Your
clear.
Honor. I need to get a yes or no to my question.
All right, you can just answer the question, and then you can respond with any clarifying points.
Can you read
have.
that one back for us, please?
You believe that follows closely with Georgia ethical rules that a determination of whether a lawyer is in a firm or not can turn in large part on how they hold themselves out.
So I think the answer to your question is no. And if I may explain, the point is that the Georgia Supreme Court, as we understand it, hadn't decided this issue. And that's why we weren't quoting a case from the Georgia Supreme Court, and we were having to go to things like articles from this guy, David Dodge, and other things to try and help get us to an answer when there wasn't an answer.
Let me direct your attention to exhibit 400 that should be sitting right up in front of you here. That's 401. I think under it is 400. There you go. And I'll represent to you that exhibit 400 is a reprint of the State Bar of Georgia Ethical Rules, Rule 1.0. And ask you to turn to page 4.
Sure.
At the bottom of the page, it has the word firm, definition, whether two or more lawyers constitute a firm within paragraph E can depend on the specific facts. For example, two practitioners who share office space and occasionally consult or assist each other ordinarily would not be regarded as constituting a firm. However, if they present themselves to the public in a way that suggests they are a firm or conduct themselves as a firm, they should be regarded as a firm for purposes of the rules. Did I read that correctly?
Yes, you did.
Does that refresh your recollection that the Georgia bar rules closely monitor this expert report written by David Doge that you've cited here on page 9 of the Alston and Byrd letter?
Your Honor, I object. I didn't present Mr. Burby and Mr. Marquardt as an expert witness on the law of such and such issue. I presented him based on his advice to me, and he's soliciting opinions, and that's outside the scope of what he's testified here to today in terms of his direct examination.
All right, Mr. Beal, I mean, I think I've instructed them whether his opinion is right or wrong is not what the relevance of his testimony is. And so what would be the purpose of this line of questioning?
The determination of good faith in reaching the conclusion and what facts they investigated evidence whether this was truly an independent investigation or simply an attempt to give Mr. Wood what he wanted to hear.
All right, you can proceed.
So does that refresh your recollection?
Yes, yeah, overruling the objection. Noted for the record.
So I'm gonna be able to, Your Honor, to be clear, I can go into redirect and talk about a lot of different legal theories and positions he has.
It's directly in their report.
It's going to depend on the question asked, Mr. Wood. I think we already have done a lot of that.
Cross-examination is limited to the scope of the direct. This
Right.
witness was presented to talk about the legal advice that he gave me, the advice of counsel. It's in writing. He can testify to it. He wasn't presented here to answer questions about other issues of law. It's irrelevant.
I agree with you. I agree with you there. Well, I think what he's trying to set up here is whether there were certain facts that were brought to his attention.
That's why we went into wanting the complaint in.
That's right. And that's why it's in. All right.
Limited, you said.
That's right.
Your Honor.
Okay.
And I'll just point out for the court that it is this witness's firm report that we're quoting from, and it's identical to the state bar rules.
That's
the only purpose.
testimony. He does that all the time.
Well, actually, it's kind of been fair game for everyone, Mr. Wood. So,
By me, I've not tried to testify.
okay, we're moving on.
This is rude.
We're moving on, Mr. Wood. I understand.
Laughing. That's not professional. He has no professionalism. I'm making an objection,
I understand.
and I'm saying that He's trying to testify that this is the same as that. He's supposed to ask the witness that question.
Can we move on?
Okay, next question. No,
Thank you. So if holding oneself out to the public is relevant, you never had an opportunity to see their website. Is that correct?
Are you asking me, did I look at their website?
At this time, at or about, the Q1, Q2 of 2020.
So I don't recall looking at their website at the time that Mr. Burby and Ms. O'Donohue prepared this memo.
But holding yourself out to the public, if they listed themselves as partners and as part of the firm on the website, would you agree that that is the ultimate act or a very important act of holding yourself out to the public?
Are you asking me, is that the ultimate fact that led to my conclusion, or are you asking me a different question?
Would you agree? You would agree, wouldn't you, that the way someone represents their firm on their website is evidence of how they are holding themselves out to the public?
I think it's fair to say that that is one piece of it. And there, as the memo pointed out, Mr. Beal, we looked at a lot of different things. You're looking at one quote of a 13 or 14 page memo. And if you looked earlier in the facts section, something that was relevant that we considered is the fact that they all had their own law firm. So there were independent law firms at the same time. Each of them, as we understood it, had their own law firms. And so that was part of what we took into account when we said, if all of you have your own law firms and the rule says what it says, we think our recommendation should be take the conservative approach, go ask the client for consent.
Objection, Your Honor.
See if he
Now
will
he's
consent
testifying about something
or not.
unrelated.
I disagree. I think he's answering the question. You can continue.
So that's why we gave the advice to Mr. Wood that we gave, which said, it's a close call. The Georgia Supreme Court hasn't ruled on this. So just go ask the client, and don't just ask, recommend to the client that the client give consent. We prepared a form to that effect. We gave it to Mr. Sandman's lawyer, and we understand that Mr. Sandman presented it to his client, and he said, I do not want to give consent.
And you never checked how they were listed with the State Bar of Georgia regarding their practice and who they work for. Is that true?
So I personally didn't do that. I also personally didn't write this memo.
All right.
Others at the firm did, so I don't know exactly what the others at the firm did or didn't do.
Let's look over at Exhibit 48.
Defendants Exhibit 48. Mr. Beal, Defendants Exhibit 48.
Exhibit 48 in the plaintiffs.
Plaintiffs, thank you.
But before we do that, let's go back on what you said a second ago. You said Lynn told you that they had maintained separate firms. Is that correct?
The memo states that they maintain separate firms. So I don't recall where my colleagues got that information, but it's referenced, as I recall, in the memo.
So did you ever see any evidence that any of the three of them ever handled a case during this time period as their LLC and not as L. Linwood PC? Ever?
I don't know if they did or didn't.
But that would be really material to this determination, wouldn't it?
I don't think it would.
Okay.
I think the question is, were they part of the same firm or different firms? And the existence of different law firms raises that question, which is part of what we discussed in the memo.
And whether Lynn asked them to open these LLCs or not would be material and relevant, wouldn't it?
I don't think it would.
Okay, let's look over at Exhibit 48.
Yes, sir.
You never saw any of these late night emails on February 22nd or March 4th when drafting your report.
I didn't draft a report. Others at my law firm drafted the report. And so what's your question about Exhibit 48? Did I personally see Exhibit 48 in June and July when my colleagues were drafting the report? Is that your question?
Do you know if Lynn shared any of these emails to Todd McMurtry on February 22nd and March 4th with your firm while they were preparing this report?
I don't know that.
Okay. In fact, you've never seen those until this litigation. Is that fair?
I think that's true.
And let's look over at Bates number 2872, the March 4th email.
So we're still in Exhibit 48?
We are. It's about 4 pages, 3 pages into it. 4, I think. Maybe 5. 2872.
I'm there. Yes, sir.
Okay, so does that appear to be a March 4th email from Lynn to Todd McMurtry?
Yes, it appears to be a March 4th email from Lynn to Mr. McMurtry.
And that's sent to Mr. McMurtry on the exact day that he hires your law firm. Isn't that correct?
I don't know the exact day that Lynn hired Joey.
We've seen evidence of a March 4th conversation involving you and a March 6th retainer agreement signed. Any reason to believe those dates aren't accurate?
It seems about right. I just don't know sitting here whether it was March 4th or 5th, 6th. I don't know.
Okay. And if we read this, it says, I'm prepared to offer WGW fees on quantum Merowit basis only, all caps, for Carboni and Lindsay. Their problem on those cases is that they did not keep up with their hours and can only reconstruct them after the fact of settlement. Did I read that correctly?
You kind of stumbled over the word reconstruct, but otherwise you did a good job.
Okay. The dollar amount that I'm willing to offer these foolish people in an effort to be kind and attempt to do God's will is only a portion of the Sandman versus CNN fee due and payable to LLWPC. After considering the absurdity of the demand they made upon me yesterday, I'm now inclined only to offer them between $100,000 and $200,000. Did I read that correctly?
You did.
And would it be important for you to know that this information was communicated by Lynn to Todd prior to executing the settlement agreement?
No.
Okay. In fact, you're not familiar with the testimony of Todd McMurtry in this case. Is that correct?
Thankfully, I haven't been spending my time listening to testimony of others in this case, but no.
So the answer is that's correct.
That is correct.
All right. And so you also don't know the testimony of Nick Sandman in this case. Is that correct?
That is correct.
All right. And you learned additional facts about the relationship of the parties from the filing of the complaint. Is that correct?
I learned additional allegations from the filing of the complaint. Yes.
Okay. And you learned about these 3 emails during the course of this litigation. Is that correct?
I don't remember these 3 emails specifically.
And Lynn never told you that he was calling Todd and writing Todd to urge him not to fulfill the settlement agreement, did he?
Objection, Your Honor. There's been no testimony about me telling him anything about not fulfilling the settlement agreement.
And then he can answer the question if he knows the answer. Overruled.
I'm sorry. Can you ask your question again?
Lynn never told you that he was calling and writing to Todd McMurtry, asking him not to comply with the terms of the settlement agreement.
Objection, Your Honor. That would imply that there were written correspondence after March 17th. There's been no evidence that that ever occurred.
All right, Mr. Wood, I understand.
It's based on evidence that
We don't need to get into the particulars, Mr. Woods. Members of the jury, I'll remind you that the questions asked by the attorneys are not evidence. Mr. Gill, you can proceed.
was my objection overruled.
It's overruled.
I keep getting lost from the question.
Can you read that one back for him, please?
Lynn never told you that he was calling and writing to Todd Mercury, asking him not to comply with the terms of the settlement agreement.
So Lynn didn't, and the emails that you're showing me predate the settlement agreement. These are before we got involved to try and get the temperature lowered, get the parties to resolve their disputes and enter into the agreement that they signed on March 17th. So that's, I know nothing about what you just suggested in your question.
And you would agree that the sworn testimony people have offered in this case is always what the jury should consider.
Objection, Your Honor. That's not a proper question of this witness.
All right, next question. No sustained.
All right. Let's look over at Exhibit 106. In the plaintiff's binder.
I'm at Exhibit 106.
Okay. And that is the email transmittal of your July 24th letter to me, July 24th, 2020. Is that correct?
Yes, sir.
Okay. So on the first page, it says in the first large paragraph that starts with the fee splits, the second sentence says, the clients in the Carboni and Lindsay cases have consented. How did you obtain the consent of Carboni and Lindsay?
My recollection is that there were specific agreements that covered that issue with those clients.
So would it be fair to say that there was no attempt to reach out to David Carboni or Sharon Lindsay?
It's fair to say that no one at my law firm attempted to reach out to them.
And the next paragraph, you say, without client consent, the fee splits pertaining to the Sandman cases in the settlement agreement are void. The other provisions of the agreement remain valid, however. And LLWPC intends to honor them and expects for WGW to do the same. Did I read that correctly?
You read that correctly.
All right. But that wasn't always your position, was it?
That is different than what the July 13th memo says.
Okay. And the July 13th memo says specifically the entire contract fails or the entire contract is the entire settlement agreement is enforceable, correct?
What we concluded at the last section of that contract is that if a court were to look at this issue, we believe that a court would likely find that striking down one provision would mean the whole provision is invalid. Yes.
Okay.
The whole agreement, excuse me, is invalid.
But what you wrote about 10 days later did not follow the advice you gave Lynn about the enforceability of select parts of that agreement. Is that right?
That is correct. What is in this letter is different than what is in the memo.
Okay, let's look over at Exhibit 131.
Is that a separate notebook?
Yes, I'm sorry.
Okay, I'm at Exhibit 131.
And does this appear to be the email that Joey wrote to Lynn and copied you on August 31st, 2020?
Yeah, that's the date. Yes, sir. Excuse me. That is the date on this email.
All right. And that's the same date that you wrote that letter that you were testifying about on direct to me, the same day.
It's the same day you filed your complaint and the same day I wrote the letter.
All right.
Busy day.
Let's look at the second paragraph. She's found some additional cases that, combined with the additional facts in the draft complaint, make this question a closer call, in our opinion. Before we respond to Drew's settlement demand this morning, we wanted you to have this additional information in case it changes how you want us to proceed. Would it be fair to say that was kind of the purpose of this memo, that you now felt that the legal issues presented were a closer call?
You're asking me the purpose of Joey Burby's email to Mr. Wood?
I'm asking you about the substance of Joey Burby's email to Mr. Wood.
I'm sorry, what about the substance of it?
Was the substance of it to explain some additional case law that made your determination a closer call?
So as you read, Mr. Burby wrote what he wrote in this email and indicated that based on some additional things, that it was, in our view, a closer call. Yes.
Okay. And you have cited several cases and articles in this email. Is that correct?
Give me a moment to look at it, please.
Sure.
So what we've done with this memo, what Joey did in the email that you're having me look at now, was to...
Objection, Your Honor. I just want to answer the question.
All right.
Did you cite a bunch of cases in this memo? And then I'm going to get them to talk about those cases.
All right. Let's start with that,
Okay.
and we'll go from there.
So Mr. Burby, in his email, cited cases from Missouri and Ohio and other states, and described them leading up to a last paragraph that says, to be clear, we don't know how a Georgia court applying either Georgia or Kentucky law would follow the rationale of these decisions out of Missouri. And significantly, this would be a case of first impression in both states. That is, neither state's appellate courts have ruled on what it means to be, quote, in the same firm for purposes of Rule 1.5e.
Why don't you just keep reading?
Sure. And it remains the case that while you and WGW held yourselves out to the public as members of a single firm, you in fact were never part of the same legal entity during the relevant period, and each had your own separate firms. But it's certainly possible that a court could elect to follow what appears to be the only relevant case law out there and interpret in the same firm broadly based on the arguably broad definition of firm contained in Rule 1.0, and hold that if you practice together as a firm and hold yourselves out to the public as a firm, then you are a firm for purposes of Rule 1.5, regardless of whether you're actually members of separate legal entities. We're happy to discuss this further with you this morning if you'd like.
Thank you. And I believe you say on the preceding page, the last paragraph, that the Missouri rule is almost identical to the Georgia rule. Is that right?
So let me see what Joey said on the prior page.
the last paragraph, the
So
second sentence.
Georgia's rule-
1.0, which is
Sorry.
very similar to the Missouri rule, defines firm or law firm as a lawyer or lawyers in a private firm, law partnership, professional corporation, sole proprietorship, or other association authorized to practice law pursuant to Bar Rule 1-203D, or lawyers employed in a legal organization or the law department of corporation or other organization, period, end quote. Did I read that correctly?
Yes.
And that's the part that was very similar. He goes on to say, comment 2 to Georgia Rule 1.0 may also be instructive. Whether 2 or more lawyers constitute a firm within paragraph E can depend on the specific facts. For example, 2 practitioners who share office space and occasionally consult or assist each other ordinarily would not be regarded as constituting a firm. However, if they present themselves to the public in a way that suggests they are a firm or conduct themselves as a firm, they should be regarded as a firm for purposes of these rules. I read that correctly?
I'm sure you did.
And that's what we've read several times. So this was what was communicated to Mr. Wood on August 31st. Is that correct?
Yes, you read parts of what was communicated to him on that day.
Now, you never spoke directly to Nick Sandman.
No, as I explained yesterday, he had a lawyer. And so the appropriate thing to do when someone is a represented party is to speak to the lawyer for the party instead of speaking directly to the represented party.
And so that applies to all of Alston and Bird. Same rule, same principle. You guys didn't talk to Nick.
Correct. I don't believe anyone at my law firm spoke directly to Mr. Salmon. Joey and I spoke to his lawyer.
And so if what people said to Nick or how he was actually feeling is unknown to you and to Alston and Bird, it would only be known to those people who spoke directly to him. True?
We never spoke to him, Mr. Beal.
Okay, thank you. You never asked Lynn where the Sandman fees actually were, did you?
When?
During this time period, when you're writing these letters saying there's no evidence of fraud, you never asked Lynn, hey, is the Sandman money still in your escrow account?
Well, I think there were parts of the time when the Salmon money was with the court, waiting to be dispersed. So that's why I'm asking, when are you saying this? But actually, let me,
At the end
if
of
I may
July,
respond.
when the money was dispersed,
Yeah.
did you ever ask Lynn, what did you do with the Sandman money?
I don't remember if I personally asked Lynn that.
And you don't know if it was still in his escrow account or it had been moved to his operating account or all the way to his personal account.
Yeah, I don't know anything about Mr. Lynn's money or his client's money.
All right. So I believe you testified there were offers of mediation to me on behalf of the defendant in this case. Is that right?
What I testified is there was a 3-part offer. There was an offer for Mr. Wood to sit down directly with your clients and try and work this out. There was an offer to bring in a professional mediator so that that person could try and help them work it out. And then there was an offer to send this to an arbitrator so that a retired judge sitting as an arbitrator could decide this in a way that prevented a jury from having to sit and hear this dispute.
When the plaintiffs demanded the full payment, was any portion ever paid to them that you're aware of?
Which full payment?
Full payment under the settlement agreement. Were any funds paid to them under the settlement agreement?
My understanding is that the plaintiffs paid no funds to Mr. Wood that were called for under the settlement agreement, and that Mr. Wood paid no funds to them. My understanding, which might not be right, is that no one made payments to anyone because a lawsuit was filed.
Let's look over at defendants, that big defendants binder, number 69. Well, before we do that, this may save some time. Let me ask it this way. Are you aware of a new contract that was entered into between Mr. Wood and Nicholas Sandman at the end of July?
So I don't believe I ever saw it. I do think that in July, Mr. Sandman turned 18 and was now an adult. And so I seem to recall that there might have been a new letter because he was no longer under his parents' care. So
Right. Go ahead and look at 69 if you can find it.
I got it.
Thank you. And neither Alston and Bird nor Lynn ever insisted on inserting any language that that Linwood had the right to share fees with WGW. Did that
I'm sorry, to insert language into what?
into Defendant's Exhibit 69, the new fee contract that said, all right, this is a new fee contract. I, as Linwood, have the right to share fees with various other lawyers.
I'm in defendant 69, not plaintiff 69.
Correct.
Okay, I'm sorry. I'm looking at the wrong notebook.
All right, sorry. Got it, man.
What is the exhibit number you're talking about?
69,
69?
it's yours 69.
Oh, yeah, okay, I'm with you.
All right, I apologize about that. Mr. Beal, I am at defendants 69.
Okay, and as you look at it, it appears to be the new Nick Sandman fee contract, right?
It does. I don't know that I've ever seen this document.
Okay, and it does not contain any rights of Linwood to share fees with other lawyers such as WGW, does it?
Do you want me to read this 2-page document that I've never seen to answer that question?
Let me ask you this. If it contains such language that would have resolved any concern about Rule 1.5 back at the end of July of 2020, wouldn't it?
Objection, Your Honor.
Grounds.
I'm waiting to pull up the exhibit that he's referring to. You have in front of you,
Yes, sir.
now approach the witness to see what document he's looking at. We're trying to find it.
It's Defense 69.
That's correct.
All right, can we look in, you have your own binder?
I object, Your Honor, to Mr. Beal's question because it ignores the fact that the engagement agreement on July 24th was executed simultaneously almost with my, may I finish, please?
No, Mr. Wood, because it's sounding a lot more like legal argument. If you want to approach to make a basis for it, you
Let
can,
me approach.
but that's pretty expensive.
You snooze and then outdoor.
Like that too.
Thank you, Your Honor.
All right, Mr. Beal, you can, the objection's overruled. You can re-ask the question if you remember it.
Okay, and so you don't see any reference in Defendant's Exhibit 69 to the power of Lynn to share fees with any of the plaintiffs here, do you?
Again, I haven't read this whole letter. I'll trust you that it's not in there.
Okay.
What I can tell from looking at the letter is the date of the letter is July 24th. The letter that you've shown me from me to you previously is July 24th. And in that letter, I communicated to you that Mr. Sandman had declined to consent. So from a timeline perspective, it seems that by the time this July 24th letter that you just put in front of me was written, we had already had the conversation with Mr. Murtry to see if Mr. Sandman would consent. We had asked him to seek that consent at Lynn's recommendation. He had already said no, it appears, because that's the day that we wrote to you in a letter reporting that the consent had already been declined.
But you never spoke with Nick.
I spoke with his lawyer.
Okay. And you never included language in this new agreement that said, or you never saw language included in the agreement that says Lynn had the power to share fees with the plaintiffs here.
Yeah, to be clear, I've never seen this document until right now.
Okay.
Right, so I had nothing to do with this letter, but what I just tried to explain is, from a timeline perspective, we had already talked to Todd McMurtry to seek consent. Todd McMurtry had already told us that his client doesn't consent. And so that had already happened before this letter was written.
So the letter saying that there was no consent and the new fee contract and his 18th birthday were all the same day.
I don't know when he turned 18. I know it was around this time.
And the letter rejecting plaintiff's claims or saying you're not going to pay plaintiffs was written and emailed to me that day also.
It was written on the 24th.
Thank you. Let's look over at plaintiffs 262. So it's volume 2 of the plaintiff's book.
Should have done yoga this morning.
Sorry, I'm trying to give you a workout today. I apologize.
All right, I'm on plaintiffs 262.
Does this appear to be a letter sent from me to you via hand delivery with an attached copy of a check dated December 7th, 2020, made out to Ellen Wood PC?
So the letter's not dated,
Right.
but there is a check attached to it dated December 7th, 2020.
And is the amount of the check $13,449.69?
Yes.
Let me read the first paragraph and tell me if I got this right. On the afternoon of Friday, December 4th, 2020, my clients received the parties S' fee and reimbursement of outstanding costs in a matter subject to paragraph 1A subpart 4 of the parties March 17, 2020 settlement agreement. Per paragraph C of the settlement agreement, 20% of this fee is paid to L. Lynn Wood PC by my clients within 72 hours of their receipt of the funds. Did I read that correctly?
You sure did.
And then there's another paragraph that explains in more fulsome or complete detail the actual back and forth of all the numbers,
There is.
indicating that this is a contingency fee that settled and was referenced in the March agreement. It got cut up by the plaintiffs, and I was giving Lynn his share of the money. Is that right?
Yes.
Thank you. Next one is the next exhibit, 263. And does this appear to be my July 9th, 2021 letter to you? Oh, it's to Lynn.
Right. Yeah, I wasn't working for Mr. Wood in July of 2021.
Okay, I just saw that. Thought you were still there then. That was after you had terminated your relationship with him. Is that correct?
That's correct.
I say you, I mean Austin and Bird. I apologize. Just 1 second, Your Honor. Take out your color. And I believe you've testified previously that you didn't know Lynn had taken all the money from the Carboni and Lindsay settlements before the March 17th, 2020 agreement. Is that correct?
You asked me what I testified during this trial, or you asked me a different thing?
Yeah, I'm asking you, I asked you before, you didn't know if Lynn had taken all the money out of his accounts. But I believe I limited that to the Sandman case. So let me withdraw that question and just ask this more simple question. At the time the parties were signing the March 17th, 2020 settlement agreement, you were unaware that Lynn had already taken all the money into his personal account on 2 of the cases that are referenced in the agreement, the Carboni and Lindsay cases. Is that right?
What I told you is I don't know anything about Mr. Wood and his money. So I don't know.
Okay. And because you haven't been in this case, you're not really aware of how many times the parties have mediated this case, are you?
Objection, Your Honor.
And the grounds, just give me
Court ordered mediation a few weeks ago. That's the only time there's been any mediation, and that, this,
okay, that's inappropriate. We shouldn't be commenting if you're not on the stand. Jury will disregard anything they heard from a party who's
so
not
I
testifying.
object to the question number 1. We did have a court ordered mediation. It was not successful. That was a few weeks ago. There had never been a mediation in this case, and to the extent that he suggests otherwise, that is false.
All right, so
What about the
Mr.
mediation?
you can ask whatever this question, I'm sorry, you can ask whatever this witness knows he can answer. So please ask the question.
Representation. I mean, there was a mediation with Mr. Hill at the same time that he was offering it.
I
All
don't
right.
know who Mr. Hill is he's talking about.
All right, we'll clean it up. Mr. Wood has said he's going, all right.
Okay.
I never met with Mr. Hill.
Okay, we'll move it on. We'll move along, and I think you'll have the opportunity to explore that if you need to recall him or if Mr. Wood chooses to testify.
Are you aware that there was an all-day mediation with Bill Hill, the attorney, judge, and mediator in this case in September of 2020?
I have no recollection of that. Are you suggesting that I was there?
No.
Okay. I'm getting old, but I didn't think I was getting that old.
We're just cleaning up what goes into evidence, Your Honor. Right. I was looking for that, couldn't find it. Thank you. All right, now we got to go back to defendant's binder. We're just going to wrap up with putting a couple bills into evidence.
Yes, sir.
I think we put into evidence 95 and 96. So can you turn to exhibit 97?
I'm at exhibit 97.
Does that appear to be an invoice from Alston and Bird to Mr. Wood?
So this is in the format of my law firm's invoices. I was not the person responsible for sending bills to Mr. Wood. That was Mr. Burby. Other than recognizing the format of this, I can't help you much.
Okay. Can you turn over to 98? Same set of questions. Does that appear to be an invoice that you recognize as in the format of Alston and Bird on this subject with time from you and Joey and Sarah and anybody else at your firm that worked on Mr. Wood's case?
So my answer would be the same. It's in the format, but I was not a part of preparing this or sending it.
Your Honor, at this time, we would offer defendants exhibit 97 and 98 into evidence.
An objection to 97 and 98.
I don't have them. They're in your book here. Here's your book.
I wonder where my book was.
Well, no, this is the one you gave me, but that's all right. Look at 97 and
Please,
98.
Got it right here.
I got it confused.
Yeah.
Full objection, Your Honor.
97, 98 submitted.
Thank you. Now let's look over at exhibit 99.
I'm there.
Thanks. And let's look over at page 4.
Okay, I'm on page 4.
Do you see a time entry for July 23rd? In the middle of the page, one from Joey Burby, 3.5 hours, and one for you for 0.8.
I see those.
Okay. Take a look and read over what Joey describes as his activities. And does he indicate that he was conferring with you?
Excuse me, there's two questions now. Which one's the one to answer?
You could break it up, Mr. Beal.
Does he indicate that he was conferring with you regarding strategy?
Yes.
And does he also indicate that he was drafting a letter to Drew Beal, regarding consent issue? Is that correct?
Yes, he indicated he was drafting a letter to you.
And then your time entry indicates you work on notice letters to WGW about N. Sandman fee split issue strategy with Joey Burby. Did I read that correctly?
Yes, you did.
All right. So would it be fair to say that on July 23rd, you guys were drafting up your July 24th letter to me saying that there would be no fee sharing in the Sandman fee, and you were doing that on the 23rd?
So what this indicates is that Joey and I were working on a letter on the 23rd that got sent to you on the 24th.
Okay. And Nicholas, I believe your testimony was Nicholas was presented the new fee contract, the consent on his birthday, the 24th.
Well, that was your testimony by virtue of a question.
Is that what occurred? It was presented to him on one day. I believe he testified to that.
I don't remember the day that it was presented to him because I didn't present anything to Nicholas Sandman. I spoke to his attorney.
Okay, so before he turned 18, you guys had drafted the rejection letter that was sent to me on July 24th. Is that correct?
As I told you, I don't know his birthday.
Thank you. I'm all done.
All right. Any redirect on those points?
Yes, Your Honor. Could you look at Chris? Plaintiffs, I believe it's Exhibit 5, which is the settlement agreement of March the 17th, 2020. P102. I'm sorry. Look under plaintiffs 102. It's D5 for us, but it's same exhibit.
What exhibit are you pointing me to, Mr. Wood?
Which book do you have? Look at defendants 5 in there. And if not, it'll be under plaintiffs
102.
102. I'm sorry, Chris, it's confusing. Never seen.
I apologize. I have the settlement agreement in front of me.
Would you look at paragraph 2 under office lease?
Yes, sir, I'm there.
Now, Mr. Bill got you to testify that they had sent me certain fees from a couple of cases that were the subject matter of this agreement. Do you remember him asking about that?
Yes, sir.
Would you read what the agreement says under office lease, section A?
WGW shall pay to LLWPC the amount of $285,000 in full satisfaction of any obligations WGW may have or be alleged to have under the lease agreement with PR2 Regions Plaza LLC for Suite 2040 at Regions Plaza.
And I was allowed, strike that. Does this agreement that they signed allowed me to deduct from any payments they made any payments, sorry, the amount shall be deducted, the amount of the lease, 285, shall be deducted from the payment by LLWPC to WGW referenced in section 1B above. So if I got fees from a case,
Objection, Your Honor.
I haven't even asked the question.
Overruled. You can ask the question.
So he gave you 2 examples of cases where I had fees that I received from a couple of cases that were part of the settlement agreement. Do you recall him asking you that?
Generally, yes.
And this agreement allowed me to use those fees that would have otherwise gone to Wade, Grunberg, and Wilson up until they had paid me the $285,000.
It's all leading. I mean, he's just leading them about his.
All right, overruled.
That would allow me to deduct any fees received under the agreement that were otherwise owed to Wade, Grunberg, and Wilson until I had been paid the $285,000 they agreed to pay me on their share of the lease. Have I got that right?
Generally, yes. The idea was that those amounts were going to net out. There's going to be money going from one side to the other and back, and so that they could be applied in the way that is set forth here in the document.
Have you ever heard of a mediation in this case while you were involved in it that involved former Judge Bill Hill?
No, I have.
Allegedly taking place in September of 2020, you heard him?
I appreciated Mr. Beal clarifying that I was not there because I just don't remember.
I wasn't there either.
Okay, Mr. Wood,
Didn't,
that, I've told you before, we're not supposed to interject personal comments.
are you aware of the fact that I never attended a mediation in front of Bill Hill in September of 2020?
If you did, I don't remember you mentioning it to me.
Did you have any recollection of ever receiving any correspondence from Bill Hill or Andrew Bill talking about a mediation in September of 2020?
I don't. I've worked with Judge Hill before. I just don't remember working with him on this matter.
Judge Hill did conduct a mediation in the Martin Luther King Jr. PC case some couple of years or more before September of 2020. That was all day. Strike that. I mean, we made you made very clear that on behalf of me, you offered to meet with these people, right?
I made that offer on your behalf, yes.
That I offered to have the matter put to a mediation, right?
You did. And we communicated that to Mr. Beal. I communicated that to Mr.
And that
Beal.
I offered to have the matter subjected to binding arbitration, right?
Correct. And I communicated that to Mr. Beal on your behalf.
And those offers were quickly rejected by Wade, Grunberg, and Wilson and Mr. Beal, weren't they?
They were. The point or the timing of them was before a complaint would be filed in court. We made those offers to try and try and work to resolve the matter to prevent a lawsuit from having to go forward.
During your representation, Austin Bird's representation, did I ever reject the advice that you gave me?
I'm pausing only because it was over a period of many months and we had a lot of conversations.
Talking about advice that you gave me with respect to Wade, Grunberg, and Wilson.
We had some differences of opinion about publicity, where we stated an opinion and you felt differently.
Other than the differences on, well, that wasn't legal advice from you, was it? That was just your expressing that your policy was not to engage in the court of public opinion, recognizing that mine was different. Am I right?
We were talking about this dispute, right? And the lawsuit that came out of the dispute, and we were talking about that. So I viewed it as my advice as your lawyer and counselor to you, and we had a legitimate difference of opinion about that issue.
Did we have any other legitimate difference of opinion where I did not follow your advice or Joy's advice other than with respect to what you've mentioned regarding publicity?
I can't think of anything else.
Did you or Mr. Burby ever tell me that I had some legal duty to escrow the monies that I received in the Salmon case?
I don't remember that coming up. I don't remember you seeking our advice on that point or asking for our advice on that point.
And you don't recall ever giving me that type of advice, regardless of whether I asked for it or not. True?
I don't. Now, and of course, I don't know what you talked about with Joey, but I don't remember that myself.
Mr. Bill made some reference to the idea that I had commented on potentially suing Austin and Bird for malpractice. Remember him asking that?
I remember that one.
Did you understand at any time that having retained your law firm to draft, research, and draft a fee-sharing agreement, that I expressed any displeasure because you had not brought to my attention Rule 1.5?
Mr. Wood, I don't remember the specifics of that. What I do remember is that the fee sharing agreement that became part of the settlement agreement is something that the plaintiffs had proposed to you before we were even retained. And that part of our work was, as I've said several times now, to get the temperature down and to bring this to conclusion. And what that ended up meaning is that the settlement agreement that was signed on March 17th included the financial terms that had been agreed to between the plaintiffs and you before we were even retained.
Right, I had come to a tentative agreement with them on these splits. But we had a host of other issues that had to be resolved in the agreement, like the lease.
Right, and that's what we worked on, but to be clear, in response to your question, you didn't seek our advice about the splits. The splits had been reached between the plaintiff's proposal and you before we were even engaged in this
Right, the
matter.
amount of the splits had been tentatively agreed to, and I put those splits, asked you to put those exact splits in the March 17th agreement, right?
You directed us to do that, and we did that.
But I'm not asking you about that. I'm asking you about what I didn't know at the time. I didn't know anything about Rule 1.5 and client consent.
Objection, Your Honor.
Strike that.
Rephrase.
Your firm never raised the issue with, and I'm not fussing at you. I'm just trying to establish the truth of the record. Your firm never discussed with me the need for Nicholas Salmon's consent at or before the time you drafted and I signed the settlement agreement. True?
It's true that you didn't seek our advice on that. We didn't discuss it. It's also true that Mr. Beal didn't raise it on behalf of his clients. What is true is that no one raised this issue relating to the financial deal that you struck with the plaintiffs before our law firm was engaged.
Exactly. You didn't raise it. Mr. Beal didn't raise it. It came up over a month after the agreement had already been signed in March, didn't it?
That's right. My understanding is that it came up as a result of work that Joey was doing with you on a completely unrelated matter.
So you could at least understand why, because the consent issue has become the core part of some of this case, that I might be a little upset that it wasn't brought to my attention before.
Yep.
That's fine.
That's an improper question.
I'm sorry,
As phrased,
I didn't finish.
well, the possibility of you being, of what you might be happening or how you might have reacted, I don't believe is an appropriate question for this witness. Next question.
They opened the door when they talked about allegedly that I had threatened to sue them. Now I'm exploring that. I have the right to do that.
You do, but I don't think through this witness as phrased, that's an appropriate question. If you want to try and rephrase it, you can.
The bottom line is, Chris, I did not file any lawsuit against you, did I?
No, and there's no basis for you to file a lawsuit against me or my law firm.
And I didn't suggest, I might have had concerns, or clients have concerns that don't materialize into a malpractice case. Wouldn't you agree?
I think that's possible. What I would agree is there is zero basis for you to file a lawsuit against my law firm based on our representation of you, because we worked very hard on your behalf to try to prevent the dispute that's brought us all here today.
And I appreciate that. And the fact of the matter is, I never wrote you or threatened you or filed any type of a lawsuit against your firm, did I?
I know that you never filed a lawsuit against our firm. I don't know if you or someone working on your behalf sent a letter to the firm. You didn't send one to me.
I don't know. I can't respond to that. I don't know what you're talking about.
I'm just trying to respond to your question.
You have a copy of the letter?
I just said I don't know if a letter was ever sent.
You don't have any recollection of ever getting such a letter?
I know that I didn't get such a letter.
So you don't have any recollection of whether your firm got such a letter?
I don't remember.
Memo, July 13th. While he's looking for, I'm going to ask you about the memo of July 13th.
Yes, sir.
T20, small binder.
I have it.
So let's do the bird's eye view real quick. I come to engage Austin and Bird the very first of March of 2020 about the dispute I'm having with Wade, Grunberg, and Wilson. True?
Again, I don't remember the date, but it was early March.
And then a settlement agreement is negotiated, signed by the parties, negotiated, drafted in part by you, negotiated, drafted in part by Mr. Bill, right? March the 17th.
Objection, Your Honor. It's so
I
cumulative.
think we've covered this, Mr. Wood. Let's cut right to the new subject matter or the thing you're clarifying from cross.
This is just to lay the foundation.
The foundation, I think that's been laid. We've covered a timeline.
So the agreement is March the 17th. The first issue raised about the need for client consent is either late April or early May, right?
That sounds right. In that time range, yes.
And if I heard you correctly and understood you correctly on cross-examination by Mr. Bill, was the analysis done by Austin Bird that in essence said that Georgia law was not clear, right?
Yes, there is not.
And
It's cumulative. He's testifying.
I think we have covered all this ground before, Mr. Wood, so
I
we
have
need to
not
get to the new
covered it.
point. This ground has been covered in this
not by
testimony.
me.
On direct,
May I make the record? Because I haven't covered this with him. First time it came up in my mind was on his cross-examination. It's only 2 or 3 questions, Judge.
all right, it came up on cross. You can proceed, Mr. Wood.
So as indicated by the memo to me from Joey Burby, Sarah O'Donohue, and Austin Bird, you were examined during cross-examination about that memo by Mr. Bill, right?
Yes, sir.
And there was not a black and white answer with respect to the issue of being in a law firm. Is that what you told Mr. Bill?
That's what I told you. That's what I told Mr. Beal.
Right.
Yes.
And so am I right that the solution to take away any problems occurring that you recommended to me that I get Nicholas Salmon's consent?
Correct. I recommended to you that you not only ask whether he consents, but to recommend to him that he does give the consent.
Because if he gives the consent, the legal uncertainty and dispute on that issue goes away, doesn't it?
That was our view, and that was what we advised you. Yes,
And I followed that advice, didn't I?
you did.
Not only in presenting him with the consent form, but in recommending that he sign and consent.
Correct. Joey and I spoke to Mr. McMurtry, and that's the discussion that we had.
On July the 13th, if you go back to the memo, page 1, under subsection 2, brief answer, if you'll follow with me as I read the last sentence in that paragraph, starting with while prior to. Do you see it?
I do, yes, sir.
The memo says, while prior to the agreement, the parties did share office space, work on cases together, and occasionally hold themselves out as members of the same firm. The fact of the matter is that they were not in the same firm at the time of the agreement and had not been, at least Lynn, Jonathan, and Taylor had not been, since April 2018, almost 2 years earlier. Have I read that correctly?
Yes, sir.
So this memo includes information that there had been some form of holding out to the public, held themselves out as members of the same firm. That was knowledge known at the time this memo was written. True?
True.
If you'll turn to page 9.
I'm there.
Paragraph beginning at Rule 1.5E. Again, this is the memo that was sent to me prepared by Austin and Berg. Rule 1.5E is only implicated when a fee is to be divided between lawyers who are not in the same firm. Have I read that correctly?
Yes, sir.
In addressing this threshold question, courts seem to focus on where the participating lawyers were at the time the agreement to divide fees was made to determine whether they were in the same firm. Have I read that correctly?
Yes, sir.
And that cited David D. Dodge, Eye on Ethics, a comment, an article he had written apparently.
Correct. It didn't cite a court case, it cited an article.
At the time that the agreement was entered into was March the 17th of 2020, right?
Yes.
So under that statement, the focus would be on where the parties were in terms of being in or out of the same firm would turn on that time period of March the 17th of 2020, true?
That is true, and that was part of the fact, that was a factor that we considered in giving you the advice that we gave you.
I believe you said on cross-examination that you did learn facts from the filing of the complaint on August 31.
Yeah, yes, there were allegations in the complaint that were new to me when I read it.
Can you state whether or not you agree that if the law is clear on an issue and an individual disregards it, that could be potential evidence of bad faith?
Objection, Your Honor. I think he's
Yeah, I think that's getting into a legal question, Mr. Wood.
They asked questions about his legal issues on these very points,
Right,
Judge.
but this is, as phrased, I don't think it's an appropriate question.
Phrase it. If hypothetically, you had told me, Lynn, the law is clear. Rule 1.5 doesn't apply. And if I had gone forward and started taking the position with the plaintiffs, Rule 1.5 does apply, in the face of the knowledge that you told me it didn't apply, you would agree that that would raise questions about bad faith on my part, wouldn't it?
Same objection, Your Honor.
Yeah, I think he's testified to the facts. You get to argue them in closing as how they apply to the law that I will give the jury.
The bottom line is that you at your firm told me that the law was somewhat unclear in terms of Georgia having not ruled, right?
Absolutely. That was the conclusion that we reached in the July 13 memo.
And then gave me the advice we've talked about to recommend that he consent, and I did, right?
Right. We talked to Mr. McMurtry and had the conversation that I've told you all about several times.
Other than the issue we had about publicity, is it your clear testimony that on all other issues, followed the advice?
Yeah, you've asked that question, Mr. Wood, so I don't want to hear the answer again. Next question. I'm fine on that cumulative. You asked that exact same question.
Want to make sure there's no dispute, Your Honor.
And just
Is
however
there
many
any-
times, okay, I'll let you ask the question, but I might cut you
Yeah.
off again.
Was there any other issue besides a disagreement about publicity? Was there any other issue where I did not follow your advice, the advice of Joey Burby, and the advice of Austin and Byrd?
I don't recall any other issue.
Thank you very much, Chris. I appreciate it. That concludes the examination on redirect of Mr. Marquardt, Judge.
Any recross on those points only?
Thank you, Your Honor. Yes. It's going to be real brief, Your Honor, but it's going to be a little messy because I've got a new exhibit for impeachment and it's only got one copy. So I'm going to show Your Honor. Show the other side.
All right, this isn't sent to him. Is he CC'd on? Wait. Oh, yeah, go ahead. Okay, you can go ahead.
Chris, sorry. Waited till you.
I heard
were working.
mess, so I thought I would clean up here.
All right. It's going to be fast. Would you agree that when a client threatens a lawsuit against you, it changes your attitude and your demeanor toward that client?
So look, on my bad days, yes. When I'm trying to do what I think I should be doing as a lawyer with clients, I try to not get upset.
Okay. And sometimes it can make you more defensive in your dealing with them because they've threatened to sue you. Is that fair?
Excuse me, Your Honor, there's been no testimony that I ever threatened to sue this lawyer.
There
That just makes it
actually
up.
I
His
think you
testimony.
did say that, Mr. Wood.
I did not say that. There's
I'm-
no
well,
evidence that I ever.
That's a
threatened.
question of fact for the jury to determine from the testimony that's been
So
presented so
we're just going
far.
to ask questions on manufactured evidence?
Mr. Wood, overruled. We need to move on.
I'm not crazy, am I? Well, I might be, but you did testify that statements were made by Mr. Wood on social media that you guys had committed malpractice. You guys, meaning Alston and Byrd, in your representation of him in this matter. And you testified to that. Is that correct?
Objection, Your Honor. Those are, we don't know the context of those statements. He's not put them into evidence. And now he's speculating on what the import,
All right.
what the gist of the statements were. They're not in evidence, and it's not proper to examine a witness on information that is not in evidence.
All right, from my understanding, this subject matter was covered in the direct examination, the first one. And so I believe that has been raised. You can proceed, Mr. Beal. The objection's overruled.
Just yes or no, Akron.
Here's what I know. I know I work really hard for all my clients. I know I work to do the best I can do and do the right thing.
Got it.
Yeah,
Okay.
but Mr. McCoy, it's not really going to whether the claims were valid or justified, just the fact, in line with your testimony earlier, was there a statement made at any time by Mr. Wood that you're aware of?
I am aware that at some point, something was on social media suggesting that he was not pleased with the advice that we gave to him.
And that he used the term malpractice.
I think so, but again, I try to filter through the noise.
Okay. And the information about plaintiffs having separate firms came only from Mr. Wood.
All right, we've covered that on
that correct?
cross, so let's move on to the next point.
In Exhibit 95, in your report, in Olsenberg's report, when you use the term occasionally held out as members of the firm, as you view the evidence today based on what you know, would the correct language be consistently for 4 straight years?
Excuse me, objection. I don't know what he's asking. Is he wanting to rewrite?
Well, I do. I think I know what he's asking, and it's basically calling for his current legal opinion, which at this point is not relevant.
Do you remember Judge Constance Russell in this case? Being the judge originally on this case?
Absolutely, yes.
Okay. And do you remember her October 7th, 2020 order ordering the parties to mediate?
I don't.
Okay. Let me hand you what's been marked Exhibit 402 for the plaintiff. And I apologize, but there's only one copy. Does this refresh your recollection that Bill Hill corresponded with you on December 7th and said, all right, these are the rules of, well, let's get this into evidence first. Sorry.
So I'm looking at what you've marked as Exhibit 402. I don't remember this letter, but it certainly looks like Judge Hill sent a letter to you and to me dated December 20th of 2020.
About the subject of mediation, is that correct?
Yes.
Okay, Your Honor, at this time we would offer Exhibit 402 into evidence.
Is there an objection to 402?
I've never seen it before and it's not authenticated, so I object. I've never seen it. It doesn't show a copy to me. And so it's not properly authenticated. So it would be hearsay. They'd have to bring in the author of the letter to say that he sent it.
All
I
right.
object on that basis.
I wouldn't grant it on those grounds. I think it's under, I believe it's 608. If this is being impeached as a prior inconsistent statement, extrinsic evidence is not admissible. You can cross him on the contents of it. You can bring it to his attention, but as an exhibit under 608, I don't believe it is
Okay,
admissible.
that's fine.
So,
And in that December 7th letter, is he sort of setting out his rates and the terms and how we're going to conduct the mediation?
He is, yes.
Okay. And Bill Hill is a former Fulton County judge, plaintiff's lawyer, and defense lawyer. Is that true?
He was a Superior Court judge in Fulton County, and he's a practicing lawyer.
A retired Fulton County Superior Court judge.
Absolutely.
Okay. And does that refresh your recollection that there was a mediation on this case with Bill Hill in 2020?
Wow. Not really.
Is it possible that you don't remember the mediation because $0 were offered?
I don't remember the mediation.
I believe you said on redirect that and on direct that part of your opinion was to recommend client consent and recommend that Lynn, that Mr. Wood asked the client to consent. Is that
Yes.
correct?
That is
Okay.
correct.
And if there was evidence that Lynn was calling the client's attorney in Kentucky, urging him not to consent, that would not follow your direction, would it?
Objection, Your Honor. There's absolutely zero testimony that ever occurred. Mr. McMurtry didn't say it, and he's making it up as if it's an evidence and that misleads the jury, and I object to it.
All right. Not so much the commenting on the evidence, but again, I think we've covered these emails on cross already.
And Mr. McMurtry did offer testimony, and so it is essential that he go ahead and answer that question.
Mr. McMurtry did not specifically.
Well, we're not gonna tag team it here. So Mr. Wood took the direct here. So the fact is, I think this line of inquiry is at this point cumulative. So I'll ask you to move on.
If Mr. Wood had already taken the Lindsay and Carboni fees before executing the March 17th agreement, would that indicate to you that whether he was using them as a set-off for rent or any other reason, would that indicate to you a predisposition by your client not to follow through on the other terms of the March 17th agreement?
Not at all.
Okay. Your Honor, at this time, we would move plaintiff's exhibit 131 into evidence. And defendant's exhibit 69 into evidence. 69 is the new Nick Sandman fee agreement. 131 is the closer call memo that he testified to.
Your Honor,
Sir.
this is beyond scope of recross. If he wanted to cover these, he should have covered them in the first two examinations on cross.
All right, Mr. Bill, why don't you approach and lay it out? I think this relates.
That's 69. I don't have any objection to it. I've got to find the others he's talking about.
P131,
What's P131?
closer call memo.
No objection. What's the other one?
That's it.
All right, both those exhibits are admitted.
Thank you, Your Honor. Nothing.
All right. Starting with the defendants, is there any reason this witness cannot be excused at this
I have
time?
one follow-up from there, just to recross.
On the subject of,
What he raised with him about social media comments about threats to sue. I have one question.
okay, we'll see. You can go.
Was your knowledge about any social? Bless you.
Thank you.
Was your knowledge about any comments I may have made about your firm's handling of this matter on social media? That would have been information that you learned after you had terminated your relationship with me.
Yes.
Thank you very much.
All right, can this witness be excused on behalf of the defense?
For the plaintiff, yes, Your Honor.
I don't know, Judge. I think we ought to keep old Chris around for a while. He may be excused. Thank you, Chris.
Thank you, sir. All right, members of the jury, there's still one more thing that I want to achieve before we break for lunch. Why don't we take 5 minutes, because you've been going at it for a while, and I think we've got maybe 30 minutes more from there, okay? Let us know when you're ready to proceed.
It would take 5 minutes.
5 minutes. It's just 10.
Oh, out of order. I see what you're saying. Yeah, I'll do that.
All right, since I anticipate that defense counsel will be reading their McMurtry designations next, let me take up the objection raised, or objections rather, raised by the plaintiffs, preserving all the ones that they'd previously made and filed. They'd asked for argument and to focus on one specific designation. That one starts, I believe, on page 45.
145, I think you're
And
right.
continues through 148. And as I took it, it's more the nature of the question that's raised, they say mischaracterizes the actual allegations in the complaint. The first thing I would say offhand, that seems to be an objection to form, if I'm not mistaken. Correct me if I'm wrong, and there is one objection to form within that questioning, but it's only the one time. So I wonder if it's only preserved just to the one question. And as for the rest of it, I would say this is something that I would be willing to cure or willing to make an instruction that the questions that are raised are not what is in evidence, and it's only his responses to how they're phrased. Otherwise, I believe it is covering subject matter that is at issue here. I think on 403, there's certainly some probative value here. It's just the form of the question that I hear you all have concerns with, the way that he says, hey, it says this in the complaint, and you're saying, well, that's not actually what our complaint says, or there's more context that's needed. It's unfair as he raises it. So, Mr. Beal, anything you want to weigh in there?
Well, that summarizes our objection. And we think it's a great objection. But I don't have anything more to add per se, other than it's a mischaracterization. So it's it's kind of prejudicial, and it's goes to the form of the question.
Yeah.
But it's not the hugest issue in the world. And in the interest of moving, I'm more interested in moving than I am obsessing about this question.
Okay, well then I would propose that before we reach that portion of the designation, Mr. Exum, you can let me know, and I'll instruct the jury that for the next series of questions, I will remind the jury that the questions asked by attorneys are not evidence, and the jury should only be considering the actual testimony of the witnesses presented.
Thank you.
All right. Anything else we would need to take out?
I just wanted to let.
Yes, Your Honor, for the plaintiff, there is a possibility.
I always let the plaintiffs go first, Mr. Woods, so we'll start there.
There is a possibility that this real brief rebuttal witness, who's only like 5 minutes, might need to be called in their case for scheduling, and
Is he not available tomorrow?
that's correct.
Okay.
And out of town and coming in, and
Who is the
It's
witness?
going to
Yeah.
be 5 minutes.
Who's the witness?
Who's the witness? What's the nature of the testimony? Okay, and what's the nature of the testimony generally, the subject matter? Can you tell me that?
Well, it goes to, her communications regarding, these issues.
These issues of,
Rule 1.5.
okay. All right,
She was
so,
one of the folks who had a contingency fee case that was in the settlement agreement.
okay, I'll let Mr. Wood respond in a minute here. My initial inclination is to say that we'd be back, the jury would be back hearing evidence somewhere around 1 o'clock. Mr. Wood has said his direct would be somewhere between 2 and 3 hours. Let's say it's 3. That puts us at 4 o'clock when cross would begin. And so at that point, if you're saying we could interrupt it with a 30-minute witness, we could do the witness in between. And then resume your cross after that point.
Yes.
So that's my initial inclination, but I'll seek input from the defendants here if they have any.
Yes.
However you wish to proceed.
All right. Anything else we need to take up? I imagine y'all want a chance to step out before,
If we get about
We get
10,
going.
15 minutes after.
okay.
It's 11:30. We've been going since 9. No break.
I understand it's been a lot. So, but we have the designations and we still think those are about, 20 minutes of reading or any better idea of how long that's going to take?
I don't foresee it going much
I
longer.
don't see it being more than that.
Okay, then,
That's on the commercial, right?
Yeah, it's only about Mercy stuff.
all right, then let's come back when you're ready to begin that. All right.
May I address the court briefly?
I think I've given Miss,
Counsel.
I know, but I've given you that opportunity this
I need
entire
to file
time.
a notice of
Excuse me,
appearance.
Your Honor.
I can do so right now, Your
Excuse me,
Honor.
I'm
But just
here
hold
as
up.
a lawyer. She's not. She is as a party plaintiff.
Uh,
Can
And
file
that's-
my notice of appearance.
yeah, Mr. Wood, I don't, procedurally, I don't see an
Hold on a
issue with
second.
this.
I would merely like to make a
Wait a
comment.
second.
Well, wait,
She's
wait.
just filed a document. I haven't seen it. May I have a
We
moment?
actually don't accept filings of documents, so you can, I don't think we do that. You can hand it back. I don't even think that's necessarily, but I understand. Ms. Wade wants to address the court. Mr. Wood, you're saying she shouldn't. I'll allow you to make your objection or any concerns you want to have.
She's not a counsel of record. She's a party. She's apparently trying to file a notice of appearance. If the court accepts that, let her appear, but she hasn't done it yet. Now, we're 7 days into this trial. We've had all kinds of lawyers over here working with Mr. Beal. These lawyers have been around in this case for 5 years. What's going on that now we got a notice of appearance filed on day 7 of trial? If Your Honor wants to let her appear, whatever Your Honor wants. But it's improper at this point without at least a formal filing of a notice of appeal,
I
of
can
appearance.
do that during lunch if necessary. I would merely
Okay.
like to say.
This is just for a legal
to the
point.
court. I would
Okay.
merely like to apologize to the court for whispering loudly to my counsel, and I would like to apologize to my counsel. I should not have done that, and I wanted to advise the court that it is just very difficult.
I have
sitting
no question of that. I understand.
But
I understand.
misrepresentations and not being able to address them in real time and have the jury hear.
We're not going down the rabbit hole on this one, Mr. Wood. I appreciate that, Miss.
Wanted
Down the
to
rabbit hole. I don't know
apologize
what she's apologizing
the
for. I
court.
just want
There was a
to-
time when she was making comments that you got upset about because she was sitting at the table,
Making comments when?
Let's get that out.
commenting on the evidence. You called him out for it.
I haven't looked over and called anybody out.
All right.
Look at this. Look at this.
Yeah.
Look at the incredible.
Yep. I told you we're not going down that rabbit hole. I'll be back in 10. We're off the record and in recess.
Being allowed in
Thank
this
you, Mr.
court by the
Kavanaugh.
plaintiff's lawyers.
I mean, this has been repeated for weeks, so.
It is our job.
Let's go there.
We'll put one of them on their table when they walk out.
I'm afraid Kim's got notes somewhere.
On both of them?
I don't know.
Tell me what he said at the break.
I need
I
to
don't know.
check.
He didn't because he
That one
talks.
is marked.
Ten?
Or whenever y'all.
10 minutes. Oh.
Let me know whenever you-
I'm good.
I just went because I couldn't. I think this one's good. I think it's fine because I'm just gonna put that on me.
question. I was saying to Michael, he said, well, did we write on these? Here, take a picture of our passes.
We're using them once.
Oh, yeah, that was a little scary.
Do you guys work in the courthouse? Yeah, we're interns at the Court of Appeals under Judge Hawkins.
Oh, fun. What law school do you guys go to?
We're at Georgia State. I'm still.
Wow, you're ahead of the game. Yeah. It's exciting. Are you guys enjoying your time?
First day, today's our first day.
Oh,
It's very
well, that's fun that they let you go to trial on your first day.
Are you doing the are you doing the program through GLOF?
No.
Okay. We do GLOF, we do like this judicial interest.
Oh, okay.
Whew, that was, they did a great job.
He did.
Yeah. Here to watch this trial. He takes some batteries.
He's mom.
You, I can purchase it. Just to track it as long as you apply to your size and because there's so many.
Did I print this at lunch?
Now he's.
Who said to unlock it?
Yeah, at least like one of them, because like, when I come out, I have to walk all the way back around.
Somebody else. But it's fine.
It's hot.
Okay.
That's funny.
Yeah, that's fine. Yeah, I can talk it.
Since when can you have that? Used to be able to just pay more than one that you just like. No, it's legal. I guess I'll just like if I send her meetings. Oh, what's that? You missed it. How did you let him know? I didn't.
I'll go.
Yes.
Yeah, it's the same. That's a better. It's like extended. It's like his cousin's. This guy. And this was him. No external license there, because it's not that. It's pretty. I think they do it. My sister wants to become. She wants to do words, but she's specifically wants to the court illustrations.
I would.
It's really, I'm not. She really is. So I think she'll. Okay. So we're really. Considering. He said he wants to be a real estate. Oh, yeah.
Yeah, I think it's
So, yeah.
This is the order.
Oh.
All right, they're ready to go.
Call for common order.
Yeah, I know.
Ready? I see the. I'm following you. Yeah. I thought this was a great question.
I thought we did it pretty good.
Well, kind of, but it was like.
Okay.
I got my buddy watching the case, so she works through it. He's cool.
That's why we do this fun.
Yeah.
Yeah, it is. And I would never say that wrong, that kind of thing. I want
What do you want to say to Andy?
So you have another way to do it?
Doing a great job.
First question.
Yeah. It's already pre-marked this instead of seven dollars. So we're just going to exhibit 97. We have pre-marked from what?
These exhibits to the portion of his testimony.
No, this turn it over. Our stuff.
That's good.
You just tell me what page you go to. Ron?
All right, we're back on the record. Yes, sir.
First, I took the opportunity to speak with my assistant. And she is going to produce the exhibits. She thought the cover pages were sufficient. So we should have those tomorrow.
Excellent. Thank you for the update.
23 tax return. Your Honor, at this time, on behalf of the defendants, I move for a mistrial.
Deputy Scott, can you shut the door? Thank you.
There's been repeated incidents of plaintiff's counsel and their table laughing out loud in front of the jury at something I have said or done. It has no place in a court of law. It's happened more than twice that I can distinctly remember today. I believe it prejudices me and it is grounds for a mistrial, and I so move for a mistrial.
All right, predetermining whether this would even be timely, I think it would have and could have been or should have been raised at the time of the conducted issue. But even setting that aside, as to the point where that did happen, where I believe it was noticeable, I did immediately issue a curative instruction to the jury telling them to disregard that. And considering everything that has been presented to in the totality of this case so far, I don't think it rises to the level of necessitating a mistrial at this time. But I think both parties are on notice. It's been a recurring theme throughout this trial. It's a contentious trial, there's no doubt, and there are passions involved. But commenting outside of the question and answer format of testimony under oath is not how this is supposed to work. And so as best I can, I'm trying to keep us within those guardrails. And so at that point, I believe we can proceed. I suppose the motion is preserved for the record. Anything else before we bring back the jury to begin with the designation?
Not on behalf of the defendant.
All right, then feel free to go ahead and get situated however you are going to plan to do that. And let's bring in the jury, Deputy Scott.
Yeah, we're gonna read the questions.
Yeah.
Thank you, Deputy Scott. Please be seated, everyone. Defense may call the next witness or present their next piece of evidence.
I'm going to be reading as the attorney asking Mr. McMurtry questions, and Mr. Wood's going to be reading as Mr. McMurtry answering.
All right. So for the record and for the jury's information, the defense is presenting for their consideration additional testimony previously sworn to by Mr. Todd McMurtry. All right. So let's proceed.
All right. Let's begin reading at page 15, line 22, all the way to page, line 4, page 16.
You want to read the question at 17?
I can. Throughout your representation of Nick in 2019 and into the beginning of 2020, did Lynn routinely refer to the WGW folks as his partners, to clients, the court, or other attorneys?
I only recall that in the plead, in some of pleadings, I believe they were referenced as partners. Some of the initial complaints that were filed, maybe they were on that line. That's my recollection. He and I did not discuss that. You know, he didn't, when we spoke, he didn't say my partners, my partners. He just didn't discuss anything one way or the other about their status.
All right. Now to page 37. On 18.
When I said I couldn't get into Lynn's head, I was looking more in the July 2020 timeframe. You said you want Lynn didn't want you to approve the settlement. And I said, I don't know what Lynn wanted. We didn't discuss that. But with regard to your question on the
Sorry, it's through line 22.
I'm sorry.
All right.
I said, I don't know what Lynn wanted. We didn't discuss that.
All right. Now for the next part, page 63, lines 6 through 24.
You want to read the question?
I will. And so then exhibit 64, does this appear to be Lynn's email right back to you 30 minutes later?
Yes.
Okay, and he says, I am excited too. The hearing will work out. I have resolved dispute with former business partners. Today is a day for prayer for our nation. I love you. Did Lynn oftentimes say, I love you in his emails?
Yes, he did.
All right. And did you then contact him to ask him what he meant by resolving his dispute with his former business partners?
I don't believe that I did. I don't recall reaching out to him. I just recall being relieved that this was resolved and we could move on.
All right. Now to page 64, lines 15 through 25. Thank you. Let's turn over to exhibit 69 and 3146 Bates number. So it's the second page. In the middle of the second page, does that appear to be your email to Lynn on Tuesday, March 17th at 9 p.m. or 9:06 p.m.?
Yes.
All right. And you say, Lynn, I write to bring you up to date on the status of the CNN settlement. We were set for a hearing on Monday in Kenton District Court to appoint Julie Salmon as the conservator for Nick in the CNN settlement. Ron, there might be an error here, but
We're just at the top of page 65 now.
yeah, I want to check to make sure what I sent the court is consistent with this other list, but I can move forward and come back to it if you want, or
65, so on your designations, sure.
okay. Let's see. I'll move on for now. But if I find later on that I did designate lines 65 through 1.6, I want to reserve that right. I just don't want to waste the court's time digging through emails.
Okay, let's keep going.
Yeah. Okay, page 70, line 13 through page 72, line 11.
Question?
And we're looking at it, excuse me. Let me restart. And we're looking at exhibit 98 and 99. Are these indications of phone conversations you are going to have with Austin and Bird around July 15th and July 20th?
It looks like there was on Exhibit 98, there was a call scheduled. I think it was a Zoom call scheduled for July 15th at 4:15 PM.
And then the next exhibit 99 looks like another Zoom call the next day. Is that correct?
I'm not sure. I can't tell. It looks like an email exchange. I don't see are you talking about Exhibit 99?
No, 98. We just did 98. Page 71.
Page 72 is next.
There should be page 71. Yeah.
I don't have it. Step back. Okay. You said we just did 98. Yes,
I'm talking about 99.
I don't see where there's a call scheduled on this.
Okay, but you have several conversations with Austin and Bird during this time period. Is that correct?
I did.
And they were about Nicholas's consent to fee divisions. Is that correct?
Yes,
And did you understand from your conversations with them, well, you understood they were representing Lynn, right?
I knew that, yes.
And did you understand from your conversations that they did not want Nicholas's consent to a division of the fees in any way other than quantum merit because that was Lynn's desire?
They did not say that.
Did you have that understanding in your mind from your conversations with them?
When Austin and Bird spoke with me, there were, I believe, 2 calls, and they told me they sent the settlement agreement and told me that Nick would need to approve it. And then they discussed, that Nick would need to approve it. And they said that Lynn was in favor of Nick's approval of the settlement agreement. And then they spelled out what that looked like. And I would say that my best recollection of what they said is that Nick had some discretion with regard to his approval or non-approval of the settlement. So that information came from Austin and Bird.
Now, page 72, line 16 through page 73, line 2. On what would be some of the factors that they indicated that Nick could consider?
Well, I'll be honest, when they started to discuss that, I didn't want to be involved in the process. So I'm like, I'll make my own decision. You guys, I don't want there to be suggesting anything in particular to me. I did not want to be, A, I didn't want to be involved. B, I was pretty ticked off that this was happening. And C, I didn't want them advising me what I should do. So that's the way I approached my call with them, calls, plural.
Right. On page 73, lines 3 through 16. Thank you. And you believed at that time that the Salmons would control the allocation of fees between Lynn and WGW and that Quantum Merowith was required. Is that correct?
Well, I believe, is there an objection? I did not necessarily believe. I believe that Nick could have said, yes, I approve. So I didn't think that he had to engage in a Quantum Merowith discussion over the fee. So what Austin and Byrd told me is that Nick needed to make some decision about approval or not of the settlement.
Now, page 73, lines 18, line 18 through line 15 of page 74. So we saw exhibit 46 and 56. Your first letter to me in February of 2020 and your second email correspondence with me in March of 2020, in which you said we can escrow the fees the Salmons control and the Quantum Merowith is required. Do you remember those two?
I do.
Letters that you testified?
That's the end of my page. Okay. Answer yes.
Thank you. So are you saying that between February of 2020 and July of 2020, your position changed?
No, I don't think that my position changed. I think that I kind of stuck. Well, I see what you're saying. So whether it was settled, that would eliminate any conversation about the case. My position after Austin and Byrd said needs to improve the settlement. So then I felt that we were, kind of walking a tightrope as to what to do here. I didn't want to have that imposed upon Nick and was not happy that we're being put in this position to have to deal with with the situation. And then these are questions by Mr. Mr. Bill, aren't they?
Yes. Now, pardon. Page 79. Lines 22 through page 80, line 2.
By Mr. Bill?
Yes, I starts with my question. Yeah. Yes, do you think he was instrumental in getting the settlement?
At this time, I did, yes.
Did you think that he was important in the other cases as well?
At that time, I did, yes.
And that's in reference to Mr. Wood. Now we move to page 94. Line 3 through page 96, line 14.
This Mr. Bill?
Yes, side. Let's look over at Exhibit 175. Does that appear to be Nicholas Salmon's affidavit?
Yes.
Thank you. Let's look at paragraph 10 on page 3. The first sentence says, after consulting with Mr. McMurtry and receiving his independent advice. Do you believe that statement was correct?
Yes.
And so you provided your counsel to Nicholas Salmon regarding the issues he discusses here in the affidavit. And from attorney Mr. Gilfillan, I'm going to object to the extent it calls for communications subject to the attorney-client privilege and work product doctrine with Nick. I think the document speaks for itself. Mr. Beal, well, I'm not asking for any independent communications. You know, he makes a statement here that he received his independent advice, and I'm asking, did you provide independent advice to him? Mr. Gilfillan, you can answer that.
I did.
Thank you. Then we see over on paragraph 11, the second sentence, I made the decision to request documentation from them on my own after consulting with Mr. McMurtry and receiving his independent advice. Did I read that correctly?
Yes.
And do you believe that that was accurate also?
Yes.
Okay. So do you believe that your advice was independent at that time from Mr. Gilfillan? I'm going
Let's
to
just go to
object.
the answer because the objection's not insisted on.
Hold on.
So read the line 15, 16 again, if you don't mind, John.
Well, line 15, 16 was the question.
Let's read the question and I'll read the answer.
Okay. Okay, so do you believe that your advice was independent at that time?
I undertook my own investigation from the February timeframe through till that date. I thought arguably there was a legal argument under Kentucky law that they may be that they receive no fee. And there's a case involving an attorney named Barbara Boner and Stan Chesley that discusses this issue. And I also received the communication from Alston and Bird suggesting that Nick did need to provide some consent to the settlement agreement. And although I was greatly disappointed that Alston and Bird was telling me we were being pulled back into this thing, I do believe that my advice was independent.
Objection, Your Honor. I think they got to read in the objection too. It was part of the designation and it also explains why the answer is what it is. So just got to read in the objection. Mr. Exum can do
Can
it.
you give me the line numbers?
Page-
With Mr. Beal, exactly.
17 through 23.
Page 95.
That's Mr. Gilfillan's objection. It's not Mr. Beal's.
All right, to the extent,
Gilfillan was the
there's some
lawyer.
commentary here on lines 22 through 1 that I think is clarifying the extent of your question. I think that would be context. So, Mr. Exum, if you can just, on page 94, line 22 through 95, line 1, if you just want to read that, I think that's context, and then we can.
I can't hear you, Judge.
Sure. I think this is just part of Mr. Beal's objection, which clarifies the answer that then follows it. So it'd be 94, line 22. Do I have that?
Oh, we read that one already. I think it's
You're-
on page 95, line
You're talking about
17.
95. I'm sorry. I thought you were going back in time.
No, he did read that objection, I think.
I did.
So you wanted
Okay.
to pick back up on,
So no, this would be for Mr. Exum. Mr. Beal's clarifying the question that was asked. So I think you need to add 22 through 25.
17 through 22.
on page 95?
That's fine. Yeah. All right.
Is that your instructions?
Starting at 15 and read through to the
That's right. You
answer.
can read through this particular objection since there's
Okay.
things that are clarified.
I'll start over, line 15. Okay, so do you believe that your advice was independent at that time from Mr. Gilfillan. I'm going to object again to the extent you're getting into privileged communications with Nick. He just testified that the statement in the affidavit he believes to be correct. Mr. Beal, now I'm talking about his state of mind, nothing to do with Nick. Do you believe that you were independent in your advice at that time?
Your Honor, I don't think we need to reread it.
And then Mr. McMurtry.
I think you can, now that it's clarified, the context.
Mr. McMurtry. Answer. I undertook my own investigation from the February timeframe through till that date. I thought arguably there was a legal argument under Kentucky law that they receive no fee. And there's a case involving an attorney named Barbara Bonar and Stan Chesley that discusses this issue. And I also received the communications from Austin and Byrd suggesting that Nick did need to provide some consent to the settlement agreement. And although I was greatly disappointed that Austin and Byrd was telling me we were being pulled back into this thing, I do believe that my advice was independent.
Page 98, line 24 through line 11 on page 99. Did you have an opportunity to review note 8 to rule 1.0, rule 1.5E? Sorry.
Not in the July 2024 timeframe. I don't believe that the version of the rule that I reviewed in February of 2020 yet contained that provision. I think the rules did. I think my book, the book that I referred to for those things, didn't have that rule, did not have that number 8 comment. With regard to heading into July the 4th, 2020, no, I did not review that. I did not see this memo. I did not review that. I relied upon what Austin and Byrd told me was required under Georgia law.
Turning to page 100, line 19. Probably meant that to be line 20.
Your Honor, we may take one break so I can confer with Mr. Exum about something.
Is this about this designation?
Yeah, we may be able to omit some of this.
All right, Mr. Exum, why don't you approach?
Yeah.
Approach you.
No, you're conferring now. Mission accomplished.
I gotta get that stuff. Go with the microphones.
Okay, you can come on over here.
We step right here in the hallway.
Oh, how long do you need, Mr. Wood?
Probably less than 3 minutes.
Okay, we'll wait here, I guess.
Thank you. Thank you, Ryan.
Turning to page 141, line 1.
Your Honor, may we approach?
This is just about the designation?
Yes. I believe he just skipped a bunch of designations.
Yeah.
I did.
We're allowed to rely on their designations. They're offered for completion purposes. I mean, unless we're given an opportunity to go through them as well and decide.
Okay, I'll give you that opportunity unless there's one that you think is placing a particular question, not in its context. You can follow with me and let me know what designations you didn't add. Okay,
So what page you want to go to?
we'll follow it up when they're done.
Let's go to 141.
Okay.
Question by Mr. Beal. Were you still dealing with the CNN settlement when the WGW plaintiffs were no longer associated with LN Wood?
During the period of working to have the settlement agreement approved, I believe that they had left the firm.
Excuse me, that's a question by Mr. Reyes. I need to restart, sorry.
That's okay.
Question by Mr. Reyes. Were you still dealing with the CNN settlement when the WGW plaintiffs were no longer associated with LN Wood? Objection by Mr. Beal. Object to the form of the question on vagueness grounds. What do you mean by dealing with? So around. Question by Mr. Reyes. Do you understand the question, Mr. McMurtry?
I can answer the question. Around that time period, we had settled with CNN. I don't know the exact date that the settlement agreement was signed. We then moved to try to have it approved because Nick Salmon had not yet achieved the age of 18, so we needed court approval. And I was taking the lead on all of that. After Taylor Wilson was no longer involved, I took over what he was doing.
So it's fair to say that Wilson, Wade, and Grunberg were no longer involved in the case at that time.
During the period of time to have the settlement agreement approved, I believe they had left the firm.
And they were not involved.
Approved by the court. Approved by the court. I think it was signed and finalized, but I don't think we had the court approval to distribute the monies to a minor at that point.
And the case was still active. It had not been dismissed, correct?
I don't believe so.
Do you believe it was active?
We were trying to figure out how to properly dismiss the case. We were trying to figure out if we needed the federal court to also approve the settlement. Once the settlement had been approved, then certainly it would have required a dismissal of the case, but we had not made it that far. I do not believe in that March timeframe. But there will be something of record as to the exact date we submitted the settlement. It probably came later in July when they paid us.
Okay.
Dismissed the case. If I misspoke there, I think we probably dismissed the case after they paid the monies in July of 2020.
Very well. Question, Mr. Reyes. Very well. Did Lynn Wood have anything to do with the postponement of the conservatorship hearing?
No. The conservatorship hearing was postponed after I spoke with Doug, judge. Well, there was a hearing. We showed up. It was canceled at the last minute. I think we actually showed up. And then we were going to move to a different judge to petition to have a guardian appointed. And in that process, I spoke with the judge. To petition to have a guardian appointed. And in that process, I spoke with the judge to whom we were going to present the guardianship materials. And he said that he could not guarantee us that the settlement would remain confidential. So then we contacted the defendants and they agreed that they would rather delay and pay us later than risk the settlement becoming public. And Lynn had nothing to do with any of that process. That's it, John.
Well,
John. That's all.
all right.
All right, so turning to the plaintiffs, you can step down, Mr. Wood. Were there, I don't think I'm provided a list of the total designations that each part makes. I get your objections. I don't get the total list. So was there a certain designation you're saying should be considered contemporaneously?
Your Honor, they skipped a lot, and I've written them down and I compared them to our list. We really one second to look at them to see if we can go. Because I've got the list here, but I think we could streamline this and just see what was left out.
Okay, but at this time, you don't have anything identified that needs to be placed at all in context?
I know what they've taken out and what was not on our list, but whether or not that needs to come in for context purposes, I do not know at this point.
Okay, all right, then at this point, members of the jury, I want to, we can go to your lunch break, and so it's 12:25 now. Let me double check my math so we can do the 45 minutes. I think that puts us at 1:15 thereabouts. 1:15, we'll go with that. Please don't discuss the case or do any research.
Thank you, Judge.
But wait, Mr. Wood, still got housekeeping always,
Oh,
just to make sure things are streamlined going forward. Okay, so I'll just give you my understanding. Just because a party designates that they reserve the right to present it, I don't think that locks them into having to present all of it. But if you have a certain place or thing that needs to be placed in context contemporaneously, we've got that rule that's come up several times already. So if you've got something along those lines, we can go along with it. Otherwise, I think we keep moving forward. All right, so with that, when we're back at 1:15, defense is ready to proceed with Mr. Wood's testimony?
Yes, Your Honor.
Okay, and that'll proceed with question and answer conducted with Mr. Exum. Is there anything else we need to take up before we begin with that? On behalf of the plaintiffs,
Your Honor.
Mr. Wood, all right, have a great lunch. We'll see you at 1:15.
Are you sure you need it? Yeah, they must have changed.
You guys, I could read the program on lock if y'all just want that back and forth.
Is that okay?
Yeah.
That'd be awesome for us.
Yeah.
Thank you very much.
I'm gonna go back if I'm leaving a lot. Oh, okay.
We're still up on YouTube. That was the one. Partitions down on it and let it soak it up. All right. So. Yeah, you can let boy know.
Well, come to order. All right, good to see you, everybody.
I have one matter, Your Honor. Quick.
Yep, let's go on the record. Mr. Wood.
I've made the observation in the last couple of days, then when I was testifying in the role of Mr. McMurtry, it was very obvious. 6 to 7 to 8 jurors are either sleeping or they're paying no attention. I think I know why, but that's irrelevant. They're not allowed to do that. And Your Honor, I'm sure has observed it because you're looking right over there at them. Now, I'm not going to move for mistrial at this point. Continue as I'm going to have to. What I would ask is that the court instruct the jury that they have a responsibility and a duty to pay attention to the evidence. And maybe that'll get them awake for the afternoon.
All right, I agree, Mr. Wood. If you will assist me by bringing it to my attention, if you do see any that have closed their eyes for extended periods of time.
I'd be jumping up and down all the time. You don't want me to do that.
Well, it may only take one warning to tell them to come to attention. All right. Anything else, Mr. Wood?
Yeah, that's all right.
Okay. Anything on behalf of the plaintiffs?
Nothing wrong.
In that case, why don't we go ahead and Mr. Wood, you can make your way on down to the witness stand and as we bring in the jury. Go ahead, Deputy Scott.
Sorry, did I just vacuum?
That's fine.
Can we get the screen turned off again?
We can make that happen. You want to grab it remote? Yeah, there's the remote's right there in the corner. We got.
Yes, I would just deposition excerpts. No.
Thank you.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, welcome back. Thank you for being ready to go. At this time, defense may proceed to call us next witness.
Your Honor, briefly, I just wanted to let the court know, thank you so much for giving us the opportunity to look at the deposition excerpts at lunch. We have nothing further to add on that point so that the defense can go ahead and keep this moving along. We appreciate it.
All right, you may call your next witness, Mr. Exum.
Yes, Your Honor. The defense calls defendant Ellen Wood.
I so affirm.
All right, you can have a seat.
My full name is Lucian Lincoln Wood, Jr. Lucian is Lucian, Lincoln, Lincoln, Wood, Wood, Jr. My adult life, and even from younger, when I was young, I've always gone by Lynn, Lin, short for Lincoln. So it's Lynn Wood.
Mr. Wood, thank you for being here. I'm going to ask you a few questions. Is that all right?
Absolutely. Ask me whatever you want to.
So we're going to go back to the beginning for just a little bit. So I want the jury to kind of understand a little bit about you. Let's start where you were born and tell us a little bit about your upbringing, please, sir.
I was born on October the 19th of 1952 in Raleigh, Wake County, North Carolina. I was born at Rex Hospital. My father was transferred. We lived in Raleigh. My father was transferred on his job to Macon, Georgia, when I was 3 years of age. And so we moved to Macon, and I grew up in Macon, attending grammar school, high school, college at Mercer, law school at Mercer in Macon. And then I practiced law in Macon for just about 3 years. And then I moved to Atlanta. And I became a resident of Atlanta. And I remained a resident of Atlanta until February of 2021. I had purchased some property in South Carolina in April of 2020, which I visited, and then made the decision in February of 2020 to move my residence from Georgia to South Carolina. And I remain a resident of South Carolina at the present time. And I'm, how old? I'll be 73 years old on October the 19th of this year.
But going back to Macon, you decided to become a, sorry, excuse me, I'll rephrase it. What made you decide to become a lawyer?
Well, I can pinpoint on a couple of incidents, but they don't really explain it completely. I mentioned in my opening statement that at age 16, I came home and found my mother beaten to death. My father went to jail, and I was on my own. I was familiar with the family background of domestic violence. I knew that could have been my mother picking up a knife and stabbing him as opposed to what he did to her. And I knew he had a lawyer that had been given to him and by where he worked, and I went to the first hearing, and the lawyer was totally incompetent. My father was charged with murder. I knew he did not commit murder. I felt like it was involuntary manslaughter. And so I went out and talked to some men and managed to raise $5,000, which Manley Brown and Hank O'Neill and Charlie Adams told me they would accept to represent my father. They were the best lawyers in the Southeast and usually charged a lot more than that, but I think they did that for me and my sister as a way to help us. Ultimately, my father pled guilty 5 years later to involuntary manslaughter. So everybody thought, well, Lynn, you're going to be a lawyer because of what I had seen in terms of the legal system with my father, but that's not really accurate. When I was 14, I preached a sermon at Shirlington Baptist Church. The youth night, they allowed you to pick your scripture and write your sermon. And I preached on Ephesians 6, we do not fight flesh and blood. And the sermon was well received. Almost the entire congregation came down and rededicated their life to God. And I was standing at the doorway when they were leaving with the pastor, and everybody said, son, you've been called by God to be a preacher. And I said, well, it's too late. I've already decided I'm going to be a lawyer. And that was 2 years before my mother died, and so it was just something that I felt like inside that I wanted to do. I wanted to represent people and help them. And then when I saw how much help and comfort the lawyers provided to me during the time period my father was, before he pled guilty, I remember thinking I'd like to be able to have someone sit in my office and feel secure and comfortable that they were in good hands the same way I felt when I was in the offices of Manley Brown, Hank O'Neill, and Charlie Adams. So the incident with respect to my father and my involvement with lawyers reaffirmed what I had decided at age 14, and that is to be a lawyer.
And you Did you say you went to Mercer for,
I did, and I was at the end of my 11th grade year when my mother died, and so we had relatives, my mother did, in North Carolina, and they wanted us to come live there. My sister was getting ready to finish up her 12th grade year, and I didn't want to leave my school. And so I arranged to live with a family in Macon so that I could stay in Macon and finish my high school at Mark Smith High School. I did that. My sister had gotten a scholarship at the end of her senior year. That would have been a couple of months after my mother died. And she went to Mercer. And Mercer was very good to her. They gave her full scholarship, room and board. And they offered the same thing to me. And so I accepted it, and I went to Mercer under a full scholarship with room and board. They were even so kind that during the Christmas break, when everybody gone home, they let me stay in the dorm for the Christmas holiday because I didn't have anywhere else to go.
so.
And then I went to Mercer Law School. I was a good student in college, but I wasn't a great student. I played a little bit too much. But I got serious my senior year, knowing I had to focus on law school. And I chose Mercer because they had been good to me before. It's a small school, 90-some lawyers at the time, and the students in their freshman class. And so they gave me a partial scholarship. But through the time period of my 11th grade, and I worked. I started off around age 12. I was selling TV guides. And I was selling men's clothing at the time my mother died. And so I had worked all of my life in a variety of jobs. I worked in a hospital as an orderly. I worked as a construction worker. Sold men's clothes. So I always had to work, but I had no choice but when I was in college. And then in law school, I was able to clerk during the summers, but I was able to have enough money in scholarship, and I borrowed some money, that I didn't have to work during the school year. So I lived in Macon and had an apartment for 3 years until I graduated from law school in June of 1977. At the time, you could take the state bar during your winter quarter.
Yeah. Well, this is how he wants to use his not indefinite time. But I will ask Mr. Exum just if we could break it up with a question here or there to keep us on a certain topic.
Yeah, I was just going to make the point that I went straight from law school to work because I was allowed to take the state bar during my senior year, so that when I graduated, I found out the next day that I'd passed the bar. And so I went to work as a lawyer with the law firm of Jones Court at the time, Jones Court, Miller and Benton.
And that was, what year was that?
That was in June of 1977.
Got it. Is that firm still active?
It is. The firm name now is Jones, Cork, and Miller. It was the largest firm in Georgia at the time outside of Atlanta. And I think we had 22 or 3 lawyers. So law firms have grown in a massive way since I started practicing law in 1977. The largest law firms now have 1,000, 2,000 people.
Did you have any interesting family life developments at that point?
Well, I mean, I got married my sophomore year my second year in law school. And in fact, I married the daughter of the senior partner of Jones Court, Miller and Benton. And then we later divorced. We dated 4.5 years. We married 5. We dated 5.5 years. We were married 4.5 years. So we divorced, and it was at that time that I moved away from Macon. and moved to Atlanta and went to work for a law firm called Freeman and Hawkins, now called Hawkins and Parnell. And I worked with Hawkins, Freeman and Hawkins for just about 3 years. And then I thought that I could do it on my own. And so I started my own law firm with another young man that worked at Freeman and Hawkins, Jack Moore, and the firm was Wood and Moore. The two of us, we were in the Carnegie Building here in Atlanta, and everybody kind of laughed at us. These two young lawyers with no experience, they're gonna fall on their faces. We struggled for a couple of years, and then we were successful. Not massively, but we were beginning to take on cases, win cases, and the firm grew to another lawyer joining at Wood, Moore, and Grant. Jack Moore decided he didn't want to practice law anymore, so he withdrew, and it was Wood and Grant. And I practiced law with Wayne Grant until September of 1997. And he started his own firm, Wayne Grant PC. I started my own firm, L. Lynn Wood PC. And for a period of time, we shared space and we worked together and we divided fees on a case-by-case basis if I wanted him to work on one. And then he went his way in May of I was after the Ramsey case, so it would have been May of 2000. And so from May of 2000 on, starting actually in September of 97, I practiced law under the name of L. Lynn Wood PC. And I continued to do that for a number of years until I finally was asked to join the law firm of Powell Goldstein here in Atlanta.
And that would have been what year?
It would have been in 2006. And it was at Powell Goldstein that I met Nicole Wade and a number of other people, a man named Rick Miller. I've learned a lot about Powell Goldstein since I was there. Powell Goldstein merged with Brian Cave, a national international firm, and all of a sudden Powell Goldstein went from about 150 lawyers to being Brian Cave, which was about upwards of 1,200 with offices around the world. And I did not like that type of practice. And they started restricting what I could and couldn't do. And I was going to leave, and then Rick Miller got me involved with two people named Alon Vayner and Daniel Barbier in a lawsuit against DaVita. DaVita is the second largest owner and operator of dialysis clinics in America. Brian Cave didn't want to take the case. The lawyer that had brought it to Rick, the clients insisted to go forward. The government had not intervened. It was a Ketam case. And if you take a Ketam whistleblower case to the government owns the case. They're the client. And if the government doesn't intervene and handle the case, most people go away because they're too expensive and you don't have a real good chance if the government doesn't agree with you since it's their money. Well, the government didn't intervene after 6 years, and the clients insisted to go forward. There were two immigrant citizens now, wonderful men. And so they basically got me to do it because I was the trial lawyer and I was willing to do it. I thought the case was valuable. I thought they were good men and they had been victimized, as had the taxpayers, by DaVita, the pharmaceutical industry, with the Department of Justice involved, ripping off taxpayers for billions of dollars in wasted pharmaceuticals that were being reimbursed illegally by the United States government. And that case led to me leaving Brian Cave, and I then had to set up my own firm. I kept L. Lynn Wood PC because I was still receiving yearly fees from a case I handled against Kobe Bryant. And so I started a firm, Wood, Hernacki, and Evans. And that was to reestablish a firm. I was tired of running a law firm, but I went out and did it again.
What year was that?
That I left Brian Cave in 2011, and that's when I did it for the DeVita case. And I took on two partners. We had a partnership agreement in writing. I had 60% of net profits. Stacey Evans had 20. Catherine Hernacki had 20. And Stacey was going to work almost exclusively with me on the DeVita case. Catherine had said she had her own practice and could generate money from that in terms of a plaintiff's practice, and it didn't work out. She did not generate much business dollar-wise. I didn't agree with decisions that were being made at the firm. It was a 2-to-1 vote usually, Catherine and Stacey against me. And so I said, this isn't working. And so I dissolved that law firm, a partnership in writing, and I went back to L. Lynn Wood. Catherine Hernacki left and went to her own firm, Catherine Hernacki LLC, I think. Stacey Evans started her own firm, S.G. Evans Law. But because she was working with me on the DeVita case, and I had promised her in agreement a significant percentage, 20%, she stayed in the office where I worked, L. Lynn Wood, and she shared space with me. She paid her percentage of the overhead. She could do whatever she wanted to do, but primarily I think she was dedicated to working on DeVita. So we worked together, two independent law firms, and ultimately we were successful in the recovery. We recovered a $450 million result from the government. From DeVita. I thought it was worth 3 times that, but the government could have intervened and settled it for less. So we got a big result. I was fighting 3 large law firms, King and Spalding, McDermott, Will, and the law firm of Emmett J. Bondurant. You may have heard Mr. Bill mention Bondurant firm yesterday. And in the course of that litigation, I proved that people in the Bondurant firm, lawyers, had suborned perjury, tampered with witnesses, and hidden evidence.
All right, Mr. Wood, we're going to get back on track with a question and answer format. So, Mr.
At any rate,
No, Mr. Wood, we're going to get back with the question.
This is the end of DeVita. The DeVita case, although it resulted in $450 million plus some attorney's fees to $492, the government took all of that money with the exception of awarding the relators, the plaintiffs, 28%. And so the lawyers, Marlon Wilbanks and I, and Rick Miller, who had gotten his wife involved, we split a percentage of the attorney's fees based on what the clients recovered. It was not based on what we recovered for the government. That makes sense. I wish I'd gotten 40% of $450 million, but it was not anything close to that. I worked hard enough to get it, I'll tell you that.
Understood. So, what year did you say you started Wood, Hernacki, and Evans?
It would have been in 2011 when I left Brian Cave and started Wood, Hernacki, and Evans to handle the DeVita case.
And that firm was active for how long?
My best recollection is that firm dissolved in 2014. I know that it dissolved prior to the settlement of DeVita because I had agreed to give Catherine Hernacki a percentage of the DeVita recovery that I made, and I gave it to her even though she hadn't worked there for probably a year and didn't work on the case much when she was there. But that was the deal I made. I kept my deals, always have.
So you met Plaintiff Wade at Brian Cave. When did you around this time period, or let me ask it this way. At what point did the other plaintiffs come into your life?
So I met Nicole at Powell Goldstein. I think she's testified about it. I've testified about it, or at least talked about it, and I'll testify about it. Before Powell Goldstein voted to have me be a partner, they knew they were going to vote me in. They told me that. But they were about to lose a big case in terms of a client, SunTrust Bank. SunTrust Bank was unhappy with a lawyer named John Marshall who wanted to settle the case, and SunTrust did not want to settle it.
Objection, Your Honor.
And they,
On grounds.
It's not responsive to the question. It's not relevant, and it's getting into all kinds of hearsay, and
So a lot of,
we'll see how it
there's a lot
ties.
of extra details. The question I asked is how he met each of the plaintiffs.
so I
that's what we're
worked,
focusing on.
Nicole Wade was working with John Marshall on that case, and when they pulled him off, and SunTrust Bank met with me and said, we're fine with Linwood being our lead counsel. Nicole was the person that started sending me, good gosh, I got so much stuff from her. She was going to bring me up to speed.
Well, let me ask you,
And so we began to work together, and we had a very successful result in that case. I had said publicly that we weren't going to pay him one thin dime, and we ended up not paying him one thin dime because he didn't deserve it, the plaintiffs in that case. So I met Nicole during the time period that we had Wood, Hernacki, and Evans. And I believe it was probably around 2013, 2014, Catherine and Stacy said they needed an associate. And so I said, fine, find someone, let's see if we can hire them. And so they did the interviews. They recommended Jonathan Grunberg. And so Jonathan was hired as an associate initially at Wood, Hernacki, and Evans. And that's how I met him. When Wood, Hernacki, and Evans broke up, Catherine did not want to pay for an associate. Stacy did not want to pay for an associate. So Jonathan, who I think at the time was probably making, I think, close to $90,000 a year, he was out of a job unless I hired him. And I didn't want to see that happen to him, so I offered him a job to work as my full-time associate to pay him $90,000 a year, which earlier had been paid to him a third, 60-20-20. So that's how I met Jonathan. With respect to Taylor, I had an associate named David Ehrlich and Jonathan Grunberg. And I believe it was in September of 2015 that Jonathan suffered a serious fall climbing a rock climbing facility, fell 45 feet, shattered his feet, shattered his legs. It's a miracle of God that he lived. And so I knew he was going to be laid up for a long time if he lived. He had a number of surgeries. David Ehrlich told me that he was going to leave and go to work for Brian Cave. More money. And so I put an ad in the Fulton Daily Report for an associate. And literally the Sunday before that ad hit, David Ehrlich asked me if I would meet with a friend of his, Taylor Wilson. Taylor wanted to discuss an issue about a fee that he had on a case he had brought to his firm in Marietta where he had worked for 1 year as an associate. I talked to him on the phone. I did not think that the firm was treating him fairly. I told him that. And I finally ended the conversation by saying, I don't want your case. It was a class action case against DirecTV. I said, but I would like to talk with you about maybe coming to work for me. We met the next day and I hired him as an associate. He was making $45,000 a year at his firm in Marietta. And I started him off at a salary of $75,000 a year, which I thought was more in line with what a young lawyer ought to be making if you're working in downtown Atlanta. It wasn't as much as the new big firms were paying, but I thought it was a fair amount of money for a young lawyer to get in a small firm.
And shift your attention to this. What type of law were you primarily practicing when Taylor
So
came on?
briefly, my law career, when I first started in Macon for 3 years, I was not in corporate. I was a trial lawyer, and I probably tried 25 cases in my first 3 years as a lawyer to a jury verdict. Somebody said, we got a client that has a client, his daughter, and goes to municipal court. Somebody needs to go in there and try that little case for him. I go. I was always anxious to get in the courtroom. And so I did a variety of cases. And then when I went with Freeman and Hawkins, likewise, I tried a number of cases, and they were of a variety because Freeman and Hawkins represented Travelers Insurance Company. So I tried a lot of different types of cases there. And then Paul started doing plaintiffs' medical malpractice. And I'd carry his briefcase, and he'd always look at me because he'd had heart trouble. And he said, young lawyer, if I drop dead in the courtroom in the opening statement, you'd be ready to knock me off to the side and say, ready for the plaintiff. And so Paul taught me a lot. I've always considered him a mentor. Recently, he passed away a few years ago. So after spending time with Paul and at Freeman Hawkins, I thought, this is kind of crazy. I'm making $35,000 a year, working hard. And I think I could do as good or better than they're doing, and I could handle the cases myself. Instead of getting $35,000 a year, I could go out and win a case for $300,000 and make $120,000. And so I left, started my own firm. And I started off doing a variety of civil litigation, but I focused on small medical malpractice cases. The cases that the big boys and girls were not handling. They wanted the $1 million plus case. I thought there was a niche in the $100,000 to $200,000 value case if it was good. And that's where I started off in terms of finding a niche as a plaintiff's lawyer doing medical malpractice. And the people that defended those cases, they didn't believe I was any good. And so almost all of my first malpractice cases, they didn't offer me a dime, and they said, go try it. So I did, and I beat them. And then I beat them again, then I beat them again, then I beat them again in court. And so finally, I started getting larger cases in value. And the doctors and the hospitals started settling with me because they knew I could go take them to court and beat them. By the time 1996 rolled around, I was getting tired of doing medical malpractice. You take 10 neurosurgeons depositions, you only want to take 11, it gets boring.
Objection, Your Honor.
And that's when
Yeah, let's break it up with a question. Mr. Exum?
and you
All right.
asked me about Richard Jewell.
Yeah, I
I'm
was
getting there.
going to get to that.
So
Your
in
Honor.
1996, after the Centennial Olympic Park bombing, a lawyer that I had worked with years back at Freeman and Hawkins, Watson Bryan, asked me if I would be willing to talk with and meet with and represent Richard Jewell, the man who was falsely accused of bombing the park. I agreed to meet with Richard, and I took on his representation. And the first part of it was more in the court of public opinion because everybody thought Richard was guilty. The FBI was threatening to charge him. They never did. And so I launched what I call the court of public opinion strategy. And ultimately, the FBI did not charge him and exonerated him. And then I started suing defamation cases. Sued Tom Brokaw. I made a claim against Tom Brokaw and NBC, the Atlanta Journal and Constitution, Cox Enterprises, sued CNN. And that was a new area for me. And I enjoyed it. And so I became, I guess people would say they recognized me as being a defamation expert for plaintiffs. And I continued to do that up until everything fell apart and I could no longer practice law in 2021. early 2021. So that's why I was involved in Nicholas Sandman and other cases against CNN. I was still doing primarily libel and First Amendment cases, but I had also the experience in the DeVita case of 5 years with another case that they brought to me involving fraud. I had developed an expertise in fraud. I knew about fraud cases.
So, but you would say it was the Richard Jewell case. Is that where you really began to develop what some would call a high profile?
I never sought the publicity. I never sought the recognition. But I also know that I was considered to be perhaps the number one defamation lawyer, First Amendment lawyer for the plaintiff in the United States, and some would say in the world. And it felt kind of good, but it didn't put a dime in my pocket. I still had to go out and work. And I did. I worked hard all my life.
And you had a number of high profile clients, if I understand correctly.
I did. After Richard Jewell, I was hired in September of 1990.
Yeah, I think we can lay those out in summary fashion, but going into the nuances and the facts of every individual case at this point, I think is cumulative and strange relevance. So you can summarize, but we don't need all the minute details. You can proceed, Mr. Exum.
So to answer his question, I was hired by John and Patsy Ramsey, the parents of John Benet Ramsey, in September of 1998 to represent their son Burke in defamation cases. After that representation, which I was involved in for 20 years, I represented them. I represented Richard Jewell for 16 years, 5 years after his death. I was then later retained by individuals such as Gary Condit, the former congressman from California, in connection with the Chandra Levy case. I was retained by Herman Cain. In fact, I was on the other side of Mr. Bill's now deceased partner. I represented Herman Cain. I represented Natalie Holloway, Beth Holloway, the mother of Natalie Holloway, who disappeared in Aruba, and a number of others of which I was blessed to represent them. They were high-profile cases, and God blessed me with success. He gave me a lot of talents.
Indeed. Oh, excuse me. So coming back to the present time, when the plaintiffs joined forces with you in the various times that they did, you said, I believe earlier, that it was primarily defamation law.
So that's what I was primarily doing when Taylor joined the firm. Nicole was being, well, she had gone from equity partner to transition partner to non-equity partner, and she told me that she was not happy at Brian Cave.
When there's an objection, you have to stop testifying. I'm sorry, what?
Cumulative. It's not
I
relevant.
haven't testified
Three
before.
times before.
I think we have through other witnesses. We haven't done it through his testimony, and so he can touch on it. So you can proceed.
So I talked with Nicole, and she said she was going to start her own law firm and leave Brian Cave. And I said, well, I've got an office here with empty offices. You don't need to go hire secretaries and pay for copying machines and postage meters, and just come over here and you can work out of my office and you don't have to pay any of the overhead. You just have to give me 20% of whatever you make while you work here. And so we entered into an agreement where Nicole was a non-equity partner. She was not in my firm, but she was a non-equity, non-ownership partner. And she had committed that she would bring a book of business of $500,000 a year. I suspect she never brought in $50,000 a year. But I stayed with her until the time came that I wanted to, in 2018, I had made it clear to everybody that I was going to leave and go out on my own, continue to practice law, but I had some other business interest. And I was going to set up my own small office. And they knew that. I had not said I was going to retire. I didn't make that decision until late 2019 when I began to talk about it. So before I actually left, CBS got in trouble with Burke Ramsey, and so I took on the Burke Ramsey case to sue them. And so I stayed in the same practice, and I allowed Jonathan, Nicole, and Taylor to work with me on that case, even though I'd been representing the Ramseys for 16 years. And we had a very successful result. And I paid them a lot of money. Not based on the hours they worked, but based on my generosity and to try to help them.
So I'm going to direct
And then when that case,
Please listen to your counsel, Mr. Wood.
go ahead, John.
So with respect to Ramsey, how is the fee schedule structured in that case?
I asked him to work with me and we agreed on that case. We did things on a case-by-case basis. And we got a juror, it might be nodding off here, Judge. I'm sorry. So I agreed to do things.
Juror 43. Need you to stay with us, ma'am. All right.
So when I asked him to help me, as we always did, we would make an agreement on how they would be paid on a case-by-case basis. The amount of the settlement with CBS was confidential, but I can tell you that I took 50% of the fee and I divided the other 50% up with Jonathan, Taylor, and Nicole, and they each made, and there was another lawyer in Detroit that had to give him a percentage too, but they each made $750,000 that was paid to them in January of 2019.
And with that, can I direct your attention to Defense Exhibit 64 being the big binder, big defense binder? Plaintiffs may have already introduced an unredacted version of this, but it's done yet, Bruce. Oops.
This thing keeps telling me I'm muted or not muted. I don't know what I'm supposed to do.
You can just press it. It says stay muted.
Stay muted? Okay. All right.
So that's
This is Exhibit 64.
D64.
That's a copy with redactions on amounts of the settlement statement in the Ramsey case.
And is your name and as well as the three plaintiffs' names on that redaction?
Well,
Not the redaction.
I think the first name redacted was the lawyer in Detroit.
Right.
But this is the way I did business. When I dispersed the money, I had the client state that they've accepted the above disbursement, acknowledging the same to be true and correct, and they gave me the authority to receive the settlement funds into an escrow account and make the disbursements from that account as set forth above. And this time, this was January of 2019. I did not know about Rule 1.5, but as a matter of practice, I always informed my clients about what lawyer was getting what. And I did it at the time of the disbursement and got them to agree to it and authorize it. And I didn't know anything about Rule 1.5. I just knew that the clients control the case, they control the fee, and I felt it was an ethical obligation to tell the client how the fee was being divided and give them a chance to object if they wanted to.
And by this time, plaintiffs all had their own DCs.
So in 2018, when I Jonathan was an associate, Taylor was an associate, Nicole was a non-equity partner. And I decided in 2018, when I was thinking about leaving and starting my own little one-man office, and then the Ramsey case fired up, I agreed to stay there, but I was not willing to do it under the arrangement we had. Jonathan and Taylor didn't want to be called associates anymore, and I understood that. You go out and advertise yourself as an associate, well, nobody's going to give you business. You'll have a better chance to get business if you say, I'm a partner, which reflects some level of accomplishment. So the way it was set up in 2018 was that Jonathan would no longer be an associate, nor would Taylor, that Nicole would no longer be a non-equity partner, but that we would agree to share office space. They'd pay their share, I'd pay mine, 25% each. That I would continue to get them to work on cases for me at my discretion, and that we would agree on how to divide up the fee on those cases on a case-by-case basis. There was no set formula.
And
that's when they set up, I think Nicole already had, back in 2015 or 16, when she joined 2016, she set up her own PC, her own professional corporation. And so I told Jonathan, the way that's going to work and the way it's worked for me in the past is you'll need to set up your own professional corporation. They did. Taylor Wilson LLC, Jonathan Grunberg LLC. I think they also set up one that was Grunberg and Wilson LLC, because I made the payments to that entity, not to them individually in their PCs. And so everybody had their own PC, and we worked together in an office sharing arrangement.
Objection, Your Honor.
We had-
Just the narrative.
Yep, we need to break it up with a question.
All right.
Mr. Exum.
yes, I have a few. If I can recover my train of thought, excuse me. So you all shared office space and worked on cases on a case-by-case basis. And if I'm also correct, was this at a point in your career, and I know we've jumped around a little bit to about 2018, but was this a point in your career where you were looking to retire?
No, I was looking to split off and have my own office with an assistant to work on my own matters, which included certain business interests that I had gotten involved in that I thought might flourish. Didn't turn out that way, but nonetheless, then Steve Wynn hired me, and his representation was hourly. And so I saw an opportunity to do work for Steve on a number of cases where the plaintiffs could get paid hourly. I think I gave them 75% of whatever I billed Wynn for their time. And then I obviously got a lion's share of what I did for Wynn with my time. And so I stayed in the setup of L. Linwood PC because of the Wynn case. And as it turned out, to wrap up to deal with the Ramsey case. And then it was shortly after the Ramsey case was actually settled that I was hired, I believe, in January of 2019 to represent Nicholas Sandman. And so it was not until the fall of 2019 when I began to think I'd had enough and that I was going to semi-retire. And I was going to work on the Sandman cases, but I really wasn't going to look for new business. If I had something brought to me, I could always consider referring it to Taylor, Jonathan, or Nicole. I never reached that point.
So
at the time that the Sandman representation was,
Objection,
when I was engaged.
He was trying to ask a question. You listen to the question that's asked.
sorry to cut you off, Mr. Wood. Did you mention to plaintiffs nonetheless at this time that with the development of their law firms, they needed to be quote unquote fending more for themselves?
Well, yes, that's what I think's been referred to as the happy camper memo, but if you look at it, it was the unhappy camper memo. I had received an agreement from DeVita where for 5 years they would pay me $500,000 a year not to sue them, but to consult with them. And I did once a year for 5 years. And so I felt like that Jonathan Taylor and Nicole were essentially living off of what I had earned in DeVita because they weren't generating any real income into the firm of L. Lynn Wood. Taylor had brought in the direct TV class action case. I made the agreement with him that he could take 80% of it. I'd take 20. We did it on a case by case basis.
And let me
So I
stop you.
reached I'm sorry.
Were these case by case bases, did you always communicate the fee splits by email or in writing?
I don't know of any exception, but I always entered into an agreement to split the fee and I confirmed it in writing, usually by email. That's where you might have seen one called the compensation committee has met. It's unanimous. So I always confirmed it. But when the Salmon case came in, it was fast and furious. And we did not sit down and have any agreement on how that fee would be divided. That was the only case where we had not confirmed an agreement, and then it settled so quickly, there was no agreement. So I could have given them quantum merit, which is give me your time, get a fair hourly fee for the time you spent, so you get paid fairly. But I wanted to do more, but then things went south and it became a dispute that we ultimately resolved on March the 17th of 2020.
And we're going to get to that, but let's talk a little bit about the structure of Ellen Wood PC. Was there, first of all, who are the owners and members of Ellen Wood PC?
L. Lynn Wood PC has always been L. Lynn Wood. Nobody has ever had an ownership interest in L. Lynn Wood PC except me. Nobody has the right to look at the books of L. Lynn Wood PC except me and the people that I hire to do my accounting or my administrative work. It was solely my professional corporation. That never changed. Even when I was with Wood, Hernacki, and Evans, my role in that firm as a partner was through L. Lynn Wood PC.
Your Honor, with that, I'd like to tender into evidence Exhibit 105. I apologize, but I sent it via email. I thought I'd had it in my list of exhibits. I'm gonna have to show it to you electronically, Lynn.
Okay.
All right. Plaintiffs have a copy of that exhibit?
I emailed it to them.
Okay. Is this on, and it was included in the pretrial order?
Well, it's not a surprise, Your Honor. We included it in our summary judgment motion over a year ago, and I meant to include it in the exhibit list.
Can I see it?
We're going to let the plaintiffs take a look at it first. Well, you can show it to him, but before you ask any other questions, I'm going to need to hear if there's an objection from the plaintiff.
It was Exhibit 1 in the summary judgment motion filed on May 31st.
We can, when everyone's had a chance to look at it, we can approach and I'll hear you any other issues.
So tell me this. I know.
My time counted. Add a little bit in for me, Judge.
All right.
We object, Your Honor.
Okay, why don't we approach?
objection. I sit here and then I just scan my attention. At all. I can just love it.
So it's relevant because
Anywhere. Because it shows on their show. It shows.
Oh, yeah. It's just on monotone. It's just on monotone.
Also, I believe Tony Grunberg referenced this the other day, and it's not. I'm trying to tease out, like, not tease out, but sort of illustrate firm partnerships, what they would look like. But you're right, this is. It's got three names. And they. You don't have three names.
Yeah, so it's just basically saying he's part of this firm previously, and so that makes it more likely that's how this one will.
Well, actually, in a way, it's, so Ellen, DC is the only one. This firm, this agreement is operating. Shows three members of that firm, it shows the percentage breakdown uniform.
Mhm.
No matter what the firm is.
So it's an example of a different arrangement.
Yeah, that's what he had in his past. Illustrate the nature of partnership. Intending to be multiple partners that are similar.
I mean, it's an example of one, but to say that this is definitively held in partnership agreements, it seems bridge too far.
Well, it's as the issue of also works to us. It's
You have a laser cutter.
I don't have a laser cutter.
Yeah, just a printer.
Yeah. Why are you trying to get some laser to cut?
I was trying to get some stuff I wanted to cut. I was gonna buy one, but yeah, I should have.
Yeah.
Mr. Bill's point was, yeah, I think that would be an improper. Yeah, I mean, that's been a recurring kind of thing. All right, but yeah, I'll let it in, but the questions need to be confined, okay? All right. All right, so, defense is tendering, what was the exhibit number?
105.
I'm familiar with it.
All right,
No, Your Honor, they're not tendering it. They're,
then are you,
he's gonna get them to testify.
okay,
About.
all right, he's gonna be referring to questions about
Referring to.
105, okay.
I thought you just rolled that. I'm confused.
Well, I'm unclear what it is that you're doing here, Mr. Hazen. Are we tendering it?
Well, I thought we were, but
I'll identify it first.
I'll go with Your Honor's instructions. I really want to ask some questions. I just want to make sure I can ask the questions I want to ask.
Okay, why don't we just start with the questions and then we can decide whether you still want to tender it at that point, okay?
Yeah.
All right, so feel free to proceed.
All right. So, Mr. Wood, on page 1.
I see it. I know
Okay.
what it is.
So,
It's the written partnership agreement between Wood, Hernacki, and Evans LLC. We were owners,
Objection, Your Honor.
partners, and we had a written agreement. That's what it is, plain and simple.
Okay, so it lists all three members of it in the
It
agreement.
says what it says, but it was the operating agreement, the partnership agreement that we entered into because we were all equity partners. We were owners.
All right. And the members,
It was Wood, Hernacki, and Evans.
and that's the Hernacki,
PCs. It was actually their PCs.
all right, the Hernacki Law Firm LLC and
Yes.
Stacy Guy from Evans LLC.
Yeah, it's all on there.
And was there a uniform percentage profits breakdown?
It's all in there, and it shows you, I believe it was 60, 20, 20.
We're not, we'll withdraw our objection.
All right.
Need to Put it in.
All right, defense 105 is admitted. You can proceed.
Thank you. Thank you, Your Honor. Okay.
What number is it, Johnny?
It was 105. I sent it by email.
Okay. So we have no objection.
Thank you. So how are things with plaintiffs, generally speaking? How was your working relationship? How would you describe it in general terms for, let's say, up until 2019?
Nicole and I had a good working relationship. There were periods of time where Nicole was not in the office. She traveled a lot. I mean, sometimes she just didn't work in the office, but we had a good working relationship when she was there. Taylor and I had an excellent working relationship, and we spent we took a lot of days off to go play golf. I'm not a very good golfer, but I like to be outside. Taylor's a pretty good golfer.
How often would y'all play golf?
I couldn't even begin to tell you, and I haven't played in 5 years, but I used to play back in the day for maybe a 3 or 4 year span. I'd play a couple times a week.
Where'd y'all play?
At the time, I was briefly a member of a club called Country Club of the South. And then when I bought a place up at Reynolds, I was a member of the golf courses there. So Taylor and I played a lot of golf together. I treated him and felt like he was my son. My son was in Texas. Taylor's about the same age. That was the type of relationship we had. And Jonathan, Jonathan and I, we had different styles of practicing law. Jonathan's a detail man, and that's okay. Everybody needs a detail man, but I don't think Jonathan ever really grasped the concept that I was trying to teach him about how to be a plaintiff's lawyer and build a bridge before you tear it down, or figure out how people can tear it down. Jonathan, he wanted to work on a case out in Arizona for 3 police officers that Gary Condon had referred to me. And I had my doubts about the case, but
This is a narrative. It's not
Yep. Let's get a question. Let's get a question asked.
I was describing my relationship with Jonathan.
Okay. Mr. Exum, why don't we ask a question so we can proceed?
I thought that was asked. I'm sorry. You want me to tell you about it or not? You have to ask me, I guess.
Well, I guess my next question was, you're also friends with your colleagues too.
Of course, they were guests at my home many times. They were guests at times I would go out to eat. They would be my guests. There'd be times where people would meet after work and drink. I had given up drinking some years ago, and I paid for it. So we had a social relationship as well as a business relationship. but the relationships were different. I've told you about Nicole's, I've told you about Taylor's and Jonathan. Jonathan and I did not socialize that much. We ran in different political circles and other things. But I love Jonathan, and I stuck with him when he fell off that wall, continued to give him a salary. And then when he came back, I even gave him an increase in salary and a bonus because he had tried to do some work while he was working from home, and I appreciated it and wanted to show him my appreciation. So that was the relationship I had up until the fall of 2019. Then things changed.
Okay. And how long was he in the hospital?
I think Jonathan, I don't know the precise number of days. I know that he didn't return to work until April after the fall in September. And I think he was in the hospital 3 or 4 months. He had a lot of surgeries. I mean, I don't think anybody thought he was going to walk again. He was lucky the Lord had saved him.
And he did some remote work for about 7 months.
He didn't work remotely 7 months. He worked some, and I
Yeah.
appreciate it. He was not sitting around at home, as I understood it, working. He was working at times to help out, but he was essentially disabled. He was at home.
But you were happy to have him back.
I love Jonathan.
Yeah.
I was glad he survived.
Yeah.
And he seemed to get along pretty well with Taylor. So they made a pretty good couple of guys to work with because they seemed to like each other. That didn't really apply to their relationship with Nicole. That applied to their relationship with each other. They did not have much of a relationship with Nicole.
All right. I was.
I brought you up in 2019.
Yeah. So I was looking for something, but I'll come back to it later. What 2019 was, let the jury know that was, what happened in 2019? I can clarify if I need to.
I know what you're looking at. So in 2019, I was hired. Actually, it may have started as early as very late in summer of 2018. But I was hired by a lawyer in England, Mark Stevens, to represent Vernon Unsworth, who was a financial guy in London, but also went out and mapped caves in Thailand. I didn't know anything about that. He said he was a caver. That's what he said he did. At the time, I believed him. So he had been in a deal where on Twitter, Elon Musk had called him pedo guy in connection with the rescue efforts for allegedly for 16 or 14 Thai children caught in a cave, lost, to which Vernon helped because he knew how to map the cave. He knew the cave locations. So he gets called a pedo guy, which everybody in the world interpreted as a pedophile, which is what he meant. And so I was retained by Mark to represent Vernon in a defamation case against Elon Musk. who was at the time, if not the richest man in the world, he was certainly in the top 4 or 5.
Now, did they specifically reference the pedo guy thing?
Yeah, we filed a lawsuit and I asked Jonathan, Taylor, and Nicole to help me. And I gave them, by agreement, I divided up a fee for them like I'd normally done in the past. And so off we went on a rocket docket. It was very strange how quickly that case got to trial out in Los Angeles. But we were especially set for a trial in December of 2019. And starting in or around October, November, Jonathan, Taylor, and my son Matt's treatment of me, and they started treating me like I was a dog. I couldn't figure it out. They yelled at me. They interrupted me. They were rude to me in my office. They told me I didn't know what I was doing in terms of my strategy for the case. And yet they had no experience from which to even begin to talk about how to prepare a case like that. Something happened. And I think I know what it was. I think the jury in the Musk case was rigged. I think Elon Musk rigged it. It's not that hard to rig a jury, even though the people that are involved in it, if they are caught, are in a lot of trouble, and they deserve to be. Every lie will be revealed. So the Elon Musk case, we did not get along at all. And I finally had a meeting with them at my lake house at the time, and I said, I'm going to hear you all out. And then we're going to make a decision. Either we're going to decide what to do, which was ultimately what I wanted to do. I was the only one with the experience. Whether I was right or wrong, that's the risk I took. The client came to me. And I told each one of them, either get on board, I'm going to lead, you're going to follow, or get out of the way. Don't go out to Los Angeles. No, we want to go. We want to go. Well, we went out there for a week. They lived high on the hog, nice hotel. And I paid for it all. I spent $600,000 in expenses on the Vernon Unsworth case. And the jury was out 30 minutes. Watch out when a jury's out 30 minutes to 3 or 4 hours. That's, in a case of that magnitude, you got to start wondering what's going on.
So what time of year again was the Reynolds Lake House?
It was, I can tell you exactly when it was. It was the weekend before Thanksgiving.
Okay.
Because I was supposed to leave on Sunday of Thanksgiving weekend. My family came to visit and fly to Los Angeles for a Monday morning start. Around Friday of that weekend, I became what I would call almost deathly ill. I didn't know if I had double pneumonia, lung cancer, or severe bronchitis. I wasn't even sure I could get to California. That's when I began to try to figure out what would happen if I couldn't go, who would be handling the case. I, at the time, thought Taylor would be the right person. But I got there and I got through it, and I thought I did a great job in court during the day. Everybody else did. But everybody would say in the mornings before court and after court, Lord, you look like you're dying. I had hired a woman named Tara Trask, on the recommendation of Phil McGraw, who I had represented off and on for 10 years in various matters. And Phil had a show, jury consultant show, and he was a former jury consultant after he quit being a clinical psychologist. And so I worked with those people, and I came to realize after we lost the case, trying to figure out what in the world happened, I came to the opinion that Phil McGraw and the people that he put into that case were involved in rigging the jury. And I started making inquiries in February of 2020. Same time that Taylor and my son Matt we're talking about having Dr. McGraw, Phil McGraw, do a medical intervention, mental health intervention on me, saying in a text, we've got too much to lose without Dr. Phil. Something's going on. And I think I know what it was. Nonetheless, that led to the February time period where I wrote some harsh messages to these lawyers, profane messages. Not proud of it. I said what I said. Go ahead.
I was just going to ask you, as I was going to ask you about that, to explain to the jury why someone as a God-fearing like yourself would.
Objection, Your Honor.
Yep. Let's rephrase that.
I'll rephrase that. So, Mr. Wood, you wrote some profane emails, and left some profane voicemails, and there were some surreptitiously recorded conversations.
Objection, Your Honor. There's no evidence that anything was surreptitiously recorded. No evidence.
There is.
All right.
But it's legal under Georgia as long as there's one party consent.
Okay. So the jury will recall the evidence. Just let's hear the question as phrased.
So
You asked about-
recorded conversations. I'll leave the word surreptitious out if that makes people happy. It doesn't matter. That's not material.
So I know what you're talking about.
Yeah.
They weren't profane conversations. There was some profanity used.
That's what I meant. Thank you.
There's no way for me to explain how angry they had made me, how hurt they had hurt me. A man that had been nothing but good as gold to them. And they were undercutting my relationship with my son, Matt. They were threatening my efforts for Richard Jewell to try to get him the Presidential Medal of Freedom, and they were threatening my efforts for Nicholas Sandman. The media defendants would have had a field day if the Mockingbird media had Lynn Wood subjected to mental health exam. Well, we don't want him to represent us. Look what happened with Nicholas Sandman. He fired me. But my mental health was fine. But nonetheless, if you looked at what I said, I was trying to teach these young people a lesson. Was it the greatest choice of words? No. Would I do it differently today? No. If the discussion occurred in a different context, yes. I was reborn as a follower of Jesus Christ in August of 2018. My life changed. Same man on the outside, new man on the inside. But I wasn't perfect.
All right.
And so I had to learn.
Mr. Wood, there's been an objection.
Okay.
Goes right to your motion of limiting.
We're getting close. We're getting close on that. I'm aware.
With all due respect, Your Honor, my faith is part of.
I don't need an explanation right now,
Coming
Mr.
off
Wood.
and talking about Jesus Christ, that's not right.
Mr. Wood, we covered this in a pretrial hearing, and I've not sustained his objection, so I'm going to allow Mr.
Okay,
Exum
well, thank
to
you.
ask the
Thank you.
question. But if it gets to a point, I'll instruct the jury on just how relevant or how that should be considered.
The point is, when I was reborn, then God teaches you. You don't get reborn and go, this is what I'm supposed to do. It's a process. So if I had the same situation today, I would pray about it before I responded. But I was very tired. I had gone to California for the Must trial. I came back from California and I traveled. Excuse me, am I keeping I may be putting people to sleep. I came back from California and I traveled to Texas. I traveled to Boise, Idaho to visit my children for Christmas. And then I came back in January of 2020 and I gave a 2.5-hour speech at Mercer Law School when they recognized me as a legal legend.
Your Honor, It's not.
And so I was tired. Yes, I had been sick, but recovered.
Objection,
Ye-
Your Honor.
Yeah, all right, Mr. Wood, when there's an objection, you have to stop. I think he was, I don't remember what question we were on, Mr.
He asked
Exum.
me about, I know what he asked me. He asked me about, let me articulate it correctly because I don't want to misstate his question. He was asking me about the profanity and the emails. And I'm trying to explain the circumstances because you just can't pull a sentence out without putting it into context.
Okay,
So, yeah, and all of a sudden, I mean, they're trying to tell me they want to start this new law firm with me. A real partnership is what it was planned to be. Wood, Wilson, Grunberg, and Wade.
Let me stop you there. When did that come up?
That came up in January
Okay.
because I had decided that I was going to retire and I was willing to try to stay with these lawyers in the sense of putting my name on a new real partnership first, because people would bring them business. And if I wanted to help them on one, I could help. If I didn't, I didn't have to. It was for their benefit that I started that new firm so they could have the benefit of my name and reputation, and at the same time work together themselves to go out and start killing what they ate. And so we planned it, although we were supposed to meet to do the details of the true partnership on February the 14th.
Now, is this, let me stop you. Is this what they testified to as the St. Valentine's Day Massacre?
That's what I called it.
Oh.
Because everything came together that morning for me. When I knew they were supposed to meet with me in my office, I had gotten my assistant to get everybody lunch. I was sitting in my house in Greenview, and I thought, you know what? These people aren't going to show up. That's the Holy Spirit. And sure enough, time for the meeting, I get a phone call. We're not going to meet with you. We'll call you at 2:30. Jonathan Grunberg. I said, okay, call me at 2:30. I was sitting with my feet propped up on the chair with my boots on because I knew what they were doing. And then at 2:30, he called me. And he was like a mad dog slobbering. He was talking so fast and yelling so much. And he was nonstop. And this is where it's going to be. I was going, whoa. So finally I said, Jonathan, can I get a word in? You got 5 minutes. Maybe he said 10. I said, it don't take that long. You got till 5 o'clock to get out of my office. Come down there and gather your stuff, gather your files, gather your furniture. Because I've changed the lock on the door. And you can come down there and you can leave with dignity, or I'll have a police officer at the building escort you out at 5 o'clock. I know what you people were doing. Looking at it now, I don't think they ever intended to start up that firm with me of Wood, Wilson, Grunberg, and Wade. I think they were just placating me until they could get the money and sand them.
Response to any question, it's some kind of
okay.
strange narrative.
All right, to that, I was just saying that. You have to, Mr. Exum, you can ask your next question.
Okay. So what do you think, well, based off all that, what do you or did you believe at the time were their motivations for the WWGW firm?
Objection, Your Honor, to the extent it calls for speculation about somebody else's. I mean, he's got to lay a foundation, what he knew, why he believed it.
I thought that was done.
I mean, at this point, I think there's a foundation of his interactions with them. So the objection is a speculation. I overrule the objection.
So with the WGW firm, I had done work with a lawyer named Nikki Baker, who also represented Steve Wynn in Las Vegas. And so when they were out, I asked Nikki Baker if she would consider stepping in and assisting me in the Salmon case. Because there were several cases, don't forget, not just CNN. And she came out to Atlanta. I met with her, and I didn't think it was a good idea. I had actually broached having her join, looking for Todd McMurtry to agree that she could join as associate counsel. And I just didn't agree. I finally said, this is not a good fit. But I talked to her during the time period because that was when I was at the height of battle with Wade, Grunberg, and Wilson. I told her, I said, I don't know what's going on with these people.
That was you.
And then it turns out Nikki sent something to them that I didn't know anything about, that my assistant missed, and they claimed somehow we're hiding something from them. I've never seen such nonsense. I do not lie. I am not perfect. I can make mistakes, but I am not a liar, and I am not a fraud. Do you think there's any amount of money in this world that I would trade my soul for
Mr. Wood.
and end up in hell?
Wood.
Yes, sir.
Thank you.
Excuse me. You have to
Thank you.
yell at me.
There's no other way I can get to hear you. You can't hear me if
No, you call my name one time, I turn.
All right, Mr. Exum, you can ask your next question.
Could we take a break, Your Honor?
No,
please?
we cannot, Mr. Wood. We're going to continue. Mr. Exum, next question.
Thank you.
So was it your intent, or was the intent with the WWGW firm to
Well-
have all named either people or their respective law firms within a written type of operating agreement?
No,
Question, Your Honor.
I've-
It's leading them.
I found
Overruled.
I found out from Nikki Baker. She called me and said, you better watch out. The law firm of Wade, Grunberg, and Wilson was formed
You're
in
staying.
20.
Mr. Wood, when there's an objection, I'm going to go say this just the last time. If there's an objection, we stop. Because that's how we've tried to do it this whole trial. I've got a rule on
Sorry, I did not
objection.
hear his objection. I'm
All
trying to
right.
focus on my testimony.
I understand.
I apologize.
All right.
I can hold up a hand if that helps. I don't
Yeah,
want
listen,
I'll do that.
I don't want to get thrown in jail.
I don't want you thrown in jail either.
Okay. The objection was to hearsay. Mr. Beals, is this something you need to approach on to lay it out? I mean,
Nikki Baker said to somebody who said to him, all this kind of daisy chain of communications, you're saying.
okay.
You can tell what he did, and I don't think it's relevant to anything, but
Well,
Mr. Exum?
it's relevant to the extent it explains the, interpersonal dynamics of the parties at that particular time, and to the extent that that might have caused controversy, giving rise to the issues that ultimately led to where we are today.
Okay. Just let the parties approach for a moment.
Yep.
Let's go a question at a time. Stan, why don't you ask your next question?
So who was Nikki Baker?
Hickey was a lawyer that I'd worked with on some cases for Steve Wynn,
Okay.
and I considered bringing her in to help me with Salmon when these lawyers were gone.
And
She's the one that alerted me that that they had started that they had started Wade, Grunberg, and Wilson. They had formed it in 2018. I didn't know that at
when
the
did she
time.
tell you this?
Objection,
During
Your
the
Honor.
time frame
I think
of
that's relevant to his state of mind. Okay, sorry. You can continue, Mr. Wood.
And it would have been in the early part of 2020. And she was giving me a heads up. I looked at it later and realized that they formed it in 2018 because they thought I was going to leave. So it was nothing nefarious about 2018, although at the time it appeared to be. The real question in my mind was whether they ever intended legitimately to be part of a new firm where they were equity partners of Wood, Wilson, Grunberg, and Wade. And we've talked about that firm. They agreed to set it up. And that's what we're going to meet about on February the 14th. And I called it the February 14th Valentine's Massacre. I have a sense of humor. So does God. And it wasn't just aimed at these lawyers. I took down some other people too. Rick Miller, for one, and others. People that I realized had been dealing against me behind my back. And I finally called them out. That was the Valentine's Day Massacre. And then I realized my phone had been hacked, my computer had been hacked.
Thank you. That leads to my next question. February 17th, could you describe the events of that day?
Yeah, and just a quick background, February 14th was a Friday.
Right.
And I had told these lawyers, one step back, after I had, in effect, had the building throw them out of the office, I went back and looked at the lease and said, dummy, they were signed on the lease as partners on the lease. I called the building and said, you got to let them back in. They never came back. They said they already had plans to go somewhere else. But I told them they could use the weekend to access my Dropbox, emails. And then I looked over the weekend and they were in it constantly. And I got concerned when I woke up, went to bed on Sunday night, woke up the next morning and my emails were in total disarray. That's when I called Tyler Jones and I called Don Samuels. And I ended up filing a complaint with the FBI to ask them to investigate what had been done to my computer. When Tyler told me he couldn't answer the question, and the other guy wanted to charge me a fortune, I said, this is just not worth it.
How long?
And I told them, they knew that I had sent the complaint. I wrote them a letter. I
Objection,
said,
Your Honor. It's just a rambling
Yep,
narrative.
we need a question here.
All right. How long was, you noticed this on the morning of February 17th?
it was the morning of either late that night, but I think it was the very early morning of the 17th. I'm a night owl. If you go through my life, you'll see that I write emails at 2 or 3 in the morning. I don't expect people to be up and respond. I just write when I have something to say, and I find sometimes between the hours of 12 and 3 o'clock, my mind is very clear, and so I'll put my thoughts down, expecting them to get it the next day and respond. So it was the morning of the 17th, without any doubt, that I saw my computer. And my administrative assistant kept a meticulous file system of my emails going back for years in closed cases, open cases, personal matters. They were spread all over my computer and I couldn't even find what had been taken, if anything, because it was in such disarray. And I already had some suspicions that I was being tapped. I later found out pretty sure that it was done through my Wi-Fi system at my house in Atlanta and my Wi-Fi system at my house in at Lake Oconee. And the guy that's in charge of my IT worked for Rick Miller. I brought the complaint against all these people, including Rick Miller and Anthony Armstrong and some other people and these people, because I thought they were involved in stealing information from my computer. When I couldn't prove it because of the cost, I said, forget it. And I wrote every one of them a letter. I said, I retract what I said about you because I couldn't prove it. I apologize. But I did defame you. And I'll totally understand if you decide to sue me for it. I'm sorry I did it. They didn't sue me. And I've come to realize over time that while I might have been wrong about what they had done, I was right about every one of them. There's a group of people that have had a long history of setting me up to attack me. And I think it has a lot to do, if not almost in its entirety, with Freemasonry, which I am an advocate against. Very much an advocate against. And I look at the people that are involved, and over time I learn they're all Freemasons. Almost every one of them.
Mr. Wood, if I can direct your attention back to what you said about the lease. Was it your testimony earlier that, actually, strike that. Who were the owners, or who was liable, rather, under the terms of that lease?
I thought it was in the name of L. Linwood PC, that I was the person on the lease, and they were paying their share in an office sharing arrangement. When I asked them to leave, I went back and pulled the lease and saw where they signed as partners. We were partners in an office sharing arrangement. We were partners in a leasing arrangement. That's when I said you got to let them back in. And that's what caused one of the problems that got me to have to hire Chris and Joey.
Before we get to that, though,
Yeah.
was there, well, I guess we can go ahead and transition to Chris and Joey, but were you the only person who believed they were liable in the lease?
Well, I looked at the lease and I raised it with Joey and Chris, but I first talked to the lawyer for the landlord, guy out in Texas, Jeremy somebody.
Would it be Jeremy Granello?
It was Jeremy Granello. I remember I was at Lenox Mall when I had the phone call with him. I was buying a suitcase. And he had looked at the lease, and I was saying that they owed me 3/4 of it. They were saying they didn't owe me a dime. He said, Mr. Wood, you're right.
Objection.
The lease,
That's hearsay.
Yeah.
Your Honor.
And it's
And-
not in evidence.
I'm about to tender it in evidence, if I
Well,
may. It's been offered.
All right, well, regardless, right now, that statement
Let me-
itself is
Yeah.
not for the truth of the matter it asserted, whether that was actually the legal effect, but for its effect if you find it has any on Mr. Wood's state of mind.
Yeah.
I'll let you proceed with that, Mr. Exum.
Yes, I'd like to direct the court's attention to defense exhibit 20 or 21, but
We're going to need that number.
21, I believe.
21, I think you said?
Well, is this the email from Mr. Granello?
I'm sorry, is it 21?
It's an email. It should be, it's either 21 or 20.
Okay. What's that?
well, this is
21.
not the email in question. This is the second part. This is the gentleman. Yeah, let me explain to you what happened. So I had a conversation with this lawyer in Texas. And he said, you're right.
Objection.
Sure it is, but it's being offered for a non-hearsay purpose. So again, this is not for the truth of that that lawyer may have said or thought. It's what effect it had, if any, that you find members of the jury on Mr. Wood's conduct.
So I was contending they owed 3/4 of the lease. He said, you're right, because they signed the lease as partners. And so they would be responsible for 75%, 3/4. He said, or if they were not your partners and they represented partners in the lease, they would have breached the warranty, and they'd be liable for breach of warranty of misrepresenting their status. So the bottom line is, I had that information when I met with Chris and Joy, that the landlord agreed that they were in fact responsible for 3/4 of the lease, which was negotiated where they agreed to pay me $285,000 to get off the lease. And they were going to pay that by allowing me to take the fees that we had agreed to split in the agreement in their entirety until they got the $285,000 paid back to me. I later in July decided I did not want to stay in the building. I tried to sublease it, I couldn't. And so then I went initially and had asked, as they wanted, for the building to take them off the lease. And the building said, no way, we're never going to do that. We don't do that. And then I said, let me indemnify.
All right, Mr. Wood, hold tight. Mr. Wood, hold tight. What's the basis of the objection, Mr. Beal?
Well, that's hearsay. There's nowhere in evidence where anyone says we're not going to allow them off the lease. That the evidence is they said the exact opposite, and it's just hearsay.
Okay. So he's testifying that that is what he was told. And so to the extent that is what happened, the jury is the final arbiter of credibility. Mr. Exum, you could ask.
I might finish.
You can finish that.
Thank you. So I took all that information to Joy and Chris. And ultimately, as you see in the agreement of March 17th of 2020, they agreed to pay me $285,000 for their share of the lease. I tried to just get out of it, get them off of it, because I had said they wanted off the lease. The building said, we're not going to let them off the lease. So I agreed to indemnify them, to hold them harmless, so they didn't have any problems going forward by being on the lease. They wouldn't have any legal exposure because I would indemnify them. And then ultimately in July, when I decided I wanted to leave the space in its entirety, then I negotiated a buyout with the building for $225,000. It was a better deal that I struck. The amount that they owed based on the landlord's calculations in March of 2020 was $285,000. So that's why that was one of the real serious issues that had to be resolved, that I took to Joy and Chris and said, you know, I got to get this lease situation resolved, as well as how we do the fee splits, which I had essentially agreed to. They're right. I had tentatively agreed, here's how we're going to divide them up. I did that in February the 20th, I think. And then I realized what they were doing. I wasn't sure I was really going to keep that part of the deal because it was tentative. But then when I hired Joy and them and the discussions began, I said, look, I told them I would do it. Let's just do it.
Let's segue into that. So when did you hire Olson and Bird?
I believe it was either March the 2nd, 3rd, or 4th of 2020.
And you're referring to the intake conversation on the 4th?
I'm just referring to my recollection. It was the very beginning. I knew I had been emotionally involved in it in February. I had some strong feelings that I wasn't going to give them more than they deserved beyond quantum merit because of the way they had treated me. And I basically said to them, either stop doing this or you're going to get quantum merit. That's all they deserved. Or get it together and start treating me the way you used to. And historically, you know, I'll be good to you. And I finally decided, you know what? I just want to be done with them. I wanted them in the rearview mirror, except that I would continue to help them in the future, sending them cases, offering a line of credit. I didn't want to hurt anybody. I never done that. I've always been very good to people that used to work for me that leave. So when I went to Joy and them, that was the issues that had to be resolved, primarily being that I had to get Lynn Woods out of it because I wanted out of it and I wasn't going to be the guy that was going to be able to negotiate at that point in time. And so I went to Joy and Chris and I said, get a deal and get me out of this marriage. I want a divorce and I want to get an agreement. And we did. So and I'd had no idea at the time that somebody was going to say that I had to get Nicholas Salmon's consent.
Okay. All right. Oh,
I'm
I
about
think
to
he
ask
was,
the
I think he was finishing. It's overruled. I think he finished his answer. Next question,
Did we
Mr.
get to some point, Judge, where I could take a break?
We've gone just a little bit over an hour and a half. Let's go at least another 15 minutes or so we can
Okay.
split the rest of the day in half. All right.
All right. Mr. Wood. When you hired Joey and Chris, or rather, as things proceeded in your representation by Joey and Chris, you had, I believe it was, correct me if I'm wrong, was it just your testimony that your position had evolved to wanting to?
Objection, Your Honor. It's leading him.
All right.
I know what my position was when I hired him.
Yes. What was your position?
Sure.
Better. Thanks.
Number one, I needed objective legal advice. I wasn't exactly sure what I should do at that point in time, but I wanted to get this out of my life. And so I needed objective legal advice. And then based on whatever advice I received, I obviously need competent counsel to carry it out. So that's why I hired Joy Burby and Chris Marquardt. I knew them from working with Joy, and I knew him from cases I'd handled with Chris, and I respected them. And they asked me for a $100,000 retainer. I said, fine. I had the money at the time.
And did you
And
pay
so
it?
I expected at the time,
Hang on.
well, hang on. I expected at the time that I'd give them the $100,000 retainer.
That's not.
They'd negotiate a contract and I'd get most of it back. I never anticipated I was going to get involved in multi-year, multi-million-dollar litigation.
All right. I think it was tied to the question at hand that he was asking regardless. So Mr. Eggs, I'm asking next question.
So you paid that retainer fee?
Absolutely. That's what they told me I had to pay. And I thought I'd get most of it back.
Okay.
I never envisioned that I'd be going through this for 5 years and millions of dollars.
You figured it'd be done in a few weeks?
I thought it was done on March the 17th of 2020 when we signed that agreement. Done deal. Started sending them cases. Offered them a line of credit. When the probate proceeding got postponed, of which I had nothing to do with.
We'll get to that.
But to finish my answer.
Objection, Your Honor. It's not a response to any kind of question.
All right, Mr. Exum, you can ask your next question.
All right. So
we both lost track.
yeah. Well,
you asked me if I paid the retainer. And
yeah,
I
we
said
answered
yes.
that.
I said yes.
And my next question is, at what point during Joey and Chris's representation did your mindset of just wanting help change?
It never did.
Okay.
I always wanted help. I wanted legal advice to tell me what an objective person thought I should do. And then I wanted legal assistance to carry out the plan. That's what I got from them. That never changed.
But did you always want to settle from the beginning?
I did.
Okay.
That's why I had come to at least a tentative decision about dividing up the fees. That's why I said to them on the phone, I said, what do y'all think's fair in salmon? How much do you want? 35%. I said, is that fair? Yes. I said, I'll give you 50%. Is that fair? Yes. They wanted as much as they could get, and I was testing them at the time to demonstrate in my own mind how greedy these people were. But then I had said 50. So when it came time to finalize the deal, I told Joy and Chris, give them 50%, because that's what I said, even though I said it for reasons a little bit different than what they may have thought. So I needed their help. I got their help. I thought we were a done deal. I thought life would go on now, and I could continue to do what I needed to do in the salmon cases, and I could continue my efforts for Richard Jewell, and I could get to that point where I could semi-retire because I wanted to write books. Got a lot of books in my head. Hadn't had a chance to do that yet. So I write on Telegram, and that's really where I get my writing desires fulfilled. And I have a channel, Linwood Speaks Truth. I do speak truth.
All right, next question, Mr. Eggs.
Understood, Your Honor. To clarify, those same tentative agreements from February 17th, were they the same ones in the March 17th?
No, the only agreement that was tentative I think it was the 20th or so, when I confirmed, or Taylor confirmed back to me, the division.
Okay.
But that wasn't the deal. We had other issues that had to be resolved, including the lease and other issues. And so it was Joy Burby and Chris Marquardt that I relied upon to negotiate the agreement. That's why the agreement of March 17th says that any prior agreements are superseded by the March 17th agreement. There was only one agreement, March 17th, not two, not three, one.
Thank you. Now, talking about the March 17th agreement, did you have a chance to review that?
Of course. I made suggestions to it. I assume they did too. The one thing that I had wanted to be clear on is that the amount of money to be paid to them on the fees had to be the obligation of L. Linwood PC, not L. Linwood individually. Why? Because the agreement with the Sandmans was with L. Linwood PC, and so the right to the fees in the Salmon case were the right of L. Linwood PC, and only L. Linwood PC could legally enter into an agreement to share them, not Linwood individually. So that's why that agreement was made, to be in conformity with what was the reality under the law.
Now, y'all entered the original salmon agreement into evidence?
The original.
March 17th.
No, the salmon engagement agreement.
Not the original.
Okay.
No, we did the original.
Well, you can ask me about it. I can tell you, I think it's in evidence.
Oh,
It'll take us a second to find it.
Just ask the question why they look.
Well, I just,
I know the judge wants to get going. I do too. So does the jury.
do you recognize, if I may approach? Does this say in the second paragraph? I believe it's 68, but I wanted to save you having to lift that big book.
Where you want me to look?
It says this letter confirms, read that part.
Yeah, I mean, the agreement that's the agreement I entered into when Todd McMurtry's law firm hired me. And it was an agreement between his law firm and L. Linwood PC. So whatever they owed or whatever I was entitled to under that agreement, it was to be paid to, and it was entitled to be, it was paid to L. Linwood PC, not L. Linwood. That's why, and you don't see Todd McMurtry's name on there. He puts his firm. It was an LLC, I think. So the agreement was with my PC. My PC was the entity that was entitled to the fee from that case. And it would have been only my entity that could have engaged in any type of a situation to share some of that fee.
Your Honor, defendants tender Exhibit 68, Defense Exhibit 68 in evidence.
Has this already been tendered? We don't know. Are you familiar with the exhibit though?
I am. I'm just trying to find it real quickly.
Is it in the big binder?
It is. It's 68 in the big binder.
I don't think we're going to have an objection.
Get that break-in, Judge.
I'm sorry. Yeah.
Yeah, I think it's in
about
evidence, but
15
I can't
minutes.
find the number right away, so we don't have an objection to it.
Okay.
Thank you.
D68 submitted. There's been a request for a cover break. So why don't we take 5? Let us know, members of the jury, when you're ready to proceed.
Can we get 10?
Whenever you're back.
All right, thank you.
Just do your best.
Thank you very much, Judge. I really appreciate
I
that.
understand.
Try to go outside and stretch my back. My back's bad. My leg. You can listen to me. Probably got some of your own, but you. We'll work while we walk.
Oh, Judge.
Uh-oh.
All right, let's be back in 5 to 10 minutes whenever the jury gives us an indication. We're off the record.
Yeah, Your Honor. Well, I can't. I can bring it up in a minute.
I'm sorry, I thought you could go.
I can tell you the truth. Just got absorbed with her, with him. He's supposed to come after he finishes, which would be
Oh.
4:30-ish.
Okay,
And I don't want her to wait that long, but
okay, got it.
I do
But I
kind
mean,
of
we
want.
started with the birth of this.
I mean, wow,
Um,
that was a lot.
Not supposed to be. She's. That's why. No, I didn't realize you have a phone, so. That's it.
So I'm gonna have to check on this.
Yeah.
And then.
So I didn't realize it after, sorry. So she's here, so we'll just make her wait. There's nothing to do. I'm not sure. At this point. But.
Oh. I'm about to fall asleep too. I know, I don't want to get. A Red Bull. Thank you.
Do you want me to open it on the spot?
Oh, we'll open it before everything's back. Thank you. I only had a half cup of coffee this morning, so I haven't met my caffeine limit for the day.
My coffee and water.
Are you interning for the summer?
Yes, ma'am.
Oh, please don't call me ma'am. I just, what school are you at?
I'm at the University of Georgia.
Fun. What year are you? 2L?
No, I just finished my first year.
Oh, no, that's exciting.
2 more years. But it was really exciting.
Are you enjoying it?
I am.
Do you know what kind of law you want to practice?
I went in thinking criminal defense, and now I'm not sure. I feel like I've just been exposed to a lot more.
Yeah,
Um,
that's actually very common. I feel like so many people go into law school and do.
I was, this case is reminding me of some of my contract terms. But I'm excited to work for a judge and kind of see
Yeah,
a lot
get exposed to a lot of different areas.
that I'm hoping, and I definitely will. Cause I need to kind of start looking.
Oh, you've got plenty of time. And honestly, this type of experience is perfect for that because like I said, you're gonna be exposed to so much. And then, maybe next summer, focus in on one of those areas that you like and hell, you might even decide you want to change your mind.
We know plenty of people who have changed their minds a lot of times. It's a practice area, right?
And I think that's good. If
Yeah.
you, I mean, if you get a multitude of practice areas, you bring something that the movie will go.
And that's why I like what you and I do at our firm because we do so much in the civil realm. It never gets boring. It's never the same thing over and over again. And there's just so many different areas. And general practitioners aren't really a thing anymore, but we do a lot in the civil realm that a lot of people do. People focus in on one area.
That's kind of why I chose the law. Career that doesn't feel the same thing every day.
Exactly.
So I want to find that it's feel like that.
Hey, well, civil litigation is that. I mean, every day in our office is different, right?
Yeah.
We do a lot of legal malpractice. We do a lot of employment discrimination stuff. We represent employees who have been discriminated against based on protected class reasons, which is really, it's difficult place work that's very rewarding. And then we do a lot of minority squeeze outs for
Yeah.
business disputes. So a lot of family owned businesses where the uncle is trying to squeeze out the cousin or the nephew or something from business and take all the money and run and do a lot of that.
Or physicians practice, physicians get together and break up.
Yeah, that happens a lot too. We represent a lot of doctors. But yeah, so it kind of runs the gamut for us because we get to do so much and we do a little bit of defamation work like them, but they are the creme de la creme, they do defamation law. In the nation, so. But I hope you enjoy the rest of your summer. It's exciting that you get to see a trial, like your first week being.
I know, I'm definitely really lucky. I was supposed to start Wednesday of this week, because I just finished exams on Thursday, Friday.
Oh, okay.
But I'm really glad.
Just check on the jury and see where we are.
This long, this still, it takes some different kind of awards. He's just a little bit longer in the bathroom.
Okay.
And he 20 attacks. Oh, yeah, no. Bring it up somehow.
Do you have any TA, Mr. Exum?
He'll be a few more moments, Your Honor. He's indisposed, but he'll be a few more. He'll be here in the next, I'm told, the next 2 minutes.
All right, I'm not asking for graphic details, but can you tell me the nature of the delay?
As best I understand, Mr. Wood has some gastrointestinal problems, or he's had that, and he walks with a cane. He doesn't walk very fast. So I don't think he's just camping out.
All right. Thank you.
Here we go. All right.
Thank you, Your Honor.
Let's go back on the record. I think Mr. Beal said he had something he wanted to bring up before we resumed.
Well, I was wondering about the real brief rebuttal witness, but we'll just let Mr. Wood finish up. It looks like it's got to be before 5 o'clock. And then
We'll go past 5 if we needed to finish up this witness.
pop her in and be done.
That's the plan of attack. All right. If there's nothing else, Mr. Wood, feel free to make your way back to the stand here as we bring in the jury. Okay, we can bring him in.
That's the letter I brought from Matt. All right.
Deputy Scott.
So one of.
Defense may resume their direct examination.
Oh, hey, go.
Judge, I
Wood.
just wanted to let the court know, I have my phone because I have certain text on here that I may have to refer to.
All right, if you just would place that to the side, not look at it unless you're asked, directed to by counsel.
Thank you.
Okay. Mr. Wood, so as to the March 17th agreement, I think we've all seen it multiple times, but for the record, was it your intent to honor every bit of those terms?
117%.
Did that ever change?
Never. Why would I enter into an agreement to pay them a lot more money than I actually felt like I owed them under quantum merit, just to turn around and not live up to it and get sued for more money? It's nonsense. I always intended to honor it, and I have honored it until I got the advice from Joy and Chris that I needed client consent from Nicholas Sandman, who was the only minor client involved. And I tried to get it. I did everything I could to get it.
All right. Yep. We were getting beyond the scope of the question. Let's ask another one, Mr. Exum.
Absolutely. And as for let's fast forward until after the hearing. What happens?
What hearing?
I'm sorry. Let me rephrase. The night that the settlement agreement was consummated,
Okay.
did you receive an email from Todd McMurtry letting you know that the conservatorship hearing had been canceled?
So yes, let me explain what happened. As I recall, the agreement was signed sometime on the early afternoon or so of the 17th of March. I'm not sure exactly when Nicole and Jonathan and Taylor signed it, but I know they met Joey Burby in his office or in the hallway. I had received an email from Todd a day or two before that, telling me that because of COVID, the probate judge was not going to be able to have the hearing, I think, the following Monday. I think everyone expected that the agreement would be signed, the probate judge would look at it, and the probate judge would approve it, if necessary, on behalf of the minor. So Todd said that he was going to try to. I understood.
Well, I think it was the reference to an email from Mr. McMurtry.
So I understood.
He can talk about that email.
Thank you.
All right.
So it was my understanding that Todd was going to try to get the judge to conduct the hearing by telephone. Then the evening, actually it was almost 10 or 11 o'clock, maybe 10 o'clock. On the 17th, I learned from Todd that the judge was not going to do it by telephonic hearing. And then I immediately sent to Joy Burby, Chris Marquardt, to Andrew Bill, and directly to Jonathan Taylor and Nicole, because I wanted everybody to know as soon as possible what had happened. So that's what happened. I had nothing to do with it. It got put off for reasons unrelated to me.
So is it fair to say that you did not learn of the cancellation of the telephonic or the impossibility of the telephonic hearing until that night of March 17th at 9:06 p.m.?
Yes, I think Todd had earlier told me a couple of days before that the courts had shut down, although he wasn't 100% sure about the federal courts. But it was clear that there was a problem with the probate court, which had to go first. And then he told me he was going to try to do it by telephonic hearing. And then he told me that night the judge was not going to set it by telephonic hearing. I think he said something about it might be as late as April, maybe even June. And that's when I notified everybody And that's when I offered Wade, Grunberg, and Wilson a $500,000 line of credit because I recognized that they had started their own firm again,
Objection, Your Honor.
and they might not have.
Just say objective narrative every time you want to raise it. So
All right.
noted.
I can interpose
Ask
a question.
Mr. Erickson.
I didn't mean to talk over you, Judge.
No, that's fine. Please ask a question.
Yes, I will. So that happened. And that leads to my next question, which was, or is, you then started referring cases to Wade, Grunberg, and Wilson?
I had, over the course of time between March the 17th and July the 24th, well, actually until August 30th, when I got the complaint. During that time period, between March the 17th and August 30th, 29th, I had referred them over 40 cases. And I had offered them a $500,000 line of credit because I knew that they had entered into the agreement expecting, as we all did, for the money to be paid within a few days after the probate court hearing. And I recognized that they might not have the financial benefit.
Related to the question.
Okay. Let's tie back to a question, Mr. Erickson.
Yeah, I thought you asked me about the $500,000 line of credit.
No, I didn't get to that one yet.
I'm sorry.
I will now, but before we do that, I would like to draw the court's attention to exhibits. I think we'd listed it as sub-exhibit C1, exhibits D27 through D63. They are the referral emails that Mr. Wood sent. They should all be redacted, but if they're not,
Okay. This is which exhibit exactly?
well, it's a whole bunch of them.
But a omnibus exhibit of, or perhaps not. You've individually labeled them?
Well, I believe they are individually labeled. They're 23 is D23 through D60, D27 through D63.
27 through 63. These are all referral emails. Mr. Beal.
I thought they had come in on cross, but we don't have an objection so long as they've been properly redacted because their clients' confidences about the nature of their claims and stuff like that.
All right. So assuming they have all been redacted, which you can clarify later, there's no objection to 27 through 63 and they're admitted. You can proceed, Mr. Exum.
Okay. So let's stay on the referrals for a minute. You made a bunch of referrals.
You just identified
Right.
D27 through,
I did.
63. Those were referrals. Now, what is a referral?
Tell us.
I get any number of individuals who contact my office. And we do an initial screen of whether that's somebody's potential case that merits my looking into it. Most cases don't. So what I did was I continued to get this large volume of referrals. I did not want to take them on. I wanted to finish salmon and retire and write those books I told you about. And so if it looked like it had potential merit, I sent it to Wade, Grunberg, and Wilson and let them take the second cut at it in the hopes that they may find that some one or more could be a good case for them to make them money. That's what I did in addition to the line of credit.
Did you refer to anyone else at this time? other than Wade, Grunberg, and Wilson?
I don't have a specific, I have over the years. I don't have a specific recollection and don't believe that I did at this point in time because I was focused on trying to help them as opposed to referring something to someone else. So I think the answer is no, that I did not. I sent them to Wade, Grunberg, and Wilson.
And why did you want to help them?
Why would I not? I love them. We had our arguments. We had our divorce. But I still loved them. I still wanted to see them succeed. If you've worked with me and you leave me, even if I had to fire you, because I've had somebody that I had to do that to, I always was happy for those people to put their relationship with me on their websites. And I would always keep them in mind because I did not want them to see them leave me and fail. Because that would reflect on their relationship with me. This person worked for Wood, can't make a living. And I wanted people to know that the people that had worked with me in the past were very good lawyers and they should be recognized and potentially considered for business, which inures to their benefit. Wasn't going to put any money in my pocket, but I was trying to help them. I'm not perfect, but I like the idea of do unto others as you would have them do unto you. And so I, guided by the Holy Spirit, try to do good works. Can't do them on my own. Have to be guided and preordained by God.
Thank you.
And that's just who he created me to be.
And did you refer any high-profile clients to plaintiffs?
I know that I referred, I believe I referenced Otis Redding III, Otis Redding Jr.'s son. And I remember that specifically because it was within a week of when all of a sudden I got this heinous complaint they were going to file against me. And I called Otis and I said, I don't know if you've signed up Nicole Wade, but let me tell you something. She's getting ready to sue me and say things that are not good and true. And it makes me second guess whether I should have sent the case to you. And he said, well, I've already spoken briefly to her and I'm not interested in hiring her. So other high profile cases, I did not take a look at specifics in the first screen. If it came past the first screen, I looked at it and I thought this could be something that would help them. And that's when I sent it to them, 63, whatever number of cases.
So you actually had a good sense based off your experience where these cases might go. You didn't just send them junk, is what you're telling me. Is that right?
Right. If you're a plaintiff's lawyer, if you don't have any discernment about the cases you take, you're going to lose your rear end. Because usually you have to finance the cases. Clients don't want to pay you back expenses when they lose. So I was always very careful in terms of the cases I took. I never took a large number of cases. I think the most I ever had in my own practice was probably something much less than 25, a number that were being developed, a number that were being litigated, and a few that were ready for trial. So I always kept a low number of cases. I wasn't a big volume lawyer. I wasn't out here putting my name on the buses and the billboards. So I tried to do the same thing in referring cases. Nobody's going to appreciate you if you send them junk. And I don't send junk. I sent things I thought they may find value in. Sometimes I don't find it. They might, just like I've had cases brought to me where lawyers didn't think they had value. And I looked at them and said, I think this is a good case. And I took it, and most of the time it turned out to be a good case.
And in that email to Dexter King, it's your testimony that you told him what you thought Nicole was going to do. You did not say, I hate her.
No. I talked to Dexter King. I talked to the co-counsel in the class action case that Taylor was handling. And I talked to a client named Rosalind La Liberté. And I called them and said, you need to help me. I've just gotten a lawsuit that Nicole Wade and Wade Grunberg and Wilson claim they're going to file against me. And if they file it, I'm not going to be able to work with them to help you on the cases that you've got. And I wanted them, in effect, I think I said it, talk to these people and talk some sense into them. That's why I called them. I didn't call them to disparage them. I called them to tell them, here's what's happening. See if you can help prevent this. Because if it happens, it's going to drive a wedge that I'm not going to be able to work with them ever again.
Thank you. Now, after you hired Joey and Chris, did you continue to have direct communications with plaintiffs?
The only direct communication I had, because I knew that was not allowed under the ethical rules, but I felt an urgency to write them directly and copy Mr. Bill to tell them that the hearing was not going to be rescheduled telephonically. Other than that, I don't believe, there may have been one other exception where there was a need. I don't believe I ever had any more direct communications with them except as it occurred in litigation.
And I recall, strike that. The Salmons, did they come to visit in the summer of 2020?
They did. Once I had learned from Joey and Chris that there was going to be a requirement of client consent, I did not have any discussions with Nicholas Sandman intentionally because I didn't know what he would decide and I didn't want somebody to blame me. So all of the discussions were with Todd McMurtry and Nicholas Sandman. I get a phone call, I believe it was July the 6th of 2020. And the Salmon said, we're in South Carolina returning from a vacation. And we're pretty close to Motley. Could we stop by and say hello? I said, sure. And so Nicholas, his mother and father, and I believe his brothers and sister, I think he's got two brothers and a sister, they came by to Motley. We spent maybe a maximum of 2 hours talking about whatever, tell them about the property and what I was doing with it. And then they left. Did not discuss one iota of business, not even the cases that were still ongoing where I was representing him. I just didn't talk business with him that day. I didn't want to. I didn't want anybody to accuse me of something I didn't do. Oh, we got Nicholas and told him what to do. That is a lie. And that's what I wanted to avoid somebody doing. So we had a pleasant visit. They invited themselves. This idea that I flew them down to Tomotley is a lie. The idea they were there with me all day is a lie.
How long were they there with you?
I would say no more than 2 hours. It was a quick visit. They stopped by because they were on vacation. And I was a gracious host, and I was proud to show them Tomotley, which, by the way, is Tomotley. It was a former plantation, a rice plantation. When I bought it, I changed the name to Tomotley.
We're beyond the scope of the question. Mr. Exum.
Yes. When did your lawyers from Austin and Byrd first tell you there might be a problem with the issue of client consent?
I had two other cases where I felt like Rick Miller and his wife Cherie Fazell had sent to me, and the deal was that I was supposed to pay Cherie Fazell a percentage of what I recovered in attorney's fees. Cherie was a lawyer, but she was not active. She had reactivated her license so that she could get a portion of the DeVita fee. And Rick Miller got $10 million, and he didn't do anything. His wife got it. So I was concerned about what I thought Rick Miller might actually be doing to me because he's a Freemason. And I asked Joy and Chris to look into whether there was any problem with me sharing a fee with Cherie Fazell, who did not do any work on the case. And it was in the process of their review of that issue in late April or early May that they came back and said, well, if she's going to receive a fee, there's a rule 1.5 and it requires that the client consent. And I remember thinking, does that apply to Sandman? Because I didn't know.
No, it's related.
From there, let's ask the next question.
Okay. So the next question is, what did you then say to Joey once he told you there was an issue with the Sherry Fazell case?
Once he told me that there was an issue that involved Rule 1.5 that required client consent, not just for a minor, anybody. And I said, was this going to impact Salmon? They said, yep, I'm afraid it does. And so then the gears shifted to trying to find out what their analysis of the law was, and they concluded that the prudent thing to do to not violate Rule 1.5 and not take the position that the agreement was simply void was for them to get and for me to not only ask, but to urge client consent. Under what they sent me, and it's in writing, the rule would have rendered the agreement void. I could have looked over and said 1.5 says there's got to be client consent. At the time that you enter into the engagement, we didn't do that here, so your agreement is void. I didn't do that. If I wanted to blow it up, I could have done it. I didn't want to do that. They said, let's get it at the end, at consummation, and that will meet the spirit of the law, even though you should have gotten it at the beginning. If you get it at the end, we believe that's prudent and will satisfy the intent of the ethical rule. I said, let's get it.
Well,
On the grounds of
Narrative.
narrative. All right,
all right,
Mr. Exum.
I can. Okay, so did you, not to make you repeat yourself, but did you seek client consent?
I did not directly. It was done through Joey Burby and Chris Marquardt,
Thank you.
and they prepared a consent form, which I was told had been presented to Nicholas and that he had conferred with Todd McMurtry and did not agree to sign it and objected until there was some evidence of their work product. I was actually shocked that he didn't sign it because, as everybody can see, it wasn't his money. It was the money I had earned. And you think he'd look over and say, well, if Lynn's satisfied, cut it up any way he wants to. But for some reason, he objected. And he did that after he consulted with Todd McMurtry. And it didn't make sense to me then. It doesn't make sense to me now, except I know now that Todd McMurtry is a Freemason. And I think he was trying to screw me.
To clarify, Mr. Wood, You wanted, even at that time, you maintained your intent to honor the terms of the settlement agreement,
I maintained my intent and my integrity. There's no amount of money it would be worth me giving up my integrity and jeopardizing my future, my future in heaven.
Your Honor.
I know. Let me think about it, Mr. Wood, while I, but to that extent, it's overruled. You can finish your response.
What I was saying simply is this. I need money. I don't love money. The love of money is the root of all evil. And there's no amount of money that you could offer me that would allow me to lie, cheat, or steal. Because my focus is on heaven, not this world. And I'm not going to do anything for money that would cause me to jeopardize my eternity in heaven
Objection, Your
with
Honor.
Jesus
Don't
Christ.
alter it.
Yeah. All right. It's time to move on. Mr. Exum.
So through counsel, how many attempts would you say you made to get plaintiffs to comply with?
That was all done by Joey and Chris. I didn't want anybody to say that I was trying to influence it one way or the other. I had paid them a lot of money and continued to pay them a lot of money. And I relied upon them even when he didn't initially sign it, objected to it. I think they made at least 3 attempts to get him to provide the information, to provide to Nicholas the information that he said he wanted before he could sign it. So they made repeated efforts to try to get him to consent. One day, we might learn why he didn't consent, but I think I know. And I'm not happy about it.
Okay. So you were completely removed from the process, would you say, of either seeking seeking the consent?
Yeah, the next thing that happened to me was I got this outrageous complaint alleging all of these personal salacious statements, kind of like they do in these emails and stuff they put up, try to smear me. And then it's game, set, match. I tried to tell them and offer to them, let's sit down and talk about it. Let's mediate it, or let's put it to binding arbitration. There's a process in Georgia where you can take to the bar and you can get 3 lawyers chosen by the state bar, and they are binding in their determination. I said, let's give it to them. And they quickly said no and file that lawsuit. So the publicity around the nation and world about all the salacious allegations they included in it that were irrelevant,
Objection, Your Honor.
it hit the world.
Objection,
And
Your
my
Honor.
reputation got ruined.
Mr. Wood, all right, that's it. We're going to cross-examination.
Excuse
You
me.
heard me. You heard him objecting.
I
and
did
you
not.
violated my order 3 times.
Your Honor.
That's it.
Your Honor,
Done.
I did
Mr.
not.
Jerry, you can step out if you'd like so we can address this on the record. Thank you.
He kicking us out.
You can't cut off my right. Didn't know anything that I do. They've been looking.
Mr. Wood, Jerry is here and you
Oh, I'm
continue to
sorry.
talk.
I'm sorry, Your Honor. May I have an opportunity to be part of this discussion since it looks like you're getting ready to tank my case?
Here's a clear judge. All right. I think we need to make a record of this, Mr. Wood. I don't know how long you expected me to put up with this, but I've now given you repeated instructions over and over again that you're not to talk over objections. There have been a lot of them. I get that. It's frustrating, but I have to rule on those before evidence can come out again. You're looking right at him as he's standing and his lips are moving. How could you not know that he's objected at that exact moment?
I don't even know what the objection was.
That doesn't matter. You don't have to know what the objection is because you're not the lawyer.
I know, I'm focusing on trying to answer the question,
Yeah.
and it's not intentional. Judge.
Yeah, I mean, I can make a finding at this point that I believe it is. So the
Well, I'm
point
gonna
being
ask
is
I'm gonna
what,
ask you one more time, like you did the other day. I didn't know I was getting ready to lose my right to defend myself. Now you've told me I will put the timer on myself. It's too important to me to not be able to tell my side of the story. And I have not been rude to anybody. I have shown deference to the court. I'm in a tough situation. We can't just isolate it and say Wood's a witness and he's not paying attention. I'm trying to walk a very fine line between being the lawyer for myself and also the witness. And I think I have done a very good job, but sometimes I might cross the line a little bit. But certainly nothing I said there would justify, Your Honor, taking away my right to defend myself. It would violate my constitutional rights to a fair trial, and it's not necessary. We've come so far, and we don't have that much further to go. Once again, and I think Your Honor will know that I abided by your ruling the other day, and I appreciate you letting me stay in the case. And I've been walking on eggshells, and I haven't broken an egg. Now I'm on eggshells again as a witness. Don't stop my cross-examination, Judge. You've admonished me again. You've threatened me. You've warned me. Give me that other chance to finish up this testimony. Otherwise, it's going to be reversible error.
I'm certainly not stopping cross. I think the plaintiffs have a right to cross. But at this point, I mean, I'm pretty much finding myself without any options because most of what you have told me, I just very much disagree with. I think you have gone over the line many times and you've done it knowingly at this point. So I'm trying to figure out what to do about it. And Mr. Beal, do you have anything you want to add?
I got a great idea. How about we do 5 minutes left of this rambling stuff, and then we'll do some cross and we'll get this case ready. There's got to be a sanction. He's been doing it for 2 weeks. He's got 45 years of experience. He knows what he's doing. Your Honor hadn't been able to get a ruling in. He's been testifying on his questions. He's been running over and trying to, it's been sort of more of a circus than it should be. Every trial gets messy. We've all been in messy trials, but this is like nothing I've ever seen. I mean, that jury has heard so much stuff that isn't sworn testimony. And there's been a ton of objections, and I apologize, but I'm trying to keep things between those lines. And maybe objections aren't the way to do it, but I think Your Honor's response is not only justified, but we've been through this speech. We've heard the exact mea culpa before. And then it hadn't even slowed down. So what I really want to do is get to some cross, get to Sharon Lindsay.
Here's what we'll do. I'm just going to note for the record, we're at the 46-minute mark. That's what's remaining. And so the direct testimony has gone for about 2 hours and 15 minutes. And some of that time has been taken up with objections, but I would only attribute a couple of minutes to that. The original estimate to me was 2 to 3. We're going to transition to this other witness. You said that you needed to get in.
Sure.
We'll do that. Then we'll transition to cross. And then when we come back tomorrow, I'm sure you'll still be in the middle of cross, but at some point you can tell me, Mr. Exum, what remaining topics were to be covered on direct, bullet pointed, and I'll decide whether and how much time you get to on redirect to cover those points. All right?
Okay.
I think that's fair.
Thank you, Judge.
It's probably not going to be 46 minutes though, I'll tell you that. All right.
So
you can get your other witness
Yes, Your Honor.
So we need to give you a bullet list
of what remaining that you haven't already covered on direct.
Right.
Email to Ms. Sue.
You can email to Ms. Sue, and that's going to probably include stuff that's very well may come up on cross as well. We'll find out.
Okay.
When do you want that done? Should we wait until the cross is done?
Probably makes sense to do it at some point before they're cross.
Oh, did mic it off?
It'll be 1 second, Your Honor. We've got to print a 1-page document.
Can we go ahead and get her in though and get her
Yeah.
started?
Yes, Your Honor.
I thought I had a minute or two, so I didn't.
We got a minute or two, but. All right, Deputy Scott, if you could check on our jury.
Right. Check on the document. I was waiting, so.
Your Honor,
Sir.
would it be okay for me to, in order to assist Mr. Exum on the topics to be covered, I'll need to confer with him. Is that okay?
I think you always have the right, even if you're in the middle of your testimony, to confer with your counsel. I think we covered that at the front end.
Do I need them? Yeah. Well, I guess we'll just do it.
I'll forward it to you right now.
Okay. Okay. Just print it. Do it, man.
Right, but you're.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, as we think we've done before in this trial, sometimes we have to take things out of order for logistical reasons. So to that end, we are pausing the testimony of Mr. Wood, and the plaintiffs are calling a rebuttal witness to present their case. So plaintiff may call their next witness.
Yeah. One moment, Your Honor. Your Honor, plaintiffs call Ms. Sharon Lindsay.
So help me God. Thank you.
State your name and spell your name.
It's Sharon Lindsay, and that's SharonLindsey.
Ms. Lindsay, how do you know the plaintiffs here, Taylor, Jonathan, and Nicole?
They handled my case when my husband was killed in a trucking accident.
Okay. Very sorry to hear that. Were they your primary lawyers in that matter?
Taylor and Jonathan.
And the tragic death of your husband, did it lead to several different lawsuits against different parties for causing this multi-car collision?
Yes, sir.
And there was a large case. And who was that against? A trucking company?
A trucking company, yes.
Yeah. And do you remember the last case that you had regarding your husband's death that Jonathan and Taylor helped you with?
The tree settlement?
Yes.
Yes.
All right. And when you say tree settlement, does that mean the company that was cutting the trees on the side of the road that somehow contributed to it?
Yes, sir.
All right. And what did you think of the work that Jonathan and Taylor did for you?
I am in such a special place today because they took care of me at one of the worst times of my life.
When all the work that they did for you, was it done through LN Wood PC? Lynn's law firm?
It was at first, yes.
And how much did the tree company case resolve for approximately?
I think 245,000, maybe 280,000. I'm sorry, I don't know the exact amount.
And was there a say about them? Perfect. Thank you. All right, hold on for me 1 second. I'm just going to mark this guy.
Thank you.
Ms. Lindsay, I'm handing you what's been marked Exhibit 403 for identification purposes. Can you tell the jury in general terms what it is?
It says my settlement claim, settlement statement.
And I'll represent to you that it's the tree case.
Mm-hmm.
And there are two different law firms listed there as sharing in the fee. Is that correct?
Would that be that?
Can you read that one for the jury?
All right, LN1 Wood PC, Cherie Fuzzle, Esquire.
Okay. Who's Cherie Fuzzell?
I have no idea.
So a portion of the fees on your case got shared with a lawyer listed there that you don't know.
I don't know.
Did you ever meet Cherie?
No, sir.
Did she ever work on your case?
No, sir.
Your Honor, at this time, we would offer plaintiff's exhibit 403 into evidence.
Any objection to plaintiff's 403?
No.
Submitted.
Thank you. At any time, did anybody from Mr. Wood's office contact you and discuss sharing of fees of this $42,750 that was going to Lynn Wood on your case?
No, sir.
That's all I've got right now, Your Honor.
Any cross-examination?
Oh, sorry. Did anybody from Alston and Byrd call you and ask you to provide consent to the sharing of fees?
No, sir.
Thank you.
May I proceed, Your Honor?
Hold on one second.
Are you done?
Hold on.
All right.
Thank you.
Cross-examination. You may proceed, Mr. Williams.
Thank you, Your Honor. Ms. Lindsay, you and I have never met in person, have we?
Yes, initially.
I'm sorry?
Yes, initially.
Where did we meet? Remind me, I apologize.
In your office with Rick. I don't remember Rick's name and my sister-in-law.
Rick Miller.
Yes,
And your sister-in-law was Rick Miller's executive assistant, true?
yes, sir.
How long had she worked for Rick Miller?
I don't know.
Do you know how you came to seek representation from me?
Rick brought me there.
Rick Miller brought you there. Now, you don't know Sharif Azell, do you?
No, sir.
Are you aware that Sharif Azell is Rick Miller?
Objection, Your Honor. Just said I don't know who she is.
Okay. And so, Mr. Wood, you can ask a question if there's something else that you think she might know about this individual, but not if she has no idea who this person is.
Maybe I can refresh her, but simple question. Were you aware that Sharif Azell is the wife of Rick Miller?
No, I was not.
Were you aware that Sharif Azell has a law degree?
No, sir, I don't.
Were you aware that when your case was referred to me, that Rick Miller requested that his wife, Sharif Azell, receive a part of the fee?
Objection, Your Honor.
Yeah, I do believe this goes beyond any scope of her demonstrated knowledge. Next question.
Did you sign this settlement agreement?
No, sir, I don't remember this one at all.
If I have a copy of the settlement agreement that you signed, would that refresh your recollection?
Yes, sir.
And I have to find that tonight, Judge, because I didn't know she was going to testify until this afternoon.
All right, you can proceed, Mr. Wood. We'll take that up at the appropriate time.
And in that settlement agreement, Sharif Azell, Esquire, received a certain amount of the attorney's fees. It's blacked out here, right?
I have no knowledge.
Look at the settlement agreement.
I am.
Do you have any idea why Sharif Azell would be on this settlement agreement as having received a portion of the fee?
No, sir.
But you didn't know anything about that.
I know nothing about that.
You only knew that your sister-in-law has for many years been the administrative assistant to Rick Miller of Bryan Cave, formerly of Powell Goldstein. True?
True.
And did you ride over with Rick when you met with me? And I apologize for not remembering.
No, sir. I don't remember. I thought we all just met there in your office.
Including Rick?
Yeah. Rick and Marcia.
Rick and who?
Marcia. My sister-in-law.
Right. And Do you have the exhibit? Do you have a copy you can put in front of the
She's got
settlement?
it. She's got
Do
it.
you have what's marked settlement statement?
Yes, sir.
And it does not bear your signature, does it?
No, sir.
Do you deny under oath ever signing a settlement statement? Or is it possible you did and you forgot?
I don't remember this document at all.
You deny under oath ever signing this settlement statement?
Objection, Your Honor. I think we've been over it 3 times.
I think
This
he can-
got a signed copy. We all thought it was eventually signed, whatever she remembered.
Okay, so he's just clarifying her position on this, so I'll overrule that. Continue, Mr. Wood.
You understand my question? Do you deny under oath ever signing this settlement agreement? Or is it a situation where you may have signed it, but you just don't recall it?
I don't recall this at all.
I understand that, but do you deny from your recollection? Do you deny ever signing?
I don't remember.
And do you see? Look at underneath where it says total net recovery decline.
Correct?
Sorry.
Yes.
Do you see where it says, if you'll read with me? The undersigned client has accepted the above disbursement, acknowledging the same to be true and correct, and gives the law firm of L. Linwood PC the authority to receive the settlement funds into an escrow account and make a disbursement from that account as set forth above and pursuant to the terms hereinafter set forth in the settlement statement. Client approves any division and disbursement of LLWPC's attorney's fees pursuant to an agreement satisfactory to LLWPC entered into on or before the date of the settlement agreement. Any purported fee division agreement by LLWPC prior to the date of this settlement agreement is not approved and should be considered null and void. Have you read that with me?
Yes, sir.
Did I read it correctly?
I'm sorry, I was not following the whole time.
Sorry.
I'm sorry, I was not following you the whole time.
Well, maybe Andrew, but did I read it correctly, Andrew?
No.
So I gotta do it again. Okay.
It's fine now. It's close enough for government
All right.
work.
It's not close enough. I gotta make sure the record's clear that I've read it correctly and she knows that. If she's not willing to acknowledge it, let me try again. Find the. Follow me? Yeah. Yeah, just give me the agreement. You ready?
Yes, sir.
Let's save time. Why don't you just read to yourself the first paragraph underneath total net recovery to client? Read that next paragraph for me and let me know when you're through.
I'm done.
So you've had a chance to read it. I'm gonna have to hand you my phone
Oh, no.
to see this email.
I don't think that's how that works,
Objection, Your
Mr. Wood.
Well, then I have to read it. This is a rebuttal witness. I have an email that goes.
We don't need to talk about the contents of it before I've admitted it. Does she party to this email?
It addresses her case.
But would she know anything about it or what's in it?
I don't know.
Well, we'd know who's on the email.
I know that Sharif Azil sent this email to me when I raised questions of, say, I don't want to testify.
Okay, I appreciate that sentiment. Why don't you show it to opposing counsel first and we'll go from there.
Yeah. Start right there. And then it goes down to here, because I raised a question.
We got to object to that.
Okay, why don't you approach and you can make your record.
I don't know. I just know. I just knew she was gonna testify. Because I've got all the documents that I'll find tonight.
See if those are admissible.
Oh, I believe so.
Okay. At this point, you can proceed with the next question, Mr. Wood.
John? Yeah. Where's the next? Where's the May 17 settlement agreement?
March 17th?
March, I'm sorry. I lost track of the month. If you don't mind.
Well, it's, I don't remember.
Could it be under here?
No.
That's not doing anything right now. What's y'all help us a little bit. What's the number of the exhibit of March? I mean, March 17th settlement agreement.
102.
102?
Yeah.
I also found it here.
Let me have 102 in paper.
All right. Approach.
Okay.
Fine. Just, oh, no, don't take it out. Just open it up.
I don't hold it. No.
Ms. Lindsay,
Mm-hmm.
were you ever aware that Wade, Grunberg, and Wilson received $34,200 from the L. Linwood PC fee as it related to the Lindsay versus Clear Zone case?
Objection, Your Honor.
Grounds.
there's absolutely nothing in evidence that they got any payment. In fact, all the evidence is we got zero payments so
All
far.
right. Witness can answer it if she knows it. I think I know what the answer will be. Can you answer the question? Do you have any idea?
I don't know anything about that.
Well, you've told us how impressed you were with Jonathan and Taylor,
Yes.
and I'll hand you, if you don't mind, may I approach?
No.
Page 1 of an agreement that they made with me on March the 17th of 2020.
I'm going to object, Your Honor. There's absolutely no way this witness
No.
could know about a document that she was never a
She
part
has
of.
nothing to do with this document, Mr. Wood. If you got other questions you want to ask her about the nature of the representation that were implicated by the direct, feel free, but I don't know. I don't understand.
May I ask one question?
Let's see what the question is.
Ms. Lindsay, Jonathan Grunberg or Taylor Wilson at any time tell you that they were negotiating or attempting to negotiate a deal whereby they would receive $34,200 from your case, Lindsay versus Clear Zone?
No, sir.
They never told you that, did they?
No, sir.
That's all I have, Your Honor. Subject, unfortunately, I don't know how to do this.
Well, I understand you. Let's take that up.
It's just a matter of what she has to do. I've got to have my office go back and look for the signed settlement statement. But then I don't want to, she's from out of town, so I mean, I can't release her until I have a chance to find it. If I can find it, I think I can.
We'll take that up and we'll make
All
a
right.
record of it.
Thank you, Judge.
if
Thank you,
we're
Ms. Lindsay.
outside the jury's presence.
Thank you, Ms. Lindsay.
Am I done?
Well,
That's
not
up to
quite
Judge.
yet. We just got to
Okay.
clear up a few things here. Is there any redirect?
Yes, Your Honor. So, Ms. Lindsay, no one from Alston and Bird or Linwood's office contacted you in February or March and asked for permission for Lynn to share attorney's fees with Jonathan, Taylor, or Nicole at any time during that time period. Is that right?
Right.
Thank you. Nothing further, Your Honor.
Nothing further, but except I cannot agree to this witness being released until I have an opportunity to search my firm files to see if we do have the signed copy that she signed to the settlement statement. And that'll take me tonight, and I'll know tomorrow morning.
Mr. Beal.
I fail to see what the significance of her final signature is going to be. I mean, it's the settlement statement and.
Okay. All right, we'll make a record of this. We still have about 30 minutes with this jury, so I want to use that time as best we can. So, Ms. Lindsay, you can step down now, and you can leave the building. The plaintiffs are going to let you know whether you have to come back at some point later. Okay?
Okay.
All right.
Thank you very much.
All right. With the time we have remaining for today, Mr. Beal, I believe you have some cross-examination you want to take up with Mr. Wood. We can resume that testimony.
Thank you, Your Honor.
All right, Mr. Wood, if you could make your way back to the stand. And I think we got a document there left behind we need to retrieve.
I would approach real quick. Thank you.
All right, plaintiffs may proceed.
Thank you, Your Honor. Mr. Wood, you have stated to the jury a couple times so far today that you are acting pro se, representing yourself. Is that correct?
Excuse me one second. I'm trying to answer a question that came up a minute ago. Would you repeat the question, please?
You have stated several times to the jury that you're acting pro se. You're representing yourself. Is that correct?
I am.
Okay. You're not a member of the bar any longer. Is that correct?
I'm not.
And you have surrendered
I'm
your law license. Is that correct?
The State Bar allowed me to retire.
The official document did not include a surrender of your license?
I don't have the official document in front of me, but I know that they had disciplinary proceedings against me that were instigated by your client's complaint, and that ultimately I went through a trial, and at the end of it, I asked them if I could retire. And in order to allow me to retire, they had to drop the disciplinary charge. They agreed to do that. That allowed me to retire and also allowed me to represent in the future myself pro se.
Okay. And that concluded the disciplinary proceedings conducted by the State Bar against you. Is that correct?
Oh, let me see. Been so many. It was a 3-year proceeding.
My only question is
and the answer is that concluded my dealings and relationship with the State Bar of Georgia, which I wanted out of.
Okay. And Your Honor, can I approach?
You may.
I'm sorry to do this. This is exhibit
105.
105, which doesn't exist in paper, and it is the operating agreement of Wood, Bernanke, and Evans that I believe we testified to and put into evidence.
I believe you're exactly right.
Okay. And then when we turn over, this is the written partnership agreement. Is that correct?
Yes.
And can you describe or read for us the 3 members of that firm?
The limited liability company operating agreement dated as of April 20th, 2011 is among the following parties, the members. 1, L. Lynn Wood, PC, a Georgia professional corporation with its principal office address at 561 Dalrymple Road, Atlanta, Georgia, 30328. 2, the Bernanke Law Firm, LLC, a Georgia limited liability company with its principal office address at 1201 Peachtree Street, Northeast, 400 Colony Square, Suite 200, Atlanta, Georgia, 30361. And 3, Stacy Godfrey Evans, LLC, a Georgia limited liability company with its principal office address at 2065 C Lake Park Drive, Smyrna, Georgia, 30080.
Thank you very much. And there's no question in your mind that Wood, Bernanke, and Evans was a law partnership. Is that right?
Made up of those 3 members?
Yes.
In writing?
Yes.
Absolutely.
Okay. And the 3 members were Ellen Wood, PC, Bernanke Law Firm, LLC, and Stacy Godfrey Evans, LLC. Is that correct?
Yeah.
Okay.
And I referred to them individually as partners, but the actual partnership was their PCs or LLCs.
Right. So there was never an allegation from you at any time while this firm was in place that Stacy Godfrey Evans was not your partner, or that her LLC was not in partnership with you, or that it was an office sharing agreement because it included separate LLCs, was there?
I'm not sure I followed you. Here's what I know happened.
No, let's get an answer to that one first.
Ask it where I can understand it, because I didn't understand that question.
All right. So you never alleged that Stacy's LLC wasn't your partner because it was a separate LLC, did you?
No, I certainly did take that position after the partnership between the three of us was dissolved. Then she continued to share office space with me in an office sharing arrangement at such time as she was not a part of my firm or a partner in my firm.
Was that it? Thank you.
Sorry, Judge, I'm not.
And
I'm trying to
Mr.
get
Wood,
that
I'm
document.
going to hand you a document marked Plaintiff's Exhibit 404 for identification purposes, and ask you if that's a complaint that your firm filed. Yeah, can you mark that one? And this one's a long document. This is going to be a complaint that you filed when Stacy was working. I'll withdraw that exhibit, Your Honor, at 404. I meant to put in this one.
So this is 404?
Yeah, let's mark this as 404. We can disregard that.
Okay.
Does that appear to be a notice of change of address reflecting Stacy Godfrey Evans functioning as a separate law firm after she left your firm?
Yes, I had asked her to help me when we were part of the firm, Wood, Hernacki, and Evans, to assist me in representing Perry Pebbles Reed, very famous singer.
And this is after she left the law firm and she was running her own firm after she left Wood, Hernacki, and Evans. Is that correct?
No.
Well, let's look at
wait a second. No, I asked her to work with me on the case when she was still part of Wood, Hernacki, and Evans. Then she left in the sense that she began to be an office sharing partner with me. And that's what resulted in her filing a change of address with respect to S.G. Evans Law LLC.
Okay, thank you. Now I got it. But if you see the law firms at the bottom, you are listed with L. Lynn Wood PC, and she is listed as S.G. Evans Law LLC.
I don't know what you're looking at.
It's 404 right in front of you. The signature blocks.
Yeah, because that's exactly what happened. She changed the address to reflect that she was no longer a partner in Wood, Hernacki, and Evans, and she was now a partner in her own firm, S.G. Evans Law LLC. But when I first got her in the Pebbles case, she was still a partner at Wood, Hernacki and Evans. But then when that dissolved, she started her own firm and I associated her to continue in Pebble's case, just like I've associated a lot of people to help me on cases.
So in a very real sense, it's important to you to represent to the court honestly who's in your firm and who's not. And when she left and became a space sharer, you changed the signature block so that it says L. Lynn Wood PC and Stacy Godfrey Evans Law LLC.
Number one,
Is
it
that
is,
correct?
number one,
What do you think? I need a
I
yes or no.
don't, I can't agree with that question the way you posed it.
Okay. My
So
question
may
is,
I explain?
when.
May I explain, Your Honor?
I'm going to rephrase.
He's
the question.
rephrasing the question.
Okay.
You said
So-
no. So
When her LLC was a part of your firm, it was listed, she would sign as Wood, Hernacki and Evans. But after she left, she would sign a pleading as Stacy Godfrey Evans LLC.
That was the way she chose to do it. And I didn't disagree with it, just like I didn't disagree with. Stacy was trying to run for governor. So Stacy wanted to have her own identity once she was S.G. Evans Law. So she didn't want to, I believe, just be on the pleadings under L. Lynn Wood PC, like these people have been. So that's a unique situation. But the answer to your question is, I have always been candid and honest with the court.
Thank you.
The fact that I list somebody as being involved with me on a case
Objection,
does
Your Honor.
not make
This is really a
them,
narrative.
yeah, I
beyond
think
does not
you've
make
given
my
your answer,
question.
Mr. Wood. You've given your answer, and so he's out you on
Thank you.
cross.
All right, moving on to the rent and the lease. Jeremy Granello was the lawyer out in Texas who represented the building. Is that correct?
yes,
And you testified on direct that he felt the plaintiffs, Taylor, Nicole, and Jonathan, all owed a portion of the rent because they signed the lease as partners. And if they were not partners, that would be a breach of their warranties in the lease.
absolutely. That's what he told me.
Okay, thanks. So you made an agreement that you would, with the plaintiffs in Exhibit 102, that they had to pay $285,000 for their 75% of the lease.
Of the buyout at that time.
Right. And I believe you just testified on direct, the total buyout, 100% of it was $225,000. Isn't that correct?
But that's apples and oranges. We obtained from Jeremy a buyout as of the time period that this agreement was signed. Months later, after I tried to get out completely, they negotiated a buyout for $225,000. So it was apples and oranges.
Okay.
If they had not sought a buyout and they had waited, they might have gotten in on the 225 buyout. But their share that they agreed to pay was $285,000.
Right. So the apples is they owed you $285,000, and the oranges is the total debt was only $225,000.
That is absolute. Number one, that is grossly false. They didn't owe me anything. They owed the $285,000 to the lessor. I was simply going to make sure that it got paid by holding that amount out of the fees that they would receive under the agreement. They didn't owe me a dime on the lease. They owed the lessor 75% because they signed to pay it. And then the second part is just absolutely wrong.
You would agree with me that your February or your March 17th agreement nowhere references anything about a payment of that 285 to anybody but L. Lynn Wood PC.
I was going to get it. You have to get me a seatbelt, guys.
Should Mr. Wood, we might have to.
Take it, Tom.
Yeah.
Thanks.
Just make it comfortable. So it says in paragraph 2A, WGW shall pay to LLWPC the amount of $285,000 in full satisfaction of any obligations WGW may have or be alleged to have under the lease agreement with PR2 Regions Plaza LLC for Suite 2040 at Regions Plaza, the lease. It's
Okay.
very clear that they were paying what they owed to the Regions Plaza. And I just accepted the idea that in order to make sure Regions Plaza got paid, that I would deduct that amount from what they were going to receive under the cases that I agreed to share fees with. Plain language of the agreement under paragraph 2A
Yeah.
and B.
Okay, I must be really dumb.
I didn't
So
say
you
that.
help me with this. WDGW shall pay to LLWPC, L. Linwood PC, the amount of $285,000. And you contend that that doesn't mean they pay Linwood $285,000. They're actually paying it to the landlord, even though it says they're paying it directly to you.
You just totally omit the truth when it says they're paying it for their obligations under the lease. So what they owed, if they had walked away from that lease, the lessor could have sued them for $285,000.
Absolutely.
And excuse me.
Sorry.
And
Keep
then-
going, because this is good.
No, you said, you asked me to.
Just, you keep going, Mr. Wood.
Yeah.
Keep going.
So hold on, I'm not finished.
All right.
So what you're just totally omitting is the reality that they wanted out of the lease. They wanted their names off the lease. I could not get the building to agree to that.
Objection, Your Honor.
Well-
Just
Okay.
rephrasing. I mean, we need to, the
It's
question
what?
was the obligation to pay to L. Linwood PC.
No, the obligation was to pay to the landlord, but I was going to collect it in effect to make sure that out of their money they received in fees, the landlord got paid.
And,
Last thing I wanted to do
Sorry.
was to have them
and
agree to
there's
pay the
no
landlord and not pay, and I
indication
get stuck with
in
it.
We're not going to talk
in
over
the-
each other, Mr. Wood.
there's no indication in Exhibit 102 that the landlord signed this agreement, is there? There's no signature block for the landlord. They didn't do any of this. The money, well, let's just stop there.
Well,
They
read
never
paragraph
signed this
2.
agreement.
Read paragraph B.
How about you answer this question
About-
Well,
for
his
us?
question was whether the landlord signed the lease.
No, the landlord wouldn't have been required to.
Okay.
There was no reason for the landlord to sign the lease.
And it's
I mean,
your
to sign
opinion
this
that when
agreement. The
they
agreement-
say, will pay to your firm, they actually mean will pay to the landlord.
They would pay to my firm 280, out of the money they received from fees, the first $285,000, I would be able and have the right to take that and pay the landlord for their obligation.
All right, let's talk
So it was for their obligation. It wasn't, they didn't give me $285,000.
about this case about that you paid Jonathan Grunberg $200,000 on the DeVita case. Remember that testimony?
I do. I believe that was the amount of a bonus I gave him. He didn't really work on the case.
And that was about 1% of the $20 million fee you collected in DeVita. Isn't that correct?
I don't know the math, but I know this. It was a freebie. He wasn't entitled to anything. In fact, I'd give him 1% or 10%. was a gift. He should have been grateful. What did he say? He didn't get too much? He didn't work on the case.
All right. So, and then in the Ramsey case, you talked about the nice big bonus you gave to the three of them. But the other side of that is you collected almost $3 million on that fee. Is that correct?
Number one, it's incorrect. I didn't give them a bonus. I paid them pursuant to an agreement that if they helped me, I would give them X% of the fee. They helped me. I paid them X% of the fee. It settled quickly. They made a killing on that deal. I didn't care. In other words,
let's try my
I
question.
made my deal. That was.
Let's try my question.
All right, try
my
yours.
question is, you received about $2.75 to $3 million on that fee. Is that correct?
I don't have the figures in front of me, but what does it matter?
No,
It's
we're not
about an
going
answer.
to go back and forth like that,
It's
Mr. Wood.
it's my fee.
You either know the answer to the question or you don't.
I received in that case the exact amount that the client agreed to pay me.
And that was
Whatever-
about $3 million to you and about 2.2 to the three of them. Is that correct?
No, the way you phrase it, it's incorrect. The client agreed to pay me whatever the figures added up to, 3 plus 2.2. The client agreed to pay me on a contingency fee basis where L. Lynn Wood would have received $5.2 million.
Okay.
But I agreed to give them.
Got it. That's all I wanted. I was just trying to get numbers. Let me direct your attention. We've heard a lot about the unhappy camper memo in 2018. And without going into all the nuance of it, it's fair to say you were unhappy because you were paying salaries, but it had been a while since the case closed. Is that right?
That's grossly inaccurate. That's not why I was unhappy. It was a lot of things. Read the memo.
And would it be fair to say that you were displeased about cash flow issues, but you had made between 25 and $30 million in the 3 years before?
What does that have to do with anything?
Okay.
Am I supposed to give them everything I made? They somehow entitled to what I worked for all my life?
I
That's
believe
ridiculous. That's ridiculous.
Okay. I believe we heard testimony about Nick coming down to meet with you at Tomotley, your plantation, your place in South Carolina.
It's not a plantation any longer. It was established as a plantation in 1689 under a king's grant.
Oh,
It's
okay.
Tomotley.
We've got that point, Mr.
Well, I think the use of the plantation is to try to prejudice people. It's called Tomotley. I
I
dropped the
understand.
plantation.
Major point on that. Let's get to the real point of his question
So he
here.
did not come by Tomotley.
Well, I don't know what he was about to ask about that, but he just, let's get to the purpose of the visit.
And you said, hey, there was no private jet sent for him. There was he came and he spent a couple hours.
Yeah, I got a picture of him and his family standing out in front of the house.
Okay.
He stayed there
And do
2
you
hours.
remember
That was
listening to
Friday.
his testimony by videotape that he was there less than 18 hours? It was an all-day visit.
What I heard him say very clearly was that it was an all-day trip or visit to wherever they were going, and I guess in South Carolina. And he said, of which I spent a couple of hours with Mr. Wood. He didn't say he spent 18, 19 hours with me. That misrepresents his testimony.
All right. We'll remember it as best we can. Now, I believe it was Todd that you sent the private jet for. Is that correct?
I had an hour lease, an hour card. It's called a jet card. And I did, in fact, fly Todd and 2 of his lawyers who were working on the Sandman cases. I did fly them down to a meeting at Reynolds Lake Oconee. And I flew them back. I'm a generous man.
Yeah. So traveling by private jet was a common thing for you at this time. Is that correct?
Irrelevant, Judge.
All right.
All right,
Mr.
I'll
Wood.
move on.
Okay.
Regarding Nick, nothing would have prevented you from speaking with your client, Nick Sandman, about fee allocation to these three people.
Objection. He was specifically instructed not to speak to Nicholas Salmon.
Okay, so that is, you have an issue with the characterization of the evidence, which the jury will recall. And so you can proceed if you can answer the question.
So my question to you is,
You want me to answer?
nothing would have prevented you in February or March from speaking directly with Nick and insisting that he acknowledge your right to share your fees with these three individuals.
May I answer the question? Number one, nothing would have prevented me from doing it except Todd McMurtry was the relationship partner. They were his client, and he wanted all communications all communications with Nick. He wanted them directed through his office.
Okay.
And secondly, I didn't learn about the need for client consent from Nicholas Salmon until late April or early May. Now, I didn't know about it in February or March.
All right. So since Todd wanted to be there for all the communication, I believe you testified, or Nick testified, that Todd wasn't there when you had the all-day meeting when Nicholas and his parents came down to visit you at Tomotley.
I did not have an all-day meeting. I met with the boy and his family for no more than 2 hours. Why don't you understand the truth? That's what I said repeatedly, and that's what the boy said.
Well,
but let me finish. It wasn't a business meeting. I get a phone call that morning from Ted and Julie Salmon saying, we're close to.
No, I think he's answering your question.
All right.
We're close to Tomotley, where you live. Could we come by and visit? I said, sure. They came by, they visited for 2 hours. There was no business discussed. Are you trying to suggest that I should have called Todd and said, hey, Todd, you need to come down here and babysit while they meet with me for 2 hours in a social visit? That's just ridiculous. Come on.
Been a great time.
Come on, man.
For you
Come
to
on, man.
discuss with Nick and his parents the good work that Taylor, Jonathan, and Nicole had done for them on that case, and discuss sharing fees right there, face to face, while with your clients.
Sir?
Yes or no?
No, I was not there.
Bad idea to do that.
No, I didn't say that. Todd McMurtry was the relational partner. It was his client, and I was not going to speak to Nicholas on business except through or involving Todd. I don't know why you don't understand that.
Okay, Mr. Wood, you've answered the question.
Okay, so it wasn't that you were trying to take your fingerprints off this issue. It's that only Todd could have that magic conversation. Is that right?
I disagree with your use of my fingerprints off of the issue. That's not even how do you respond to something like that? And Todd, the relationship was simple. Todd brought the client. He was engaged by the client. He retained me. He got the client to retain me to work with him on the case. He was the partner in his firm that had brought the case in, and he made it very clear that any communications that were going to be had with Nicholas, he wanted it to be done through him. He was in Kentucky. I was in Atlanta.
Okay, we're going beyond.
Let's look at 85, Exhibit 85. But let me ask you a question about it before we get there. I believe you testified that you were shocked that Nicholas wasn't going to sign and show his consent to fee sharing. Do you remember that testimony where you sat there and said, frankly, I was shocked. I didn't understand why a young man like that would care how his trial lawyer cut it up. Remember that testimony?
Yeah, I used the words shocked. I mean, it was in effect surprised.
Okay, well, let's look at
I was surprised.
Let's look at Exhibit 85, page 2. your Tuesday, May 26, 2020 email,
Wait a second, where?
Plaintiff's-
Exhibit 85,
Yeah, okay.
page 2, Bates number 3040.
Okay,
And your May 26th, 8:35 PM email from you to Joey Burby, your lawyer. And you say candidly, if we explain the fee dispute and resolution to Nicholas, I do not believe he will agree to the payments to WGW in excess of quantum merit. He is a very principled young man. So the truth is that you knew all along he wasn't going to. You weren't shocked at all. You told your own lawyers 2 months before, I know he's not going to agree, right?
I object to the form of that question. There's 4 questions in there. I'm happy to answer them, but I think I'm entitled to get them one at a
There's a lot
time.
going on there. You can answer what you can. If you want to break it up.
There's a lot going on there.
Break that up for
I'm
me.
gonna have to ask
I'll
the-
break it up
Okay.
for you.
All right.
Were you
thank
lying a minute ago when you said to this jury, I was really surprised when he signed?
No,
Was that untrue or was that a truthful
didn't sign.
statement?
Just a question. All
Well,
right.
you asked me when he signed or didn't sign. He didn't sign. And if you're asking me, was I surprised? Yes. I know you may not believe it, but there are people in this world that tell the truth. They're children of God, not children of the devil that lie.
Okay. And do these children of God say 2 months before, I do not think the payment, he will agree to the payments to WGW in excess of quantum merit?
That's because of what Todd had said at a time when Julie and Ted were the clients. He said that, and I had a concern that he might not, but I did not believe when it finally came push to shove that it made any sense for him not to agree to it when I, remember this, when I had recommended that he do so. So he may have had a position before that as expressed here, but I was surprised that when I recommended and asked that he sign it, that he didn't do so. That's a totally different situation than what we were talking about in May of 2020. So I have not lied. I do not lie. I can make a mistake,
All
but
right.
I'm not a liar.
You've answered the question, Mr.
Now, I believe
Bill.
you testified that you believe that the plaintiffs interfered with your relationship with your children. Is that correct?
I made it clear that I thought particularly Taylor and Jonathan were interfering with my relationship with my children. I did then. I believe it now. I've seen evidence of it. And I don't like that. You don't mess with somebody's children.
But would it be fair to say that the actions that you took are what caused your children, as you said in opening, to be afraid to speak to you any longer?
Number one, that is not true. And I've got a letter right here that will show that your statement is a lie. My son does talk to me.
Okay, great. Let's look at Exhibit 265.
When what relevancy does this have?
All right.
That's
Mr.
all right.
Bill.
Let him go on and do it. Let him attack my
So
children.
Mr. Exum should be the one raising objections for you.
All right.
You can proceed, Mr. Beal.
Excuse me if I might have just a second. With respect to the former witness, if she's still here.
We're not going to do that right now. We'll
I'm
do that
just
when the
trying to
jury's
get her,
gone.
well, she's from out of town. I was trying to let her know I've got a couple of documents
But
for
we're
her.
not going to do that mid-testimony. Mr. Bill, let's
Look at Exhibit 265.
Do you have a copy of it?
It's in Volume 2, and it's about to go up on the screen right behind you.
Well, I can't turn around. I got it right here. Let me dig around. 265.
All right. And is this your April 6th email to your son, Matt Wood? Thank you.
That's right. Just. Yes.
And Is this where you say, I know so much more than you realize, you're making a horrible mistake that will impact you, your family, and your children for the rest of your life? Get out of this game you are playing before it's too late for you, your law firm too. You really do not know anything about me. Know this, you do not want to be identified as my enemy, but I know what you are doing and why. Get right with the Lord. Get on the right side before it's too late. Did I read that correctly?
Yes,
And then he responded by, I truly have no idea, Dad,
Is-
I truly have no idea what you're talking about. I'm not playing a game.
Is there a question?
Yeah, I'm asking you, did I read that correctly?
You read it, but you,
Okay,
my
let's
son
look
was
over
involved,
it.
my son was involved.
You brought this up, you can answer it.
Thank you. I believe my son was involved in rigging the jury in the Elon Musk case. I also have learned that my son is a Freemason. And I have had problems as a result of that relationship, which they have fostered back in February of 2020, when they were trying to get me to do some sort of or have Dr. Phil behind my back do a mental health exam on me. But I know my son. Fathers and sons, we have our differences. I think I know why he and I are separate at the time. But what you're suggesting is that there is no love between me and my son, him to me or me to him, and you, sir, are dead wrong. I've got a letter to prove it.
Okay. Let's look at Exhibit 266. Well, before that, let's look at 276. It might be easier. You brought up Dr. Phil.
276?
Yes. Is this the email that you sent to Dr. Phil on February 15th?
Yes.
All right. And right below the, were you able to find it, Michael?
Minute, we're
Sorry.
having some database. Your Honor, was any of this covered on direct? I don't remember asking many of these questions.
No, but cross-examination is a little more wide range. So
Okay.
to the extent that's an objection, it's overruled.
All right. Let's take a look at the middle paragraph that says, I am copying. Well, the second paragraph, you can come here tomorrow and support me and win a victory for God and for a family. You can win a victory for a father who simply wants to be honored as commanded by God. If you come here tomorrow for any other purpose, I am afraid it will be the biggest mistake of your life. It will be the biggest mistake of your life on earth and your life eternally in heaven.
Amen.
The fourth paragraph says, I am copying a lawyer on this email and I'm also copying my son, Matt. This email is not privileged, so I have chosen my words carefully. The next email, if I send it because you do not respond to this one correctly, will be privileged, but it will be detailed and it will be the truth. I think you understand. You are too damn smart not to understand. But maybe there is someone smarter than you, smarter than me, and maybe there is someone smarter than everyone in the world that he created.
What's the question?
Did you write that to Dr. Phil?
You bet I did.
And the next paragraph says, I would never violate attorney-client privilege unless I had to as my best effort to save my children from Hill. And I think you mean hell. Life on earth is one grain of sand. Eternity is every grain of sand from every ocean under the water and above the water in the entire world.
Yes, and what I meant by that is that when I realized, and again, I didn't have any documents that proved it, but I realized that's the Holy Spirit. I realized what they were doing and that Dr. Phil was going to be part of it. Dr. Phil is a Freemason and a worshiper of Baphomet. I realized what he was going to be doing, and he was going to be interfering with my relationship with my son. And what I made clear to him was that if he did that, it would be a bad mistake, because I love my son more than I love being a lawyer. And I have documents in my safe that if I disclose them, Dr. Phil's reputation is gone. And he knew it, and he didn't come. He wrote back a letter saying, Matt, your father's a genius. I hope y'all work this out. Dr. Phil knows I had him, and he was going to come, and I didn't have any basis to know it except the Holy Spirit, and the Holy Spirit is always right.
And did the Holy Spirit kind of lead you to the conclusion that what you needed to do was extort Dr. Phil and say, if you don't do as I instruct, I'm going to breach the attorney-client relationship and hurt you?
That's not what I did not extort Dr. Phil. I told him the truth. The Holy Spirit is the Spirit of truth. And we are to be guided by the Holy Spirit to do the will of the Father. And the Holy Spirit will give you what you need to do his will. God controls everything. He controls you.
Right.
He controls the judge. He controls everybody on this jury. He is sovereign. And if you pray to the Father in the name of the Son and you seek the guidance of the Holy Spirit, he will give you guidance. It's in the Bible.
Right.
Do you know that?
But the
Did you know that?
State Bar of Georgia probably would have disbarred you if you had done what you had threatened to do.
I wouldn't
here.
have cared if Dr. Phil had come through and tried to interfere with my child. The State Bar of Georgia is a Freemasonry organization.
Okay.
And they did not disbar me. They wanted to, and they started the whole process based on the lawsuit that these people filed in September or August 31 of 2020.
All right.
I know what's going on.
So let's look down right underneath your signature. You sign it, Lynn, and put a heart next to it.
Yeah.
Anyway.
I do that, don't I?
The second line
All the time.
says PPS. Can you blow that one up for us? Sorry. There you go. PPS Taylor Wilson has my former law partner who I terminated the relationship with today. So even when you were furious at him, you still, furious with everybody, you still referred to the plaintiffs as your law partners. Is that right?
Show me what you were looking at.
The PPS right underneath your signature and the heart emoji.
Taylor Wilson was, I think it meant to say, my former partner who I terminated the relationship with today. And I think that was referring to February the 14th. He is on Matt's side because he has almost $400,000 at stake. That would have been his claim for part of the fee in Sandman.
And
money he shall never receive. He is in it for the money. That was my position in February. I changed my mind and made an agreement in March to be done with this guy, to be done with him and try to help him.
Okay. And while helping him, at different times, you've sort of mixed in some extortion of the plaintiffs during this time.
What do you mean extortion?
Well, you filed a bar complaint against them that was dismissed by the State Bar of Georgia. Is that right?
Well, the State Bar of Georgia, I've told you, pull the record.
Freemasonry. Got it. Okay.
Well, let me answer.
May I answer the question? Well, they are Freemasonry.
Okay.
I mean, that's just the truth, and you know it. So what the State Bar of Georgia did, and again, I didn't pull it, but I recall that it was a judge that did it. Used to be with King and Spalding, and he said that it was premature.
Objection, Your Honor. It's hearsay.
All right, well then you can say what the order said, and I can't.
Well,
I remember.
we're talking. The question was about him filing a complaint against the plaintiffs. A bar complaint.
I filed a complaint not to extort them. I filed a complaint because I believe that what they were doing was unethical, and I had a duty to file that complaint. And it's a public website, and they urge members of the public to file complaints if they think there may be unethical conduct by a lawyer. So they urged me in effect to do it, and I did it. I wasn't extorting anybody.
And you have made various criminal threats against them to have them arrested in a variety of settings, including an FBI investigation. Is that right?
That is not right. You just misrepresented the truth. You asked me the truth, and I'll answer, but I can't answer a lie and a distortion.
All right. And when you wrote to Todd and said, call me right now, or you will lose your biggest supporter, and I will pull out of all these cases and you'll have to do them yourself.
I don't have any
That was a type of extortion, wasn't it?
No, that was me saying, I don't know, Andrew, what irritated me that Todd had not called me back. I don't even know how long it had been that I was trying to reach him. I was making a point. Show me some respect here. I've been a big donor. I've been a big donor to your campaign. I've been a big donor to your PAC, both at your request. I'm handling these lawsuits for you where you're going to make a lot of money. Have the respect to call me back. That's not extortion, if you understand it, which you may not.
And you even tried to extort me when we first got into this case, didn't you?
I don't have any idea what you're talking about.
Let's look over at Exhibit 59 and see if that'll refresh your recollection.
Sounds like I'm in extortion business. Sure.
All right, no need to comment. No need to comment on either
Where's
side.
59?
Volume 1?
59.
What does this have to do with the case?
All right, Mr. Wood, I can be the judge of that. And if an objection made, then I'll handle it. But for now,
Maybe you can object.
sorry.
I mean, I want to be here all night.
Okay. I think 59 has already been admitted into evidence, is it not?
No.
It is not.
Thank you.
And Mr. Beal, at this, we need to be finding a stopping point as well.
How about right after this one?
All right.
Am I looking at 59?
Yes.
All right.
And is this the initial, one of your early emails to me of March 4th, 2020, where you wrote to me and you copied a bunch of people?
I did. Let me read it. Drew, this shall be the final email I send to you until you receive the analysis of the lease from counsel for the landlord. This is March the 4th, before I hired Burby and Marquardt.
Okay, you can
With
read
all
the
due
rest of it
respect,
yourself.
with all due
I
respect,
don't know what
I-
Mr. Wood, he hasn't tendered it yet. So let's first start with
it's not
that.
in evidence. I'm sorry. I thought it
You
was
haven't
in
done that
evidence.
yet, but so you tendered in 59. Mr. Beal?
Your Honor, at this time, we would offer Exhibit 59 as well as Exhibit 276 and 265 into evidence.
Let's just do these one at a time.
All right,
Starting with the
59.
one that's in front of him. Is there an objection to 59?
Yeah.
I'm looking at 59 now.
John, there's none. I can help. No objection.
All right, it's in. You said after this, subject, we'll pause for the day.
And I'll just introduce the other, I'll just offer the other two right after this. Second paragraph. Your client should also be very concerned about the evidence of their fraud and attempts to extort money from me in violation of their fiduciary duties and other laws. See attachment. I chose to believe that you have not been actively or knowingly involved in their illegal efforts, as I know you have a wife and a family.
Is there a question?
And would never jeopardize your valuable privilege to practice law in this state. So the first time you communicated with me,
Okay, go ahead. I was going to say, keep reading.
you threatened me that I was going to lose my law license and it would interfere with my family if I continued to represent them.
That's not what I said
How
here.
dare you?
Okay, Mr. Beal.
Your Honor, maybe we take a break, because again,
Done for today. Members
this
of the jury,
man is
Mr. Wood, that doesn't invite you to get on a box either.
No, no.
Okay. Members
How
of the jury,
dare me?
thank you
How
for your
dare
attention.
you?
Mr. Wood,
I'm sorry.
thank you for your attention. Please don't search the case or do any, learn anything outside this courtroom. We are on track, I still believe, for closing arguments to begin tomorrow afternoon. There will be a portion where there's probably an extended break because we have to discuss the law that applies to this case outside of your presence. So you may want to bring a book. I'm hoping I can limit that to an hour. All right. Thank you all.
Your Honor, I've got two other topics that we do it after the jury goes. Housekeeping, the two that I talked about.
We'll see.
Okay. First of all, I apologize.
Kind of the apologies aren't really helping me out at this point.
I would move to admit exhibit 265 and 276.
Let me, I think we can take a look at it. Give me those numbers again.
265, 276.
276. And what are these?
That is the email to his son and email to Dr. Phil.
All right. So those were already referenced in detail before. I mean, we'll formally tender and admit them again in front of the jury and on the record, but just while it's on the forefront of our minds, is there any objection to 265 and 276? All right. So
You've already ruled them relevant.
yeah, well, I mean, there are statements by you during the time period at issue, so I don't really see the relevance concern. All right, there's a lot of housekeeping we need to take up. I don't think we can run screaming for the door just yet. First thing I want to bring up is, as I mentioned, if we are on track, and I believe we still are to close tomorrow, the parties have a lot of work to do in terms of figuring out what exhibits go back and which ones don't. And so what I'm going to ask the parties to work on before that moment arrives is every single exhibit that you have admitted, we're going to need a physical copy. And then of those physical copies, each party needs to decide which of theirs they think goes back to the jury. And then once we've got that stack from the plaintiff, we got that stack from the defense, we're going to need to see what points of contention if that there are. If someone thinks something goes back and someone doesn't. But what I don't want is, well, we don't have that stack ready. We haven't even started that process. So we need to be starting that process because there are a number of exhibits here, many of which may not even have been printed out, right? So I don't just want to be thinking our work's done just because we get to closing arguments. Okay. What else? I've been emailed here the signed version of this Lindsay settlement agreement. And
In fact, there are two. She's committed perjury and Your Honor needs to get her in here and deal with it.
I don't, she said she had no memory of signing one.
Well, she dodged around it, but now we know she did sign it. And we know that I have the right now to cross-examine her about her relationship with Cherie Fazell, whose name appears on the document of receiving $28,500. She claims she'd never heard of her, but now I got her because she signed the agreement. She's not telling the truth. Period.
Your Honor.
She said that she didn't remember signing the agreement. You happen to have a copy of it.
It was unsigned. Then when she denied signing it,
She didn't deny signing it.
she said she had, what she did. I asked her specifically, are you denying under oath that you signed it? And she very smartly said, well, I don't remember signing it. That's okay. But what she did testify under oath is that she didn't have any idea who Cherie Fazell was. How could she sign this agreement giving Cherie Fazell $28,500 and not know who she is? I think the jury's entitled to potentially draw an inference that the good Sharon Lindsay is a liar. And I have the right to pull her back up now that I've given the court this documentation.
Mr. Beal?
I would ask for the right to do so.
Your Honor. First of all,
Well, let me just start here. I think if y'all had the signed agreement, you probably would have introduced that one. So let's put it this way. Is there any objection to the tendering of whatever this would be marked as on behalf of the defense?
No.
Okay, then were you going to give me an exhibit number?
I will in the morning. I mean, I just.
Well,
had it
just
on my-
what's the most recent number?
106.
Okay, so this is now admitted as D106.
So now that it's in evidence, Ms. Lindsay needs to come back and answer some questions about it.
To that end, I disagree with you, Mr. Wood. It's in evidence. The jury has heard her testimony about the issue. You've got the exhibit that you wanted to have in. You can argue whatever inferences come from that. But I don't see the.
She testified unequivocally that she didn't know who Cherie Fazell was.
Right.
And then now I can put in front of her a signed statement. And I think the jury's entitled to hear me ask her, why would you sign something gives Cherie Fazell $25,000 and you don't know who she is? And that goes to her credibility as a witness, and the jury's entitled to hear it because the jury is the sole arbiter of the credibility of a witness. And I'm entitled to ask it. They brought her here. She got caught.
Okay. Any final word, Mr. Beal, on this?
She didn't get caught. Her Honor's recollection of it is 100% correct. She said, I don't remember signing this. I may have. I won't remember it. I don't know who Cherie is. It's been on our document list for forever and listed in this. She was a make-call witness. And Lynn could have called her at any time. He did none of those things. She isn't under subpoena. So if she goes, she kind of goes outside the jurisdiction, the subpoena power of this court. So, I got it. I don't feel like I'm being hyper technical because none of this, it's a tempest in a teapot. There's nothing really left.
You just got a witness that said that she didn't have any idea who Cherie Fazell is. I've now found a document where she signed giving Cherie Fazell $25,000. And I'm entitled to cross-examine her now and confront her with that and see what she tells us. Maybe she'll tell us she made another mistake. But they brought her in as a witness, and I'm trying to now impeach her, and I'm entitled to do that, Judge.
Well, it would be, to the one end, I think there's the logistical issue here, which is she's in the PTO. Apparently this exhibit has been part of the list from the beginning. We're here for trial. We can't put things on pause just because you don't have everything ready. I think they've extended a courtesy by actually consenting to allowing in the signed version, because otherwise I was going to say you had your chance. We're at a trial. We don't just get to pause things indefinitely. So on that alone, but setting all that aside, I'm just not seeing the probative value that's added by recalling her. I'm not seeing how this is a material issue in this case. And so in addition to the procedural issues, I would even say, I think here on 403 grounds at this point, I don't see a need to recall her for all of those reasons. So your objection's preserved for the record.
I've made my record. I appreciate
you
your
absolutely
honest
have.
ruling.
All right.
I'll just deal with her in closing argument.
It's a fair game for closing argument.
You
You've
bet.
got the exhibit.
Thank you. Am I done with him or?
No, I'm afraid not. We've still got some more there.
How much time they've got?
They've gone 50 minutes thereabouts. He had said he had estimated 2 hours, whatever those estimates are worth these days for all of us. But that's where we're at. And there's still some housekeeping though here. I still want to use this time productively. I want to inquire if the parties had a chance, I think because this one's easier to dive into, did the parties have a chance to look at the phase 1 verdict form that I provided? Not.
Judge, we're swamped. We're just two lawyers. We're doing the best we can.
All right, just one of me. All right.
Yeah, but one of you got a brilliant person, Miss Sue.
Thanks.
Have you all had a chance to look at the verdict form?
I just insulted John accidentally.
We'll be
I
ready.
apologize, John.
Both Emory alum here, by the way, I think. But no, nothing initially for me that we could hash out here.
I mean,
just don't have it.
Opportunity to look at it.
They'll have an opportunity to respond. I just wanted to know if you already had something maybe out of the gate you could go ahead and put on,
Okay, we do on the verdict form, you go through these things and then you say, like at number 4 or 3 or something, you say, if you find for the defendant, comma, do you find that they were part of the law firm? And I was kind of curious. do you find that the plaintiffs and defendants were previously associated in the law firm, in the same firm? So I just had a question. What was your honors thinking about, sorry, how many times you gonna have to tell me that? Oh, maybe you should make that argument.
Judge, with all due respect, this is going to be duplicative because we haven't looked at it yet. So why don't we just?
It won't be duplicative because you're going to get your chance to respond and I'll be able to hear from them and they won't have to repeat it. So I can at least
They
hear
won't
their
repeat
thoughts.
tomorrow what they're saying today.
That's the idea.
Okay.
Okay, Your Honor, on 1B, the question is proposed. If you have found in favor of the defendants, do you find that the plaintiffs and defendants were previously in the same firm? The Georgia bar rule on this says previously associated in the same firm. So we would ask that the word associated be put in there as well.
Okay, noted. And
then
but you asked why it's there.
Yeah,
It's
yeah,
to get
why
a
does it
special.
say defendants first and then that. And did you consider moving that to the head of the class as one of the first? Why is it where it's at and why does it say if you find for the defendants?
If you found, right? So, I mean, again, open to organization, but I think that it would be valuable to have a factual finding as to some of these core issues in the case. And however it's phrased, if they're finding in favor of the defendants on that claim, it's because presumptively, either they've found the firm issue, the association issue, or they may have gone beyond that and gone to the other three prongs. And so it's trying to game out exactly how far down the list of findings they got to make their ultimate determination. So that's the intent. If you're saying there's a clearer way to organize that, I'm certainly open.
We'll give it to you tomorrow morning, but I was thinking when I first looked at it of flip-flopping it and starting with, do you find that they were previously associated? If yes, then go to this number. If no, then go to this about proportionality and all that other stuff.
Could be a better flow.
Well,
or and furthermore, that we run into the problem that whole issue is not supposed to be addressed to the court, and the bench brief we gave you really makes it
the cases from the 1800s you gave me, right?
Yes,
Yeah.
yes. Old law is good law.
Yeah.
unless it's against you, then it's bad law.
Look,
Judge,
you go ahead.
well, I don't have any response to what he's saying. We're going to renew our motion for directed verdict. I do not believe that.
You'll have the time to do that. You'll absolutely have the
I don't
time to
believe
do
the
that.
court can enter a breach of contract finding against L. Lynn Wood. That's just undisputed what the contract says, but I haven't had a chance to look at the charges. We'll do that. John will work on the documents. I still got to, stay somewhat rested to go through cross-examination. And then I got to do a closing argument. And so the court knows that there's only 24 hours in a day and I'm tired and I'm sure we all are. But I'm the only one doing the driving back and forth to get here. And I didn't sue anybody. So bear with me. I know, Your Honor, that I'm passionate. Mr. Grunberg admitted it. I know that I have some very strong feelings on a number of issues that only come into play in this court when they are relevant, which they were today. But I don't mean to in any way disrespect you. I know the Bible says you are anointed by God to be a judge. And the Bible says that because you're anointed to be a judge, I am to respect you. And I have tried every time, sometimes I have to bite my tongue. So I've tried in this courtroom to show you the respect that your black robe and your position is entitled to. I'm not perfect, Judge, but if you would you can't get in my shoes, but I've been going through litigation for 5 years with these people.
And Mr. Wood, look, my purpose here is I'm just trying to land the plane, okay?
Well,
so we don't have to go into, I mean, maybe one other day you can share with this, but just time is a finite resource. And so I'm trying to stay focused on the task right before me.
I have eternal life. Time has no meaning to me.
Well, for these jurors, we promised them Wednesday.
I do want to say one thing. I noticed that when I was questioning Mr. Wood, he wasn't even really seeing me when I was sort of, so I don't know that he was ignoring. I know you've already ruled on that, but I just thought of it, of a delayed processor sometimes, so I'm sorry if I'm late on that, but.
No, I understand your point. Let's not, we're getting a feel of what I was trying to just, I hear everything you're saying. We'll take it up as we need to. We're not, well, you can leave Mr. Exum behind if you want, but here's a point here that I want to flush out before we call it a day, because I think it's, all right. And to your point on the difference between the PC and your individual liability, I'll just point out, when you look at it on the verdict form, it delineates that. They have to make a finding for one and for the other, just so you know.
And down on 3B, it says, as to whether the defendant's conduct warrants consideration of punitive damages. That doesn't really follow the law. I think it should say whether the plaintiffs are entitled to punitive damages. I mean, it's just a wordsmithing, but you start saying consideration and whether they're entitled to, and then say
Okay.
yes or no. And we can change this from find in favor of the plaintiffs to we, the jury, find the plaintiffs are entitled to punitives. We, the jury, find the plaintiffs are not entitled to punitives. And they can check one of those. I think it's clearer and a little bit more in line with Georgia law.
We'll address those tomorrow.
Understood. Again, I'm just trying to get everything out in the open, so I actually have some time to think about it. And it's not having to decide this in real time. Was I getting the impression that maybe you don't have as much of a position on the specific factual findings of 1B? Is that still something you want to maybe clarify tomorrow?
We'll talk about it, and we thought it was interesting. We just had some questions, and we were like just trying to all get on the same page.
I think the purpose that serves is we would actually know precisely why the jury found what they did. So to the extent you think you can streamline it or make it more effective in making that point,
Okay.
Open to that.
You want us to come early tomorrow and sort of knock this out?
I don't think we need to do that, but we'll get started at 9 again. We continue with your cross. Are you still on, thinking you're on for 2 hours?
No.
What do you think you're on?
Depends on how much they cut my stuff. My goal was to get it all done in one.
Okay.
I mean, one
Well,
more hour.
one more, so about 2 total, right?
2 total.
Okay. That's all right. Fair enough. And all right, last thing I promised. You've said you got the bench brief, but other than that, was there a particular charge in here you're wanting me to take a closer look at tonight?
I haven't had a chance to look at it.
I understand. I'm just
We're in
asking.
that- We're in the same category with Mr. Wood on that.
I get it.
Sorry, Your Honor.
We finally found some commonality. Drew,
Was there something?
I'll get electronic
You
copy
can
of that.
address them right now. If you can.
Okay, Drew, may I have an electronic copy of the bench brief? I think I had the paper one, but.
All right, I'll email it to you.
Thank you.
As soon as I find it.
all right. Anything else, Judge?
I'll open the floor. Nothing else from the defendants? Anything else from the plaintiffs for now?
No, Judge.
There were a couple jury charges that I think were fair to point Your Honor to.
In regards to defendant's request to charge number 17, I know you mentioned the bench brief, different flag in that. Based on our bench brief, you can feel that the question of law should not charge to the jury. And then there's also.
Let me flag some for you just to put it in advance. I'll throw the ball back at you since y'all are still looking at it. I'm wondering why we need to be, I'm wondering if calculation of interest is really a relevant charge here, if that's just something as a matter of law. It's just a pattern charge. I don't even know which side requested it.
And it is relevant because it comes to a couple $100,000 in this case.
I know, but are you going to be telling them what the rate is and giving them a calculator?
No, we do that. We are requesting that they say interest. I think arguably you can do the whole thing. We can just petition Your Honor to apply interest.
So we contend that they never liquidated their damages to get interest. The only interest they'd be entitled to would be on the judgment. But I haven't looked at that issue.
Okay, that's why I'm just flagging it for you now. It's an odd charge to me.
A lot of odd things.
Yeah. All right, fine. I think we've.
Your Honor, one other just for tonight for flagging, on page 36 of 63, the impossibility charge that's not requested. Usually that's not.
Okay,
We'll have to look at those.
we'll take a look. All right, we'll see you on the morning, 9 a.m.
Judge, can I do the ventriloquist?